Hello, everyone, and welcome to Immigration and Jobs Talk Show. I'm your host, Sam, and before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. All right, after this very important disclaimer, once again, guys, welcome back to Immigration and Jobs Talk Show. And today we are going to talk about post election impact. What does it mean for non immigrant visa processing in 2025? So, guys, after the election, there are so many questions on everyone's mind, especially for non immigrants. What will the visa process look like? Will it speed up or face delays? And will there be some kind of new restrictions on the H1B visas? And will it become harder for students to apply for F1 visa? And especially for the mass deportation that Trump has told, and it's been a hot topic. But guys, the best thing is that we have an expert for this. So please help me in joining and welcoming an immigration attorney, Kimberley Best Robidoux. So, Kimberly, welcome, and it's a pleasure having you on our show. Please go ahead and tell our viewers about yourself.
Yeah, thank you very much. I'm really excited to be here and happy to see everybody. As you can tell, the sun is rising here in San Diego. So I'm an immigration attorney with WR Immigration. I'm based in San Diego, California. And I have been working in the immigration arena since the early 90s, way longer than I really probably want to care to admit. But it's interesting to see changes over time, as well as how some things in immigration have always stayed the same. So I'm excited to talk with you about this topic, especially given that our election, just ended 2 weeks ago. So it's really fresh in everybody's minds.
Right, right, of course. So thank you so much, Kimberly, for joining us, and it's a pleasure having you. And it was lovely also to hear about you, as obviously you are an expert in this. So, Kimberly, were you expecting Trump to be back in the White House?
We were cautiously optimistic that we would not have a Trump 2.0 administration. From an immigration perspective, what we had seen with Trump 1.0 and then Trump 1.0 with COVID-19 pandemic on top of it was really, really difficult, not only for foreign nationals in the United States, but, for the immigration community as well. So it was a difficult time. And one of the things that we have seen with what was happening on the campaign and different things that were coming out of, the campaign and President-elect Trump himself were things that weren't necessarily going to be beneficial from an immigration perspective, which also would and will have a significant impact on the U.S. economy. And, if I can be so bold as to say the global economy as well.
All right. I think that's a pretty good background that you have shared with us. So, Kimberly, also, I would like to know that not only for like non-immigrant thing, but I would also like to know that how the future of US as a whole will be. Will it be a new era under Trump's administration, or will people will be, having a nightmare kind of thing?
Well, based on, everything that we've read with respect to Project 2025, as well as what we've heard from the campaign and what we saw previously, right, with his first administration, um, it's going to be really hard times. There's some discussion that maybe there might be some benefits to employment-based immigration, but overall, there's going to be a lot of hard decisions that will be made by companies, by individuals, And we're expecting that based on actions that will be taken by the administration. As I think everybody has heard, the call for mass deportation beginning on day one, which will be day one is January 20th. That's Inauguration Day. So it's about 2 months away. And we're helping our clients, both corporate clients and individuals, be prepared for kind of the worst case scenario of what could happen. As you say, Sam, a potential nightmare. I'm hoping that it isn't as bad as that, but we have yet to see. So what we have been doing is working from the perspective of let's prepare for the worst case scenario and hope that it doesn't get to be that bad.
Absolutely. And Kimberly, also talked about mass deportation. So I don't know whether it's going to happen or not, but if we look practically, then it is also very difficult, to have millions of people deporting just on a day one. So it's going to be very difficult, not only like for working in a political way, but also it will deteriorate the economy of US too, because there are so many, companies of US, who are completely relying on H1B workers. So, how do you think that will this mass deportation will happen, or how the immigrants should be cautious about it?
Yeah, so in terms of mass deportation, you're right, Sam. It's not only very difficult from an operational perspective, but it's also incredibly expensive to deport a lot of people in a really fast period of time. So what we were or what we are expecting that could happen is targeted workforce actions, meaning that Immigration and Customs Enforcement would more likely than not conduct worksite enforcements at various companies within various industries that might tend to have a higher population of undocumented, or as the administration likes to say, and some people call it illegal immigrants. There also can be, and more likely will be, a focus on individuals who have criminal records and who are already in the immigration system, so to speak, with respect to having been to immigration court and have been in removal proceedings, have stays of action. So individuals who already are in the quote unquote system would be, a primary target, right? Because they're known pretty much where they're located. So Immigration and Customs Enforcement would more likely than not focus on those individuals first. But what can happen with the raids? I mean, their worksite enforcement activities. There could be raids. It just depends on how the administration is going to pursue their process for deportation. And as you mentioned, Sam, it isn't just an impact on the individuals, right? It's an impact on the organization, because if a company loses employees, then that disrupts the business operations. It also has that ripple effect within the community, right? So if there aren't employees that are going to a company to work, then businesses within that area can be impacted as well, right? Food trucks, restaurants won't be getting their customers, grocery stores,
Mm-hmm.
clothing, retail facilities are all going to be impacted as well. And then if you have individuals also working at organizations who have some type of work authorized status, such as, where they're sponsored by the employer in TN or H1B or maybe even O1, their positions could potentially be impacted as well if the organization has to have cutbacks because they're unable to fulfill orders or complete projects timely because of loss of certain personnel that may not have had appropriate work authorization in the U.S. So those are the concerns, that it's not just the individuals who will be deported, but how that will have a ripple effect throughout the economy and then in communities as well. And if I can just do a public service announcement out there for individuals, specifically in California, where I practice law. Individuals who are not U.S. citizens or permanent residents in the United States might want to make sure that if they have children, that they have some type of caregiver agreement in place, which is they create a legal document in California, and what that does is if they are taken by ICE, this caregiver agreement will provide instructions and guidance to say, so-and-so and uncle, friend, has the permission to be guardian and pick up my child from school, can help out with finances with the children, et cetera. So that's like even outside of the scope of what I do, but it's something that I think is really important for people to consider. As heartbreaking as that is, it's one of the ways to become proactive and be prepared for anything that might happen.
Absolutely, absolutely. And thank you so much, Kimberly, for sharing such important information with us. And also, Kimberly, you talked about ICE also, and we know that, Tom Homan is going to lead ICE, and he is a very practical man, and that too very blunt. So he doesn't care about family separation. He's also like against DACA and, completely against with illegal immigrants. So do you think that we are going to expect some kind of brutality from Tom Homan's side, or will there be some kind of violent attacks, or like, yeah, what it will be?
So yeah, as Tom Homan has said, if it means family separation, then that is essentially not his problem. So I have had that question before. Well, how is it that a U.S. citizen could be deported in respect to family separation? Well, it isn't that the U.S. citizen would be deported. So I'm talking about situations where the parents might be undocumented or not have legal status in the U.S. and they're deported and they have U.S. citizen children. What Tom Homan is talking about is if the parents are deported, then essentially, in order to prevent family separation, the children would want to go, with the parents as they leave the United States. So that's, in a way, that is family separation, but the opposite of what we have seen in the past, right? Family separation, everybody thinks in their mind is people who are coming across the border and then they're detained and the families are split apart. This is a little bit different. And I think it's more egregious, right? You're disrupting children who are, or potentially disrupting children in the U.S.
Absolutely, absolutely. And also, Kimberly, I would like to know that, what kind be there some kind of biggest challenges, especially for non-immigrant visa applicants, that we are going to look in 2025?
Oh, so some of the biggest challenges, I'll do high level, and I'm sure we can get into this a little more descriptions, but biggest challenges are potential travel bans. So another public service announcement for anybody who is not a U.S. citizen, we highly recommend, if you're traveling during the holidays, which are starting very soon, to make sure to return to the U.S. Before Inauguration Day on January 20th of 2025, because we don't know if there will be travel bans or restrictions on entering the United States. So we don't want anybody to get stuck abroad. We can also expect an increase in delays in the consular processing of visa applications for people who need that visa stamp to come to the U.S. We saw that previously, and the consular posts under the State Department still have not been able to increase their staff to limits pre-Trump 1.0. So they're still working at a disadvantage, which has been essentially, in a way, beneficial in that a lot of interviews for the visa applications have been waived. We will likely see the demise of that policy. So we would expect that every visa application would require an interview at the consular post, which would more likely than not result in delays in the processing of the visa stamps. Some of the other things that we can, expect is backlogs at USCIS here in the United States with the processing of applications and petitions. So those would be, H4 applications, H1B petitions, Ls, like the alphabet of immigration, non-immigrant visa categories, as well as more likely than not an increase in requests for evidence. And we had seen that under the prior Trump administration, where there was a significant increase in those RFEs that were at one point over 40% of petitions were being issued RFEs, which resulted in higher costs for employers and individuals to respond to those RFEs, as well as just delay in the processing of those cases, which in some circumstances can mean a gap in employment authorization, which will have a negative impact on the company as well as an individual's financial situation.
Absolutely, absolutely. So, Kimberly, do you also think that the election results is going to impact on the processing of visas for family members of non-immigrant visa holders, and especially such as dependents on H4 or L2 visas?
Yeah, I do. So in January of 2023, there was a settlement that brought back the bundling of processing of the H1B and H4 cases together, as well as L1 and L2. So what had happened in the past is those principal workers had their cases adjudicated, and then the petition, or I'm sorry, the applications that were submitted for their dependent family members were processed at the same time. And then under Trump Point One, that bundling was removed, primarily because for all I-539 non-immigrant applications, such as H4, L2, J2, et cetera, those individuals had to have their biometrics taken, which meant appointments at the application service centers, which resulted in delays because those appointments couldn't be scheduled typically within a premium processing period of time. So we expect the biometrics requirement will likely come back, but will be reinstituted by USCIS. And then that settlement that went into effect on January 25th, I think, 2023, has a 2-year validity period. So at the end of January of 2025, that settlement agreement that required the bundling of the principal employees and the dependents cases together will no longer exist. So more likely than not, given that that will now be under the Trump 2.0 administration, we would likely see an unbundling, right, of those cases. So that will have a tremendous impact as well on the processing for dependents.
Mm-hmm. Right, right. And Kimberly, also, do you think that the rules for getting H1B or L1 visa could change? And if yes, then is there some certain jobs or industries, that will be more affected than others?
Yeah, so with both of those, we're likely to see an increase in the request for evidence. We also had seen in the prior Trump administration an increase in the scrutiny of L1 applications under company blanket petitions at U.S. consular posts. And so that, coupled with a delay in the consular processing, might result in significant delays in individuals being transferred from abroad to the US within their same corporate organization. The RFEs could also, as I said, have a tremendous impact, which, if those RFEs then result in a denial of the petition, that means a loss of the employment authorization, which could trigger, requirement for the individual and family members to leave the US and then wait until maybe there's another petition that's filed in the US, or there's an appeal, or there's a lawsuit before the person can be brought back to the state. So that's like the really ultimate worst case scenario. And
Mm-hmm.
then under the Biden administration, there was a modernization act for H1Bs. And part of that modernization act was already implemented that primarily affected the H1B cap process, as we saw last year, where it became more beneficiary centric, as well as, specific requirements that were needed for the registration process. And that was partly to reduce fraud. The Modernization Act pieces of that weren't implemented were changes to the definition of the H-1B specialty occupation, as well as the definition of employer-employee relationship, which becomes really critical when you're dealing with startup organizations in which the founder is someone who needs H-1B classification. Also, the Modernization Act, which has not yet been addressed, is bona fide H-1B employment, which could be increased reviews by the fraud detection unit to make sure that these H-1B petitions are not fraudulent petitions. And then there was also a cap gap protection and an expansion of cap exempt for certain nonprofit industries. So we have yet to see if the remainder of that Modernization Act is going to go into effect before the end of the Biden administration. And so that's one of the things that we're really closely watching. So we'll wait and see what happens with that. But we do, expect some additional changes with the H-1B program, just as the new administration will tighten the requirements for the H1B petition. They could also, if they're able to get Congress to act, which might be very viable right now, given that Republicans control both our House of Representatives and our Senate, it could result in legislation that would reduce the number of H1B visas that are available, which we know is already not sufficient for the workforce as needed by employers.
Exactly, and I can see that the way you are explaining it's really great, but I don't find that 2025 is going to be very smoothing season for H1B workers and also for L1 visas too. But all right, I think with guidance and with expert advice, immigrants can definitely make their jobs and industries better. So Kimberly, you talked about H1B visa and L1 visa too. So now I would like to talk about F1 visa too. So, how might the new administration's policy will impact the international students who are coming to the US on F1 visa?
Yeah, it's a good question with respect to the students. So, unfortunately, again, I have to say that there could be, backlogs with the consular
Yeah.
visa application process. So that could um, result in delays of the individuals getting their F1 visa stamps that they need to come to the United States. So that's an impact that we would likely see. And then individuals who are in the United States who might be changing their status, for instance, from H4 to F1, there could be delays in the processing of those applications, which would impact when they'd be able to commence their studies at the university. There's also as many, of the people who are watching today, and you might know that there's been a lot of attacks over the last several years, by different organizations. One primarily is the Washington Alliance of Technology Workers that has been trying to essentially eliminate the STEM OPT extension, and to a certain extent OPT as well. Back in October 2023, our U.S. Supreme Court denied the petition for a writ of certiorari, which meant that they upheld the lower court's decision that said that the STEM OPT stands as it has been enacted through regulatory measures by Immigration and Customs Enforcement. So depending on, what pressures are on the administration and what internally we can see through policies with Stephen Miller, STEM OPT could have could be significantly impacted if the administration or decides that we don't want STEM OPT, or we don't want the full 24 months of STEM OPT. So that is definitely something that we are wanting to look at very closely to see if that will be negatively impacted by any of the administration actions that might happen. And that is something to consider, because the incoming administration is what how they're acting and what they're saying is essentially protecting the American workforce. And they're protecting the American workforce in ways that will actually harm the American workforce, in my belief, and what I've seen within my immigration attorney community. Because if we don't have essential workers, then that has a tremendous impact on the economy. And as a lot of us probably know, we don't have sufficient American or U.S. citizen and permanent resident workers to actually fill a lot of the positions. We need to educate our youth more in STEM degrees, and until then, we really want to continue to attract the best and brightest from around the world, and have an open environment for people to be able to stay in the U.S. So if H1Bs are negatively impacted, or even TNs for Canadians and Mexican citizens, then I could also see a decrease in foreign national students wanting to come to the United States to universities. So that would have an impact on, like, a decrease in the use of the F1 visa classification, not because of a direct administration action to say, no, we're going to deny the visa application, but rather, the loss of individuals who are actually interested in coming to the U.S. for education and might seek education elsewhere.
Absolutely. And Kimberly, thank you so much. I'm really loving the conversation that we are going through. So, but Kimberly, I would also like to ask you that, we also have interviews with different attorneys, and they say right now that as Trump is going to be back in White House, so, most of the immigrants, they are afraid and they are trying their level best to leave US before Trump's rule. So, are you also getting calls? Are you also been into the situation that you are on people's mind, and they're completely coming to you and they're asking for the help, what to do and what not to do? Is it so?
Yeah, there are definitely a lot more questions
Hmm.
from both individuals as well as from companies, right? So a lot of the corporate clients with whom we work are concerned about losing some, really valuable employees through a
Yeah.
scare of, reduction in H1Bs, the removal of, potentially removal of DACA, as well as TPS, which is temporary protected status. So those are, in our workforce, we still have a lot of individuals who don't have sponsorship by an employer and whose status in the United States could be significantly impacted. So we do have, a lot of calls from individuals who are on DACA or TPS to understand, how does this impact them, right?
Hmm.
TPS is at the discretion of Department of Homeland Security. And a lot of the TPS work authorization and designations are valid. Some of them will expire in March of 2025. So there's concern right now, is the Biden administration going to extend those? Will the new administration cut them off immediately? What kind of impact does it have to those individuals, and what alternatives do they have to be able to remain in the US if they decide that they want to remain in the US? So yes, Tim, there are a lot of questions that are being, I guess, thrown at us, and in that sense of, hey, I want to understand what's happening, and I think that's really important for people to have an understanding of where they are with respect to their status and how they could potentially be impacted, so that they could, like companies are doing, plan and strategize and have a strategy to the extent possible ready if we have that worst case scenario. So those are really some key things. Like here in California, we plan for earthquakes. We have our go bag, for individuals, plan for the worst case scenario, a denial of an H1B
Hmm.
petition, how would that impact their family life? And then for individuals who are undocumented, as I mentioned, having certain plans in place for caregiver agreements or people who can step in and help out with their finances or what happens to their apartments. And those are some things that, are tangential to losing a job, but it's really important. If you have a U.S. worker, U.S. citizen who loses a job, they
Hmm.
can stay here. But if a foreign national loses their job, they more likely than not might have to leave under the Trump administration. So those those questions are definitely important, and I think it is important for people to have an understanding of how they can be impacted directly and have a strategy in place.
Right, right, absolutely. And Kimberly, one more thing I want to ask you that, we definitely going through about the US situation, what is happening right now. But here's a question that I want to ask that, there are so many undocumented immigrants also who are living and staying in US. So till now, they didn't get any time to make their documents clear or what it was, because that has been quite a long time to prepare their documents. But why is it so much fear around the undocumented immigrants? Because they got time. So why is this that they still don't have the documents?
Oh, so why do people still not have authorization or status in the U.S.? Um, it's a good question. And our bottom line, our immigration system is really complex and it's
Mhm.
has a lot of flaws. So if you don't mind me giving a little bit of history of
Yeah,
what
sure.
happened. Yeah, so in 1996, under President Clinton, who is a Democrat, we had the last major immigration reform, and re, we refer to it as IRA. Under that provision, or that act that came out, there was a provision that put in place what we call unlawful presence. meaning if someone is admitted into the United States, they're admitted for a certain period of time. If they stay beyond that authorized period of time without having an extension pending or a change of status pending or taking some action, then they become unlawfully present in the U.S. If someone is unlawfully present for up to for 180 days, but less than 365 days, once they leave the United States, they cannot come back for 3 years unless they can obtain some type of non-immigrant waiver. If someone is unlawfully present for 365 days or longer, then when they leave the United States, they are barred from returning to the U.S. for 10 years, unless they can show that they can get an extreme hardship waiver, and those are really difficult to obtain based on the criteria. So we created this undocumented class of individuals who were fearful of leaving the United States because once they did, they couldn't come back for 3 years or 10 years. And that was the only mechanism where these waivers or remain outside of the United States for that period of time. We, in Congress, there was an immigration reform bill that was passed by the Senate in 2013. And then it had full support, bipartisan support by the House of Representatives. But the Speaker of the House at the time, John Boehner, refused to bring that bill to the floor in the House of Representatives because he knew that there was strong bipartisan support and that it would be passed. And then it would be signed by President Obama. And Speaker Boehner did not want any type of immigration reform credit to be given to President Obama. So the bill died. And that was a really good reform act in that it alleviated these 3 and 10 year bar triggers. It also provided visas for what we call guest workers. So for individuals who come into the United States who are in jobs that I would say like U.S. citizens don't normally want to do, right? If there's people in landscaping, construction, nannies, like they're really, really tough jobs, agriculture. So we've created, in a sense, an undocumented population by, those 3 and 10 year bars, which have created problems for people to essentially correct their status. So there have been different provisions put in place that have tried to soften that a little bit, but under a Trump 2.0 administration, those are going to be almost impossible to obtain. And just to answer your question in terms of, well, what about people who've been here for more than 9, 10 years? Because our immigration system is very limited with respect to visa types that people can obtain. If you have someone who falls into this undocumented category and are subject to the 3 or 10 year bars, it's really impossible to get their status corrected. Again, unless they leave the U.S. and are out for a significant period of time. And then also, we don't have visa classifications for a lot of individuals who would normally are employed in some really key positions in the U.S. And by key, I mean those jobs that U.S. citizens might not want to do. So the grunt work types of jobs, so to speak.
All right, I think that's great, because these are the questions that most of the people have in their mind, and they are completely, they get confused what it is. But I think, Kimberly, you were absolutely, it was so good to hear about the history, that why it is happening, and, how they can also work on this. So thank you so much, Kimberly, for your outstanding answer. And I'm really loving this, and absolutely, you are a great speaker, as we all know. So I'm really admiring it right now. And Kimberly, why don't we go ahead and take up viewers' question too, because they are also having a quite a long question. So I'm going to take firstly Cynthia's question. So Cynthia is asking that I am planning to apply for an H1B visa in early 2025. Should I be concerned about new regulations or executive orders disrupting the usual process? What can I do to prepare for potential delays or increased scrutiny?
That's a good question. So I'm assuming that this is in reference to the H1B cap, which would we anticipate that registration will occur in March, as it has since, well, forever. But the registration itself, I mean, for H1B cap in the past, for many years, we had to get the cases in by April 1st. Beginning in March of 2020,
Mm-hmm.
we went to that electronic registration process, which we were all skeptical of at first, but it has for the most part worked. So that will be in March.
Oh.
At this point in time, it's probably there isn't enough time, is not enough time to implement a new regulation that would change that particular registration process. Um, the registration fee has gone up to $215 this coming 2025. It was $10 last fiscal year, March of 2025. So that was implemented under the Biden administration, along with primarily all the other fee increases that went into effect April 1st. So it's a significant increase for employers to pay the registration fee. And what could happen are these triggers that would say for H1B specialty occupation, there's a more strict definition of what is a specialty occupation. Or there could be that salary requirement, which means that the salaries that are offered have to be higher. What we use in the Department of Labor's wage survey, there's 4 levels. So it's looking what the prior Trump 2.0 wanted to do was make it essentially level 4, which when you're looking at someone in entry level and getting a level 4 wage, that's a significant increase, and that could discourage employers from sponsoring. So what can somebody do? Work with your employer, right? If you know which employers agree to sponsor under the H1B cap registration, talk to your employer about your concerns of, how is this going to impact us? Employers that work with immigration attorneys usually do work really closely with determining who the company wants to put in the registration. And then a lot of times there's an assessment that is completed to look at, is there going to be an issue with the specialty occupation? If so, how do we deal with that up front, right? What kind of research or do we need to do in order to prepare for that? As well as looking at what is the wage survey, what will be the prevailing wage, and then can a company use an alternative wage survey? So those are the nitty-gritty issues that the company would discuss with the employer. But usually information will be passed along to employees. Hey, there's going to be a change in the H1B cap process, or there's going to be a change in the requirements. So I would say be on the lookout for those potential changes, and they should be addressed or broadcast by the attorneys and the company, but they will definitely, be in the news for sure. There's changes with respect to that. And then also, one of the things that we do is we work with our corporate clients and foreign national employees. Are those we consider last chancers, right? So last chancers are those who, if they're not selected in the H1B lottery, then they have no, what is their alternative to be able to remain in the U.S.? So that, in essence, if we're looking at significant changes to the cap process, if they do happen, then in my mind, a lot of people we would be treating as essentially last chancers. So looking at what are alternative strategies to get different types of work authorization in the U.S., such as an O1, which is for extraordinary ability individuals, or is this a situation where somebody might need to go work abroad for a year or so and then be transferred back to the U.S.? But that's a really long answer for the question, but I just wanted to think about all the different angles of it and things to consider.
But that's how, we want answers. We want everything to be clear, and that's how you're answering. Thank you so much, Kimberly, and thank you so much, Cynthia, for participating in today's episode. And next up, Kimberly, we are going to take question from Fawad Ali. So he's asking that I'm currently on an F1 visa and considering transitioning to OPT. With the potential for stricter rules post election, should I expedite my application, or is it safe to wait for my planned timeline?
So the university is in charge of granting and issuing the Form I-20 with the OPT recommendation or approval. I do recommend for individuals that have the option to premium process a case at the immigration service that be utilized. So I understand that premium processing is expensive. All premium processing now is well over $1,000 for the immigration service to process cases, applications, and petitions, quote unquote, faster than normal processing. But I strongly recommend utilizing premium processing if at all possible, unless there's a strategic reason not to. We have that in certain situations. So but I'm just thinking with OPT, I don't see any strategic reason not to utilize the premium processing. Again, you just want to address your current specific situation, but that would be one of the ways that I can see, ensuring or trying to get ahead of the processing of an application before Trump 2.0.
All right, all right. And also, Kimberly, I need to ask you something that, mostly we have seen in US companies that they prefer employer sponsored visas rather than individual merit. So, are we going to see any kind of change in how the applicants are being evaluated? Will the individual merits be getting more preferences, or how it's going to be for them?
Oh, so yeah, under Project 2025, there is some discussion about changing our immigration system to be more focused on individual merit,
Yeah.
and potentially going to a point system, but primarily looking at individual merit. At
Mhm.
this point in time, we do not have that in our immigration system, and
Mhm.
most employers essentially when they're interviewing and when they're recruiting for a job, and then when they're interviewing applicants, they're looking at who's the best fit for the company. And in many times, I've actually seen some companies that have never sponsored anybody in the past, and they're willing to do it because they found that unicorn, right? That one person who the hiring manager really, really likes, and the individual who will be a good fit in the organization.
Mhm.
So I would, until there's some change in the regulations or the law, I would expect employers to continue to recruit and interview and offer, extend offers of employment, based on the particular qualities of the individual and if there is a visa option for that individual. So
Mhm.
those are some of the things that we see usually um, with companies that don't want to sponsor. They do have a policy that says they're not going to sponsor for any positions, and sometimes that's from a business operations perspective because it just takes too long to obtain certain visa classifications, or it's more, it's financially burdensome for the organization. So from a business operations perspective, there are some companies that choose not to sponsor individuals, but otherwise, that individual merit based system in our immigration system in the United States has not been implemented. It's been primarily discussed within the Project 2025 document and prior Trump administration.
Mhm. All right, all right. So I think that we can also look for a good change, though, because till now mostly it was preferring the employer-based visas, but now we can also have a hope for individual merit too. So, Kimberly, also one more thing I would like to ask, as you mentioned about Project 2025. We have went through that, and we have seen that how disturbing it is, how extreme it is. Trump himself said that he is not going to implement, not clearly, but some on the other we found in his statement that he's not favoring Project 2025. But the irony is that in Project 2025, we can see 100 times it's mentioning about Trump itself. So, what can you say on this? Do you think that it's kind of tactics that Trump is trying to play in front of people, or what it is?
Oh, that's a loaded question. So e- by seeing who Trump is appointing to his administration at the cabinet level, some of those individuals, such as Stephen Miller, I think his first name is Kenneth Vogt,
Mhm.
who's President-elect Trump wants to be in Office of Management and Budget, and a couple other people have been individuals who have been proponents of Project 2025, as well as individuals who have helped to write Project 2025. So by President-elect Trump's actions alone of bringing those individuals into his administration, to me, says I am embracing Project 2025.
Mhm.
Maybe he's not embracing all of Project 2025, but it seems pretty clear to me from the actions
Mm-hmm.
that Project 2025 is, in fact, a big part of, or will be definitely a part of, the administration's policies and systems. So that's how I'm looking at it from that perspective
Mm-hmm.
um, for Project 2025. So we are anticipating that some of those proposals will be implemented or will try to be implemented.
Right, right. And I think, by seeing the list of Project 2025, most of the people are scared. But let's see how it does. As you also mentioned, that maybe some of the policies he may implement and some of them it's not. So, all right. Thank you so much, Kimberly, for your answers. And now I would also like to ask some questions from the Facebook group as well. So, here's a situation that I would like to read it out. That is that I have a question to me and my brother and sisters, and my mom came from another country here back in 1988. My mom passed. She had an aneurysm, leaving my brother and my sister without any papers. We came here legally on a plane. I'm worried with the situation has going on with Trump and want to get them help. Do you know what can we do? My sister has a mental breakdown as my brother since my mom's passing, which it makes it even harder to deal with things. I just want to get some help.
I'm really sorry to hear about that. That's really heartbreaking. Um, the my recommendation and the best thing to do is to seek guidance of an experienced immigration attorney who works with individuals within the community that do not have any status in the United States, in order to determine what potential areas of relief are available. um, and Sam, we had talked about this a little bit earlier, like why have some people stayed in the US and not corrected their status in all these years? And unfortunately, sometimes there's just no options, or the option has been to leave the United States for 10 years and then come back, which, being outside the United States for 10 years can create incredible hardship, especially on family members. We have several situations where a U.S. citizen has married a foreign national who, is, excuse me, is undocumented, and because they had entered without inspection or they had certain violations, they were subject to that 10-year bar and would have to leave the U.S. for 10 years. So that's, that in a way that's a solution, but it's not a good solution for many people, right? Leaving your
Mhm.
home essentially is really difficult. So my recommendation and guidance is to really seek out an experienced attorney in the area in which you live. And one of the things that you can look on for the under the bar associations, they'll have, sometimes they have pro bono lists, so that might be an option to start there, or to reach out to one of the immigration associations like Catholic Charities or the Immigrant Justice Project, just to see if they have recommendations, because I don't want anybody to get in a situation where they're dealing with, an notario or an
Right.
attorney who doesn't understand that particular area of law. So it's really important to find someone who is experienced and can help out, but with having that consultation.
Absolutely. And I think, guys, we have Kimberly, so I think it will be great to contact attorney Kimberly Best Robidoux. And not only in case of anything about H1B or L1, you can also contact her related to any problems or any, processing of immigration that you're going through. So here's her contact details that I would like to read it out. Her contact number is 619-826-4010. You can also email her at krobidoux at wolfsdorf.com, and you can also visit her website, that is www.wolfsdorf.com. All right, so thank you so much, guys, for being for participating in today's session, and to Kimberly too. Moving ahead, Kimberly, there are some different questions also that I would like to ask. That there are so many participants who keeps on commenting and keeps on texting us. So now I think it's the best time to take up those questions. So, yeah, Kimberly, there's another thing that anonymous participant is asking. My husband and I have paid an immigration lawyer $9,000 so far for his case. She has not submitted his packet to USCIS. Today, we received an email asking for more money. Times are getting harder. What would you do?
Well, I don't know the particular circumstances of the situation, so I can, comment on different types of applications and petitions take different periods of time. So, for instance, if an immigration attorney is working on an EB1 preference category for extraordinary ability or outstanding researcher, or even EB2 national interest waiver, that can take 3 to 6 months to prepare the petition in detail, to gather the information, help write the employment or the recommendation letters, put the case together. So that is an out of the norm for a case like that to take 3 to 6 months to prepare. For other cases such as marriage to U.S. citizen, where there's an I-130 immediate relative petition concurrently being filed, possibly with an application to adjust status, that can take a couple of months to prepare, and that's after an attorney receives all of the documentation and information necessary to prepare the case.
Mhm.
If there are exigent circumstances and there's a deadline, then an attorney should be made aware of the deadline. And most likely, once they are aware of the deadline, then a case can be rushed in order to, file something so that an individual does not go out of status. So those are some factors to consider. And then I also look at what was in the services contract, or some people call it an engagement letter. So what did that say? Did it say that the attorney was preparing, specifically what is the attorney preparing, and what is the fee for that preparation? And is the attorney asking for additional amount now because those are the filing fees that need to be submitted to USCIS, versus asking for more money to adjudicate or to prepare the case? So those are some things that I would look at. I would definitely look at that agreement that you have between you and the attorney, to understand specifically what it is stated in that agreement for the attorney to be preparing, and what the fees are. Those should be clearly stated in the agreement. And anything outside of that, you definitely need to ask the attorney, for specific information about why they're asking for additional funding or fees. That's really important.
Absolutely, absolutely. So thank you so much, Kimberly, for your answer. And next up, we have received a question from Shani Tracy. So her question is that my fiance was recently detained by ICE. He is a Wasden refugee here in the US, legally I-94. We need help. He has some misdemeanors which led to them detaining him, located in the DFW area, seeking pro bono assistance.
So that would be Dallas Fort Worth. I would check with, I think there's a Catholic Charities there, or an immigrant justice project of the
Mhm.
American Bar Association. But also, I'm not sure if Texas Bar Association has a list of pro bono attorneys like the California Bar Association has. So that might be an area to focus on. Um, there's also one of the things to look at in the Dallas Fort Worth area is to look at any kind of, one of the other things I have had people do is contact the immigration clinics at various law schools. They might be helpful, or they definitely have the pulse, on their pulse on the community, and can know, or more likely will have the information to make referrals to specific individuals in that area who can address that particular situation. Because with ICE, um, there's a lot of work that goes into sometimes contacting ICE, trying to get to the right ICE officer, just trying to get the right information to find out, where the individual is being detained, and then work through that process. So those are some of the people I would recommend reaching out to right away, in order to get someone who is essentially boots on the ground, in that community area in order to help out with that situation.
All right, all right. Thank you so much, Kimberly, and I'm sure that Shani is definitely going to accept the all the conversation that she's listening right now. And also, we have next question that we have from G Annie, and he's saying that, "Hi everyone, can someone tell me if I should do anything else after I file the I-130 online?" Also, in the form, I put in the address Canada since my parents were visiting my sister during that time. I even put in Canada address for the closest consulate to conduct the interview. I don't know if I did it correctly or not, but now my parents are back in Philippines. Should I do something about it?
All right, so that's a very case specific situation, right? And so after filing an I-130 petition, typically there isn't anything that can be done to make corrections unless there's a request for evidence that's issued, or potentially after an approval of the I-130 petition, it's sent to the National Visa Center. And at that point in time, at the National Visa Center, if the National Visa Center says, well, we're scheduling the immigrant visa at the pardon me, at the U.S. consular post in Montreal, um, then there's the ability to say, well, the beneficiaries do not live in Canada; they live in Philippines, and here's proof of their lawful status in the Philippines. And then the National Visa Center, which is part of the State Department, can work to adjust that immigrant visa application process from Montreal in Canada to the Philippines. But if there are specific questions, before then, in terms of anything that may have been that might need to be addressed, I would again speak directly with an immigration attorney who you would retain that can look over the actual, the full on petition, understand all the particulars, because even though it might seem like nothing or just a really small point, can be a huge
Right.
factor in determining what to do next.
Absolutely. We really have to be very much particular about all the information that we are sharing and we are receiving. All right. So here we have another question from Delgado, and he's asking that, can I apply for citizenship if I lost my green card? I am eligible to become citizen, but I don't process my green card. What can I do?
Yeah, so permanent resident status is based on, it gives you the ability to live and work in the United States, and the card is just evidence of that status. You don't typically need a valid card. Like if you let your card expire or you lose your card, it doesn't mean that you lose your permanent resident status, unless if you've been abroad for many, many years or for a significant period of time, or you don't pay or file a U.S. tax return. So those are all other issues that could impact
Yeah.
green card status or permanent resident status. But if it's a matter of somebody has maintained their permanent resident status in the United States and they've let their card expire, you may still be able to apply for naturalization, because naturalization has its own requirements with respect to having been a permanent resident for at least 5 years, unless you're married to a U.S. citizen, which can reduce that time to 3 years. Being physically present in the United States for at least half of that 3 or 5 year period of time. Continuous physical presence in the United States, meaning no more than 6 months in a row outside of the United States, and then having a good moral character, as well as being able to read, write, and understand English and pass the civics test. So those are the criteria over, generally for naturalization. If someone is required to apply for a new permanent resident card and pay the hundreds of dollars for that card while their application for naturalization is pending, is again like something specific with respect to the timing that should be addressed with an attorney based on the particular circumstances of the individual. Because in some circumstances, the person can file their N400 naturalization application without having to apply to get a new permanent resident card. But there are strict,
Yeah.
criteria around that. So that would have depend on a case by case situation.
Absolutely, absolutely. Okay, so next up, we are going to take this question. So, I need help. My brother in law came here illegally and has been married to my sister for 3 years, and they have children together, and they don't want to know what steps. No, no, sorry. I'm so sorry. Uh, I'm reading it again. Okay, I think I fumbled in between. So yeah, here it is. Here's a question that I need help. My brother-in-law came here illegally and has been married to my sister for 3 years, and they have children together, and they don't want steps to take to get his papers started. They fear what their future may look like. So, what should they do to have some form of security in these hard times? Oh God, this is something very, you know, very critical topic. So, how do you
Yeah.
say?
So in that situation, if someone has entered without inspection, meaning they crossed the border not at appropriate ports of entry and were not admitted and inspected by an officer at the port of entry, then typically trying to write your status is pretty much impossible unless you obtain a provisional waiver of the extreme. I'm sorry, a provisional extreme hardship waiver, or potentially reside outside the United States for 10 years. So those are the heartbreaking scenarios where we see that there might not be a particular solution, or a solution that is not something that a family wants to go through because it means separation of the family members. So in
Mhm.
this particular, in this circumstance, and then in anyone who has anything similar, my advice again is to seek experienced immigration counsel to discuss the very specifics of the background, the history, current status, looking to see if there are any available options to proceed with obtaining valid status in the US. But also, unfortunately, in these times right now where we're expecting, Trump 2.0 in 60 days, um, working not only with an immigration attorney, but potentially also another attorney or um, professional that can help get everything in order with respect to, as I mentioned, in California, there's a caregiver document. There are similar documents throughout the country in every different state, as well as getting things in place with, picking up, how do I get my last paycheck? How do we pay the rent? What do we do with our property? How do we have like a family tree contact list, so to speak? So, again, preparing for the worst in case there is action taken by ICE for deportation. So that's a piece of it. And then the other piece of it is looking at what options are available. And, some of the things that even looking at now, is it smart, or is it a good idea to actually put someone forth with an application or a petition where you're putting somebody vulnerable into the immigration system, where it can be easier for ICE to find that information. So those are things that really need to be considered and discussed with an attorney.
Absolutely,
Which,
absolutely. So I think that's very important, because now people only think about how the policies are, how the process is, but we don't see that what problems do they really face. So I think this is also very important, Kimberly, to mention, and you mentioned it beautifully. So Kimberly, this is the last question that I would like to take up, and okay, let's take from this question from a viewer,
okay.
that is Madhvi. So Madhvi is asking that my employer is planning to sponsor me for an H1B next year, but we concerned about potential caps or quotas being reduced. Is this likely scenario, and how can employers overcome this risk?
Um, so decreasing the number of H-1B visas would take an act of Congress. It may or may not be possible for Trump 2.0 and the administration to take that up before we have the H-1B cap registration in March. It's definitely something that everybody is going to be watching and looking to see what happens. Um, in terms of how to prepare, the best thing to prepare is to prepare as if the registration is happening, that we'll have the same number of visas for H1Bs, and then look at the alternative strategies, if not if the registration is not selected in the H1B cap. So does, the individual have optional practical training or STEM OPT that can get them through another year? So look at those alternatives to the H1B cap. And then if there are no alternatives, what does that mean in terms of potentially getting prepared to having to leave the US? So those are all good conversations and things to discuss in advance. With respect to the H1B cap lottery, I mean, we've seen the percentage of being selected getting lower each year. So those who have less than an advanced degree from a U.S. university have had definitely under 30% likelihood of being selected in the lottery. And then those who have an advanced degree from a U.S. university have had slightly greater than 30% chance of being selected. So even without a decrease in the visa numbers, we also already unfortunately have very low selection rates because of the significant demand. But thinking about it, we could have less demand this year, with employers saying, well, the registration fee is $215, so we have to be really careful about who we select to put in the registration. So the selection rate may go up. So I don't know. It's a mixed bag right now, and I hate to say that as an attorney, like it depends, but in this scenario, I think it does depend. And the best thing to do is just prepare for what if I'm not selected in the registration. What does that look, and what are the options?
Absolutely. And this is the same thing that I would also like to suggest to our viewers also, that guys, it's very important to, contact an expert attorney to get the right guidance, so that you don't do something that, you can get into hurdle with. So it's very important to stay updated and to stay informed on everything that is happening. So that is why it's very important to like, share, and subscribe to Immigration and Jobs Talk Show to attend our everyday live shows, that we have with different attorneys with different topics. And you can also get a chance to participate in this conversation by commenting and by replying to us. So it's going to be a great opportunity. And well, Kimberly, we have come across to our almost 1 hour, and it has been wonderful experience from my side. I really enjoyed, and you were outstanding, you were clear, practical, and to the point. And I really enjoyed this session. How was it, like, how did you feel it? How was your experience?
Oh, this has been fantastic. Thank you so much, Sam. It's been, as you can tell, a great topic. Unfortunately, we're having to talk about some really hard issues and tough
Yeah,
topics, and the discussion isn't happy discussion. But I think it's really important that
exactly.
people are getting prepared and are arming themselves with knowledge, right? Knowledge is power. So I think that's really, really important. And thank you for bringing this to your viewers, so that they have that knowledge and they can, protect themselves or plan for the future. I appreciate it so much.
From our side also, thank you so much, Kimberly, for sharing these insightful information with us. And it has really been a great, great session, and a very insightful session too. So guys, if you would like to contact attorney Kimberly Best Robidoux, then please go ahead and contact her right now on the given details, that is 619-826-4010. You can also email her on krobidoux at wolfsdorf.com, and you can also visit our website, that is www.wolfsdorf.com. All right, guys, so thank you so much to everyone, to each one of you who has participated and who has watched our session till the end. Thank you so much, and keep on like, share, and subscribe to Immigration and Jobs Talk Show. I'm Sam, signing off for now, and thank you so much to attorney Kimberly Best Robidoux. Have a great day.
Thank you, Sam.
Thank you, guys.
Good afternoon, everyone. Thank you so much for joining us. Welcome to Immigration and Jobs Talk Show. This is Nipasa Pradhan, and I'm going to be your host for today. And it's lovely being here. So, sorry, it's not just good afternoon. It may be good morning or good evening. So, thank you so much wherever you've joined us from whichever time zone. So, welcome to Immigration and Jobs Talk Show, and I'm really happy to be here. We are streaming live right now on YouTube, LinkedIn, Facebook, and X. And I'm really glad that you have joined us. And before we proceed with today's webinar, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, yes, and you can also participate, by the way, in this session, friends, by commenting whatever questions you have, especially with regard to today's topic of discussion. And that is Trump's new team, a fresh start or a nightmare for immigrants. I'm sure all of you folks have many questions and are probably in a dilemma whether it's going to be good or it's just going to get worse for you. So, today, here in this webinar, we are going to discuss this further, and joining me is someone who needs no introduction, who has been a part of Immigration and Jobs Talk Show, makes it a point to be here. So I'm very happy to welcome once again none other than employment based immigration law attorney, but also a true advocate for the immigrant community, from defending H1B RFEs and NOIDs to guiding students on F1 OPT visas and offering expertise on TN and E3 visas. Justin has been a beacon of hope. So please help me welcome him back to the show. Hello to Justin Rivera from Wasden Immigration Litigation. Thank you so much for joining us.
Thank you for having me. That was a very nice introduction. I appreciate it.
It's been a while, I mean, I take it for granted sometimes, and maybe I don't say good things about you or let folks out there know. So maybe we have new friends. This is none other than Attorney Justin Rivera, today's special guest, and he's going to help us today on this topic. We're going to talk a lot on Trump's new team. So before we head start, Justin, what do you have to say to everyone out there?
Well, anybody that's here that's celebrating, an early happy Thanksgiving to you, because that'll be coming up this week. If you're here in the U.S. celebrating that, happy Thanksgiving. I hope you have a short work week. But yeah, in regards to today, we'll just try to delve into, I think, a lot of what many people are doing right now, which is trying to kind of wrap our heads around what a new administration is going to look like and the impact that it's going to have on immigration in the country. And you can do that kind of by looking at who's being put in influential positions within the administration, and what have those people said about immigration, and what that possibly means they'll be actually doing moving forward.
Absolutely, friends. Thank you so much, Justin. And yes, don't forget to participate. And before that, if you have friends who would be interested in getting to know this more about today's topic, Trump's new team and its effect on immigration, please feel free to share this link with everyone or your friends out there and ask them to join in this discussion. So, yes, thank you so much once again. And let's go ahead, Justin. I have this first question. This is regarding Pam Bondi, and she has a history of aligning with Trump's agenda, including her role in his impeachment defense and her work with America's first policy institute. So, how do you foresee her policies impacting immigration cases, especially regarding federal prosecution priorities?
So I think obviously it's a fortune teller argument here of what are you predicting or what can be done. But I definitely think that, there is an avenue to go after criminally, go after people that are, found to have committed visa fraud. Usually that's something that's applied to companies, organizations, usually the higher up individuals within the organization. And so, could they use that avenue moving forward more liberally than they have in the past? I definitely think it's an option. In regards to Pam Bondi, just kind of reading up on her and looking at kind of her record, I think she's probably going to be basically doing what Trump is asking her to look into. And from her perspective, I think the immediate things are probably not going to be immigration, and that enforcement of, maybe fraud allegations against individuals. Now, that's not to say that that couldn't happen, because honestly, it would be a pretty interesting tool for them to try to utilize if their goal was to actually start trying to crack down on the companies rather than the individuals, as a method of kind of limiting how some of the organizations that have been able to get away with using H1Bs would be able to use them moving forward. So I definitely think it's something to look into and think about. I do know that from my understanding of Pam Bondi, her relationship with Trump had something to do with I guess the fact that he gave a donation to her of like $25,000 or something like that to her reelection campaign, and not as a direct result, allegedly, but maybe the fraud investigation into Trump University in Florida was no longer something that was being discussed or put on the docket. So that's on the Washington Post. You can see the inference formed there. But what that really kind of tells me is it's like you're going to see with a lot of these appointments, it looks like it's more of a loyalty issue rather than a skills issue. It's, is this person willing to carry out what it is that he wants to put forth with his administration? And so, yeah, I would say, would it shock me if there were more cases brought against people for visa fraud, especially the employers, the people who are actually signing the H-1B forms? No, it wouldn't shock me at all. And honestly, if I were them, it would probably be something I would utilize.
All right. Thank you so much, Justin, for giving us a sneak peek into your thoughts about Pam Bondi, and thank you so much. You can also go check out the post on Washington Post, and the news is out there already. So thank you. On that note, Justin, we also have Amay on YouTube asking a question. Amay, please stay with us. We will take up your question in a bit. Hang on. For now, I have another question, and this is about Matt Gaetz. Although he withdrew his nomination, the controversy surrounding his potential appointment raised concerns. So, does the consideration of such a figure indicate a shift in how the administration might handle immigration related ethical and legal matters?
So, yeah, I mean, I don't know really if we're going to be able to frame it specifically through the prism of immigration, but I think what we saw with Gates's attempted appointment was the fact that there are still guardrails in place, regardless of how tenuous those guardrails are. There's still going to be some level of qualification required for these people being put into these positions. And the fact of the matter was that Matt Gaetz, he wasn't really qualified for the position that he was going to be put into. That being said, as well, would he have gotten the position were it not for his ethical issues? It's very possible. But what it really kind of does show me is that there is still going to be pushback on appointments, which is a positive thing. That people still should be held to a high standard. But in terms of immigration and kind of how I think it's kind of interesting, you could maybe draw this small parallel from it, but the fact that Trump was even willing to try and appoint Gaetz in the first place, it's not that surprising, and it's a bit indicative of his strategies. A lot of times they just kind of throw stuff at the wall and see what sticks. So if I'm looking at it from that way, I wouldn't be that surprised if you see a lot of quick changes to immigration that come in, and a good amount of them end up being invalidated by the courts. Just because they don't hold legal muster. So that wouldn't shock me. I definitely think that they are more willing to act and then just kind of see whether or not the court will let them act, rather than make a prepared, concise, well-researched change that's going to stick. So that would be my thought process, would be, don't be surprised if you're seeing, within that first month of the administration handover, changes, fairly drastic changes and proposals that may or may not actually hold up in a court, but are still going to cause hiccups in the immigration system.
All right. It's scary how the situation is for many immigrants out there, I think. And with all these new picks, I think it's the situation is getting even more tensed. What do you say, Justin?
Uh-oh.
Can you hear me?
Yeah, sorry. The quick little hiccup right there.
No
Um,
worries.
I
So,
gotcha. I'm here.
yeah, I was just saying, like, with these new picks, it's just getting scary. So, what do you think?
It's actually someone just commenting about. I think it's Dr. Oz was allegedly being given an appointment. No, I know, Sakshi. I know. Yeah, it's not ideal for me. I think for a lot of people who are looking at the individuals that are being named to these positions, there is a little bit of a wow factor to it, because I think in the first administration, I think Trump was a little more reeled in just by the nature of the fact that, like, it was fairly surprising for most people that he won, and I think there was a little bit of period where the Republican Party was kind of like, we're going to put we're going to put guardrails up. We're going to have people appointed, Rex Tillerson. There's going to be people put in positions that are experienced and qualified and know what they're doing. What we did learn, though, from that administration was there was a pretty high level of turnover, and that turnover basically correlates to, if you're not doing what he wants, you're going to lose your job. We saw it with Jeff Sessions, and then he even ended up having problems with Barr, which was, another person he had appointed himself for the AG spot. So the other thing to think about, too, with this is kind of a shelf life. How long are these people actually going to hang in these positions? And actually stay and deal with kind of the turmoil that this administration is inevitably going to bring. So that'll be something I think we're going to have to consider as well.
Right. Right, Justin. Thank you so much. That also was a very good insight, I would say. And we have Malutek USA and even Sakshi joining us with their questions. And I think that we can take Malutek's question for now, if you don't mind.
Yeah,
So it's
sure.
asking, Canada, Australia, and UK reducing temporary issues and student visas. Why Republicans act more left than Canadian Trudeau? 10,000 of American tech workers are unemployed, desperately need job. Okay. What do you have to say?
I Okay. I think so. I've been kind of monitoring the Canada situation pretty closely because I found it very interesting. So during the initial Trump administration, Trudeau, who is still in a position of authority, Trudeau was very open to immigration. He was basically saying, like, oh, if you're not wanted in the United States, come to Canada. We want you here. We're more than willing to take people on.
Yeah.
They looked into expanding their immigration regulations to bring in a higher influx of people. That may have come back to bite them. About probably around last year, the middle of last year was where I started seeing it. That's not to say it's
Mhm.
not something that's been existing before, but I did start seeing a lot of attention on it in the middle of last year, and it's at the forefront this year. Trudeau's already made statements that he's reversing course. They are taking steps to curtail and limit immigration moving forward. He has made the spigot argument, which he's claiming that the spigot, the water spigot, has been turned too far one way and needs to be turned back the other way.
Mhm.
That's his
I've been
stance.
playing through my 34 years.
What's up?
Sorry.
Oh, it's okay. But anyway, that's he's a politician. He's dealing with the vibe of what's going on in his country presently. But as a result, yes, I think you're seeing Canada move towards more restrictive immigration policies. Australia, I think I've also seen is possibly trying to reduce immigration. I'm not as well up on the UK. Why Republicans would act more left than Canadian Trudeau. If you're saying why would the Republican Party embrace immigration, legal immigration in the United States? Because legal immigration in the United States is beneficial to the United States economy. It's been well established. So there wouldn't be really any valid justification. I think that the whole point of these programs like the H1B program are to create the necessary guardrails that prevent U.S. workers from being kind of left out in the cold by, allowing there to be people who are going to be able to do the same job for less money. That's why you have the labor condition application that establishes the wage levels. These things are stringently enforced, both when someone applies for the H1B and through FDNS's site visit systems when they actually go out and make sure that the person's complying with the conditions of the H1B. So that all being said, it would not shock me if the Republican Party acts differently than the Biden administration. I know people are very quick to jump the gun and say, well, what has Biden actually done for legal immigration? Like, how is it that different than it was under Trump? I will tell you firsthand, as someone who practiced under the Trump administration, it was significantly different. You were dealing with an entity in USCIS that was borderline adversarial. It wasn't more so our job is to process these applications. It was, we're looking through these applications almost with an assumption that there's something deniable in what's being presented to us. And I think that's what you're going to see as the biggest difference. And it will show you that the Republicans are not more left than any of those other countries. They are going to seek to draw out the time it takes for an application to be processed. They're going to do that using requests for evidence that I'm sure will become more detailed and require more information than is currently necessary. They're going to do that by attempting to limit validity periods any way they can, meaning, they're going to probably go back to trying to find ways to cut down people's requests for 3 years. Whether or not that will hold up in court, we will have to wait and see. But I'm sure that they'll be taking from the pages that they've used previously in order to grind the system as slowly as they possibly can. On top of that, yes, it's completely possible that they're going to be introducing new ideas and new ways to try and make the system even more difficult than it is presently, with the underlying goal being that they want employers to just not have to deal with the program, and if they do things like increasing the wages, making it to where you have to pay even more to have someone employed on an H1B. That's one avenue that they may look at. They may look at curtailing the definition of specialty occupation, making it more stringent to where it's more difficult to qualify for the position. They might make it harder for the employees to qualify with their degrees, unless their degrees are absolutely one-to-one correlated to the job duties being performed. So these are all things that they're going to do. And if they didn't do them, it would surprise me. But these are all things that I definitely think they want to do. And with Stephen Miller, who I'm not sure if we're planning to talk about today or not, but with Stephen Miller in probably a more influential position in this administration than he had been previously, all of these things are going to be on the table. And it's not really, to me, a matter of if, but when, and whether or not they've now also decided to find new things that they're going to be putting forth. I believe I saw last week, towards the end of the week, something about the dismissal of a case that had been backed by a Miller group where they were going after, once again, the H4EAD. So it was another attempt for them to go after some part of immigration to curtail it, to make it more difficult for people that are here on that H1B visa if their spouse can't work. That didn't hold up in court. But you got to remember, they were challenging something. They're moving into a situation where they're going to be taking part in the rulemaking process. And that's going to change how they're approaching it and what they're trying to do. So all of that is to say, for Malutech, I don't think that the Republicans are going to be acting more left than the Canadians. I don't think that that's going to be the case at all. I think you're definitely going to see them crack down on legal immigration. It's not going to be the forefront of what gets people's attention, especially initially. Where everyone's eyes are going to be drawn is where the election seemingly was decided on in a large part, and that's the border. And the actions that are taking place at the border to curtail entry. And I think that's going to be what gets the headlines. But at the same time, it wouldn't shock me if they're able to walk and chew gum at the same time and also move forward with making those changes to legal immigration.
Right, right. Thank you so much for taking that up for Malu Tech USA, and thank you, Malu, for participating with your question.
Yeah,
But
no,
Justin,
I think it's a
yeah,
good question. I think it's also indicative of, in a lot of places, you're seeing a protectionist shift. I think you're seeing people people in countries that are moving more so towards not maybe being outright anti-immigration, but being more selective in their immigration process. I think to say that is something that's moving forward in Western countries, I think to say that it would be realistic.
Right. But yeah, coming back to Stephen Miller, I mean, talk about his first family separation, including travel ban and all that. So, what do you foresee? I mean, this could also, influence this term as well. So,
Mhm.
how's it going to be, you think, for immigrants?
So I think, I apologize. I think we have a question on him. I don't remember the name of the border czar that has been appointed, but I remember I've heard about him. Tom Homan. Thank you.
Tom, yes.
So Homan has really talked about his ability to enforce actions at the border, right? And it's a pretty when you really think about it from an immigration perspective. When you're reviewed for admission to the United States, that's a pretty big part of a process, because at that time you're being, assessed by an officer who makes a determination as to whether or not you are admissible to the United States, right? So for most people that are legal immigrants, this is a very quick part of a process. If you've been in before, you come in, you know what you're doing, you go through CBP, it's no problem, right? It wouldn't surprise me if the enforcement activities being promulgated at the border begin to bleed out into other facets of entry. And so what I mean by that is this: I've already actually seen it. I was reading about it before our discussion today. Homan has already come out and made a point about illegal immigration at the Canadian border. Basically saying, yeah, there's problems at the southern border, but what about the northern border? We have issues there too. We need to be,
Right.
we need to be more stringent in how we're reviewing people there as well. And so I think for a lot of people that are, that travel between Canada and the U.S., maybe people that are on intermittent L visas, TN visas, things of that nature, I think you're going to see a heightened level of scrutiny. I think it's going to be created initially under the guise of trying to curtail illegal immigration, but it's going to bleed into the other facets of immigration as well. And I think that that's going to be, it's going to create a difficulty where one previously hadn't existed. So I would say it's pretty imperative for people moving forward when you're getting ready to really consider traveling and how you're going to re-enter, where you're going to re-enter, what documents you're presenting when you re-enter, and being prepared for detailed questions being asked in relation to not only that, but any of your previous immigration history in the United States as well. Because, we've already seen things that are popping up under the Biden administration that have been popping up for a while now, but issues with, people who have been on their H's for years that are now being questioned about F1 employment with, companies that have been blacklisted, basically, that USCIS has now come out and basically said, if you worked with this company, if you worked with this company, then you're basically de facto fraud. Like, you've committed fraud based on the connection to the company. So I think that is something that's going to need to be very well thought out by people when they're immigrating or coming into the U.S. Looking at what is it that you could be asked about in your immigration history or about your current job or any of those things that could lead to additional questioning or additional scrutiny. Because all of that, I think, is going to be on the table. Because if you're not readily prepared, you put yourself in a bad situation. You put yourself in a situation where you're going to be questioned by an officer. You may not remember some of the facts. You may misspeak one time. That's really all it takes, is one misstatement or one slip up. And it's enough to put you in a circumstance where you could be an expedited removal and end up having your visa canceled. So I don't say all of this through the desire to fearmonger. It's not my intent to make people scared to travel. I've also seen, people online already are starting to get upset. They're saying, "Oh, my attorney's telling me if I have any travel, it needs to be done before January mid-January, because they don't want people stuck by any changes that are made. This is ludicrous. I've never done anything wrong. You have to understand that as an immigration attorney, our job is to advise. And usually when we're advising, we're trying to take the most conservative approach or strategy possible, because what we want to do is minimize risk. That's our goal. We minimize the risk that an individual has, either when they apply for something, or they go to a visa interview, or they re-enter the U.S. That's the goal. Not to make you scared, just to make you informed. And I'll put it this way: if we didn't say these things, and then in the middle of January you travel and something happens and you're stuck out of the U.S., who are you going to blame? You're going to blame us for claiming that we didn't tell you not to travel. And so that's why that's happening right now. It's really not because we want to make people fearful. It's more of we don't know exactly what's going to happen. And the best idea when that's the circumstance is to just minimize the risk as much as possible. But yeah, to just kind of button that question about Homan's leadership, the border policies, I think you're just going to see a lot more difficult issues with entry that you probably weren't dealing with in the past couple of years. I just think it's going to be a lot more scrutiny. They may bring back some of the issues that had existed beforehand, which were things like, did you do a second master's degree and do day one CPT? Did you go to some of these universities that are looked at as maybe less than compliant with F1 requirements, just things like that. And then there, obviously employer issues and stuff like that. So I just think all of that's going to be on the table.
Yes, absolutely. And talk about the borders are. We can expect a lot of difficulties for sure, as we've already spoken about. Maybe RFEs getting more and more. Maybe they would want more evidence than already required. So, stuff like that is what we have been discussing. And I think there's more to discuss on this. There's so many new picks. And well, I would just like to say thank you to Pavan also for joining us with your questions. Just stay with us. We will take up your questions. All right. And yeah, Justin, getting back to our questions, earlier I had asked about Stephen Miller also, because we have seen a lot of family separations and also, travel ban as well. So I think this is going to be a little more tough on immigration, immigrants now, right?
Yeah, and I mean, obviously, I think if you're sitting on this call and you're somebody that's on, a non-immigrant visa, you're sitting there thinking, well, what is the applicability of that to me? I'm not entering the country illegally. I'm not doing anything wrong. I'm not doing anything illegal. Okay, so that's fair. It's a fair assertion. But aside from the fact that there's a whole human rights issue regarding the family separation issues. I think it was Tom Herman, is that his name? I think Tom Herman, when he was asked about family separation, he said something along the lines of like, well, no, we're not going to separate them. We'll make sure they're deported together.
Together,
That was the solve
yes.
to the
Tom
Homan. Thanks. I'm going to see what's going to suck is I'm not going to remember his name, and then he's going to be the bane of my existence for the next 4 years. And so he's going to make sure I remember it. But yeah, I get that, okay, well, maybe it's not applicable to me, but I'll have you look at it from this perspective. From this perspective. I remember during the last Trump administration, something that they had tried to do at the outset was deny people's extensions and then say you're now unlawfully present, which means you're subject to, you can be deported basically. Yeah. And then there kind of became a quick run where we were kind of running around like, are they issuing notices to appear for these people? Are they going to be coming after them to put them in deportation proceedings? Because people need to understand this. If your status, let's say your H1B extension gets denied and you're no longer lawfully present in the U.S., you can depart. You have an opportunity where you can leave the U.S. You have a timeline where you're able to leave. And, outside of having to admit that you had a prior denial and maybe explain the denial, there's not going to be that wide reaching of a problem that comes back to bite you on that. If you were to get placed in deportation proceedings, that completely changes the game. That's a situation where if you leave without appearing in court, there's implications, and then there's implications of how long do you have to stay while everything is waiting? How do you sort things out? Can you apply again to get yourself back in status? So I do understand I do understand people being like, I don't know how that's going to affect me. It can affect you because the policies, like I've kind of been reiterating on this call, that are initially utilized for people that are illegally immigrating, they can bleed out and subsequently be used in the future against people who have come into the country legally and then lose their status because, they've had a denial or something like that. So while I'm very hopeful that that doesn't happen, because it would just really complicate our jobs even more, it's not to say that they can't utilize that. And so just thinking backwards from that, I just think that, if it does happen, it's horrible, but I hope it doesn't. But I think people should be aware that it's something that I know they have on their table. It's in their arsenal of things that they might want to do.
I mean, imagine being like the second or the third generation in the country, and suddenly, like, you and your family are having doubts if you can still be in the country or not. So,
Yeah, I mean, that all that stuff's frustrating. I mean, especially I would not be shocked for a second. During the last administration, they really cracked down on the F1 program. They did. They went a lot harder at STEM OPT than they had ever done before. It wouldn't surprise me at all if they went after that again. I think that it's something that because you got to think about it this way. If they want to curtail immigration, what's one of the easiest ways they can do that? They stop people from coming in and doing F1s and working in the U.S. on OPT and STEM OPT. If you cut that out of the process, then those people have to leave the country. And yes, they may still go into the lottery, but it's probably going to be harder for them to get sponsored because they're no longer working in the U.S. They're working overseas in their home countries. So yeah, I think that that's definitely on the table. It wouldn't shock me at all if they tried to come out with basically new enforcement mechanisms for the F1 program.
all right, let's just hope for the best and look forward. All right.
Mhm.
Well, now, Justin, let's take up Rag's question. He's here on YouTube. He's saying, "Hi, Napasa and Justin. With a flurry of cases coming in, will the attorney's efficiency be compromised, resulting in more RFE or rejections?"
So I don't know if it'd be the attorney's efficiency that creates the issue with RFEs. The issue with RFEs are you prepare a petition as best you can. You try to cut off all lines of inquiry where they reasonably exist. But if you're dealing with a circumstance where the goalposts are being moved constantly and in real time, it's going to create problems. And that's what creates the increase in RFEs. Things like changing how you look at specialty occupation or how you make that definition. Things like how you look at how someone qualifies for a position, trying to reintroduce things like, project documents or proof of specialty occupation work. Those are all the things that are, in my opinion, are going to lead to an increase in requests for evidence. That's really the big issue with it. I think that the goal is not only to just increase the probability of denials, it's to increase the time that it takes to go through the process. It's to draw this out and make it more difficult so that it becomes a circumstance where employers just don't want to deal with it. I think that's really the underlying goal. And that comes from mucking up the system by making things harder when they shouldn't be. When it comes to, rejections, rejections are circumstances where when you're filing a case, there's something missing in the case or deficient, or it's sent to the wrong location. Those are things that typically an attorney should be able to deal with, regardless of what administration is in a position of authority. Where that could become problematic, just speculating here, because we've already seen it with Biden in some regards, is just changing things. Making quick changes to forms and saying, actually, you know what? You got to use this form edition. And we're not going to backdate it, so you got to start using it as of December 1st. And the form came out on November 26th. Well, if you're a normal, business immigration attorney, you've probably got X amount of cases pipelined that have already gone through that process, went to the client for signature, and they're in line to be filed. If you don't catch those before they go out, those will be rejected. So that's definitely something that could happen. Just making constant, updates and alterations to the forms. But at the same time, if that's going to be something that they do, then it's going to become incumbent on the attorneys to make sure that they're doing their due diligence at the time of filing, to make sure that everything that goes out is correct and proper. Because that's really the only way you're going to combat it. The other thing they can do too is they can move around the mailing locations, which is annoying, but we do try to stay on top of that as much as possible. That's a lot. ALA deserves credit for that. ALA does a lot with making sure that any of those changes that happen are kind of blasted out to the attorney so that we're aware of it. But those are avenues that they could take to increase rejections.
Yes, I mean, changes and updates, these are very, very important things, and it's very important to stay updated. So, folks out there, just keep on researching and keep looking out for new changes. Because, I mean, I remember we had a lot of fee changes, and like you said, address changes, Dropbox location change, and stuff like that.
Right.
And this led to a lot of, cases becoming invalid because of the wrong fee and etc.
Right. And so that's another one too, that obviously, like when you talk about mechanisms to make the process more difficult, fees are such an easy one, you know. Fee increases are always a great way to hit the bottom line of the sponsoring petitioner. So
Hmm.
if they're able to kind of combine increasing fees with shortening validity periods, that's a win-win for them, because it puts them in a circumstance where they're really making it harder for the employer.
Right.
But yeah, that would be my answer to that, Raj. Thank you for your question. I appreciate it.
Yes, thank you so much, Rag, for participating. And if you have any more questions, we're still here. So, Justin, my next question, this is about Pete Hexet's political appointment as Defense Secretary. You know, this brings attention to his hardline stance on national security. So, do you think this could lead to increased militarization of immigration enforcement? And what might that mean for immigrants at the border?
So I will say this is actually something I've really been thinking about. Maybe not necessarily for the border, but it's something that has been crossing my mind, and that is, what is the impact on legal immigration of increased conflict abroad, whether that be in Europe or in the Middle East? You know, do we see some sort of proclamations coming out as a result of those conflicts, limiting immigration for people from those countries, or limiting immigration overall? I say that as someone who, we had a discussion before this call, for something I had just been dealing with, where it looks as if that there are people from a certain country that's engaged in a conflict right now that are basically just being denied U.S. visas under a very interesting strategy, where they're being told that they cannot overcome a presumption of immigrant intent. And by doing this, it's kind of almost become this blanket justification for a denial, where they're just saying 214B, no presumption of you have not overcome presumption of immigrant intent. Therefore, you are not able to qualify for, let's say, a B visa to the United States. My wonder is that a strategy that could potentially become weaponized moving forward as the conflicts in the Middle East increase? Hopefully they don't increase, obviously, but it's pretty hard to watch the news every day and see what's going on, and think that the next 4 years are going to be really chill, and not involve more foreign conflict. But does that conflict create an even higher inclination and desire in the United States for this protectionist nature, where you're basically saying, like, we're severing ties. We're keeping Americans in their bubble, and we'll let people in from a couple different countries, but other than that, we're just staying with what we're doing. Maybe, I don't know. We'll have to wait and see. But that's
Yes,
something I've now been worried about. I'm starting to
yes,
think
I
about,
can only imagine.
right, what is the impact specifically of what country you come from and your immigration, not even how you qualify for something, or is it a valid petition? That, I think, is going to be on the table as well.
Right, right. And I mean, we've seen a lot of cases and a lot of announcements about becoming anti Muslim and not allowing, I mean, countries with major religion as Muslim, not to allow them to come in to the country.
Right.
So, and plus, like what you were saying about the case, I mean, imagine, you being denied a visa in spite of doing everything right, having all the
Yeah,
documents
I
correct.
mean, I'll just come out and say it. It's pretty much being talked about already. I'm talking about people from Russia, just specifically.
Yes.
There's been
Yeah.
a big increase in 214B visa refusals, specifically for people from Russia. It's a blanket denial, basically, that's being issued, and I'm kind of wondering, how is this strategy employed moving forward with other countries in the event that those people from those countries, their countries embroiled in a conflict. So we'll have to see. But like you said, the so-called Muslim ban is another issue that's something that's probably going to get attention coming in day one. So we'll have to see the impact of that as well.
Right, Justin. Thank you so much for taking that up. I think we should get back to Malu because he has another question for us on YouTube asking wage levels won't get enforced for H1B. I know H1B visa employees working for $70,000 per year, whereas citizens working for client for same position has double the salary.
Yeah, so I mean, if you're asking about wage levels being enforced, the wage levels should be enforced because you have to pay a specific wage level based on where somebody's working and residing. Where they sit is what's going to dictate the amount of money that they're paid for the position, based on what kind of position that is in the labor condition application. There's really two ways that USCIS and DOL can attack and attempt to undercut wage levels. The first of which is when you apply for a position, you have to determine what the wage level is at the outset of the filing. There's 4 wage levels. Wage level 1 is entry level, experienced, quasi-managerial, high level, four across the board. USCIS has the ability to question whether or not the position qualifies for the wage level provided. They've done that pretty stringently when it comes to what's called level 1 wages. So that's the lowest wage level. Basically, that level 1 wage level is only applicable at this point to absolute entry-level positions. People just out of college with degrees that are maybe just now starting to work in their specific industry, they maybe have internship experience or something like that. But as a result of that, you can't use level 1 to go in and undercut a position that doesn't meet that standard. So that's the first way in which you're really not able to game the system as much as it could have been gamed in the past. The second issue is if the company is actually paying someone under what's in the labor condition application, that's a DOL violation, and that can be reported. So not only would I tell you, Malu, if you see this going on, not only would I say feel free to report it to the Department of Labor, tell those people that are employees, if they're being paid under the amount of money that's in the LCA, to report this to the Department of Labor, because this is a violation. And those companies should be held accountable for what they're doing, because what they're doing is illegal. So that's kind of my opinion of how you fix a system that even has like some small issues in it, rather than just kind of make this blanket proclamation that like the H1B system is bad. Understand that there are ways that you can work within the confines of the system. I will tell you this, I file H1Bs all the time. It's been very rare for me to see anybody getting paid $70K a year. I think that is a tough beat at this point to find people that are going to be getting paid around $70K. Even when you're paying on the lower end of wage levels, I think that obviously location matters. If you're in California, you're getting a very high salary. If you're in Iowa, the wage levels might be a little bit lower. So it does depend on where you're located. But that being said, yeah, I think I've done 4 or 5, maybe 6 LCAs last week. And I can't remember one of those LCAs being for $70K. I think probably the aggregate among those was close to $115 to $120. And some of those were even higher. So yeah, I mean, look, is there a notion that the H1B is utilized as a way to undercut wages in the US? I think that, yes, that's an assertion that's been made. Can you do that now in the current 2024 iteration of the H1B? I don't think so. I think it would be very, very difficult to do. And I'll do you one more, Malu. I will definitely tell you this. On top of that being reported to the DOL if someone's violating and paying under that wage level, I definitely think you're going to see a big increase in FD&S visits. I think you're going to see people coming in now. I think you're going to see more officers getting paid to do site visits all across the U.S. to go to client locations or employer locations or even home locations if they're on the LCA. And they're going to be asking those kinds of questions. Things like, what are you being paid? Seeing if that complies. All of that stuff, if it's a violation and the company is violating the conditions of the LCA, they need to be held accountable. They absolutely need to be held accountable because that should not be the underlying purpose of why someone is utilizing an H-1B.
Right. Right. Thank you so much for taking that up. And I'm sure Malu is very happy with your answer, very detailed. And thank you, Justin, for taking that up. See, he has something to say already. Many of us have been replaced by H1B visa employees. So H1B wage level need to increase to 120,000 to minimum.
Okay, well, I mean,
I
that's
hope
what you're
so.
asking. You're asking me, you're saying, do H-1Bs undercut the wage level of U.S. employers of U.S. employees? I've come back and said no, and now you're saying, well, the wage level has now gone up to 120K minimum. Well, that means that the wages are higher. So I'm sorry, I don't really know how else to answer your question. The underlying purpose was to prevent wage abuse, right? By hiring people that are paid less money to do the same job. So if that's no longer the case, then it seems that the program is being implemented in the way that the people wanted it implemented in.
They say they need to increase it to 120K minimum. So okay, I think that's what he. But yeah, thank you so much, Justin, and I hope that Malu, you have your answer to your question. But anyway, Justin, I have my next question, and I think without discussing about Elon Musk, we this wouldn't be complete. So,
Yeah.
with Elon Musk advising on government efficiency, do you think his involvement would lead to changes in how immigration processes are streamlined? Or do you think his focus will be on wasteful spending, which will result in reduced resources for immigration service?
So I would definitely say this. USCIS is fee based, meaning that the money that they get is generated by fees that come into them. So in that regard, I don't think you'd see much of a change because they're just going to basically do the same. Pardon my language, but they're going to do the same crap they always do. If they're going to say we don't have enough money, and then we need to raise fees because we need more money, and then processing will stay almost exactly the same, and we'll wonder where the money's going. But in that regard, I don't foresee it being that big of an issue. Musk, I'll be honest with you, he confuses me to a little bit because I don't really know what his long term goal is. For example, my understanding was that the Trump administration wants to get rid of electric vehicle incentives, which would seemingly be directly harmful to his own organization. And then I've also seen that, one of the agencies that they want to cut funding from is NASA, which I think, again, would negatively impact his SpaceX program.
Yes.
So I don't know if his goal is to somehow put himself in a circumstance where, like, his companies benefit from these changes, but then other people don't. I'm really not sure. Um, yeah, I mean, maybe he does want to be president. Who knows? Well, I don't know if he can be president. I don't think he was born here.
Yes, I don't
Um,
think so.
so I don't know, maybe, but I definitely think that he's enjoying the amount of sway that he has presently, uh,
Attention, yes.
because he's
Power.
in every picture, basically seated at the right hand of Trump. So yeah, I think he's enjoying that. I think him and Vivek, you know, what they're actually able to do and what they say they're going to do are probably going to be two different monsters. Because this really kind of gets back to the whole appointment issues with Trump. It's almost never a matter of just if that person's going to quit, it's a win. Eventually it's a situation where the person gets worn down and just leaves. So we'll see what he's actually able to do versus what the impact of it'll be. When it comes
True.
to like immigration, I've never really heard Musk come out and have any sort of anti-immigrant sentiment. I mean, I can definitely tell you through the grapevine that Tesla utilizes a lot of employees that are on NIV visas.
Yes.
So I definitely think that he's someone that benefits from the H1B program. So it'd be odd to see him kind of bite off his nose to spite his face or whatever the term is. But yeah, we'll have to kind of wait and see. I would be surprised if it has long-ranging impact on immigration. The things that could have an impact on immigration for him from a business immigration perspective are what are the implications of these kind of cuts to government contracts, and government projects? Because I will say that I've worked with companies that, there may be a consulting company who the third party is actually a state agency, and what is the impact of that funding that's coming from the federal level to the state level for that project? And does it mean that they cut employees or whole cloth get rid of that whole project in the first place? That's something that I think could be a problem. But but it's going to have to just be kind of wait and see. I mean, I know that they introduced a couple of policies that they want to talk about, but it's all broad strokes. There's no actual how to of it. And until that really comes forth, we're not going to have the full scope of the picture. But yeah, I mean, hopefully out of everybody, Elon's at least the only person in Trump's ear saying, hey, immigration's a good thing.
Yes. Thank you so much, Justin, for that view. Well, I have a few questions on, our Facebook groups and also our YouTube channel. So let me see if I can
Yeah,
do
I could try to do like one or two, but I am
it.
cutting time pretty closely, to be honest.
Sure, sure. So let's go with quickly. I mean, these are just comments. Maybe you can just tell us your views on these. So this was on our channel saying, so conservative Republicans support people immigrating legally, but the border has been invaded by unwanted and the poor. We cannot financially support people who never put into our tax system, but want the
Yeah,
financial benefit
I,
as a welfare recipient. Yeah.
I think the there's a pretty easy way to just say what this person's saying. Trump wants to block illegal immigration from coming in. People validly understand that undocumented immigration is a problem in the United States. The system does not operate efficiently, and it doesn't operate the way that it's supposed to. I personally will even go one step further and say when people that are immigrating to the United States come in and they're working on work visas, I think that it's a little bit ridiculous that part of the employer's job now is to throw an extra $600 into their petition, specifically to deal with issues at the border. The so-called asylum fee that has been added into these employment-based applications, I think is unfair. I don't think that it's necessarily appropriate for legal immigration for people who are sponsoring people here in valid non-immigrant statuses to have to take on the additional burden of dealing with problems that are occurring at the border. I understand that frustration. I also think that it must be incredibly frustrating for someone who has been in this country legally for 10 or 15 years that is still sitting here waiting for an opportunity to apply for a green card, be told that, the big issues in this country aren't you. The big issues in this country are people coming in from the southern border and, claiming asylum. And that's really where everyone's attention is going to lie. So I understand that anger. I get it. What I don't understand is this disconnect that seems to exist for some people that are here legally, that have immigrated here legally, this disconnect that Trump only has issues with illegal immigrants and Trump's only going to be creating enforcement activities that only goes after people that are in the country illegally. Donald Trump may believe that in his heart and soul. Stephen Miller doesn't. And Stephen Miller is the person that's going to be architecting the policies that are going to dictate the next 4 years. Yes. That's where the disconnect I see gets frustrating for me. Because I really don't want to hear people complaining when we're a year and a half into this process and legal immigration has gotten more difficult. I don't want to hear the complaints about, oh, well, I didn't think this was going to happen. We were telling you it was going to happen beforehand.
Yes.
So I don't want this head in the sand crap that is inevitably going to spew up as a result of that. So yes, to this person's point, I get it. The southern border is a mess. It needs to be addressed. Honestly, it looks like it was pretty high on the list of reasons why Trump won. And that's something that he's going to be tasked with fixing over the next 4 years. We'll see how he does. I hope he does well. I hope that we're able to create avenues that create positive results where we're able to curtail this problem and make it better. I also hope at the same time he does things that benefit legal immigration. But we will see. Is it likely? No. So yeah, that's kind of all I have to say in relation to that comment.
Thank you so much, Justin. That was really valuable. And this next one is, I hope Trump bans sanctuary cities and ban illegal immigrants from getting any benefits from America.
Okay, we're kind of we're spinning on the same wheel that we were on previously.
I hope so also.
And look, I get it. Like, there's definitely going to be a lot of showdowns that happen over the next 4 years with illegal immigration. There's going to be issues related to state government versus federal government. The enforcement of immigration by local officers, I've already seen as an issue that people are bringing up. The idea of sanctuary cities being challenged or being brought up as well. All of this, in my opinion, really comes back to this notion that all of this comes back to the notion of people who came here the right way are frustrated that people who didn't come here the right way are getting benefits. And they're getting, it's a feeling of animus that I'm trying to do things correctly. I see people not doing things correctly, but those people not doing things correctly seem to be getting more attention and a better break in terms of benefits than what I'm receiving. Okay. I hear that frustration. I understand it. All I can say is what I do professionally, and what I've done professionally over the past couple of years, dealing with this exact administration and what we're going to deal with its new iteration. You're not going to just escape the impact of immigration policy changes merely by virtue of entering the country legally. It's not going to mean, do I think that Trump's going to hunt down everyone that's on an H1B and deport them? No, of course not. That's not going to happen. But we are going to see a tougher 4 years play out than we have seen under the Biden administration. And that's just a fact. It's going to be what we deal with. And that's regardless of what they do with illegal immigration.
So true.
So if you are happy that these changes are being made in relation to illegal immigration, okay, that's great. But do understand, if you are an immigrant and you are in the United States right now, or you want to immigrate to the United States, the world that you're going to be looking at by the middle of next year is going to be very different from the world as it is what we're speaking about presently.
Mm-hmm. Right. I think, thank you so much, Justin, for that. Last but not the least, if you would just like to take up this last comment from Rag, will legal immigration get a day one surprise, or could there be a bit leeway?
I genuinely don't know. I mean, I don't think it really makes sense for them to come out and make drastic policy changes in relation to legal immigration on day one. I think they're going to want to serve the master, which is the masses in their desire to make changes at the border. So I really think that's going to be what policy A is for them, is going after making whatever changes they think are necessary. I think they're definitely going to reinstitute the Remain in Mexico program. I have heard that they are trying to institute a similar program in Canada. So that'll be interesting. Because I didn't know that there was a lot of people trying to come in through Canada to claim asylum. Usually you hear about it coming from Mexico. So I know that those are going to be things that they're probably putting in at the outset. I definitely think that, the family separation thing is going to be big. And then how they handle different policies with removals and stuff like that. That's all going to be big. That's going to be, like I said earlier in our call, that's going to be what gets the eyeballs. What's not going to get the eyeballs outside of the immediate community that handles immigration on a day-to-day basis are going to be the policy changes that they implement throughout the duration of the 4 years that they're in. Because I think obviously don't agree with the things Stephen Miller does, but have to give some level of credit where credit's due. He's had 4 years to sit on the things he did last time, and he's had an opportunity to probably make changes and corrections to things that he was not able to get done before. So you're going to see, you're going to see somebody that's coming in with plans and ideas that he's going to want to implement. But yeah, maybe day one, will there be 150 RFEs issued the day Trump takes office? No, I don't think so. I think you're probably looking at more of a slow burn.
All right. Thank you. And Rag already says, thanks to Pasa and Justin. Great updates. Thank you, Rag, for participating.
Thank you for your time. I'll try to come on next time we get together with just something more positive.
Sure.
But
Justin, it's really, yeah. But it's seriously always a pleasure to have you here. Thank you so much. Today was great. I mean, it was a great and interesting discussion about all these picks that Trump has made in his new team. So thank you so much for doing this today.
Absolutely. Thank you very much for having me. You guys have a great week. Have a great Thanksgiving. And I'm sure I'll talk to you soon.
Yes, me too. And here's wishing you and your lovely family a very happy Thanksgiving as well. Happy holidays.
Happy holidays. Bye.
Bye bye. So, folks out there, thank you so much today for joining us in this very important discussion. And it was great having you. Please don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. We are on YouTube, LinkedIn, Facebook, and also on X. So, thank you so much. And stay tuned because we have more webinars lined up. And I think in just 15 minutes, we're going to have another. So, yes, watch out. Immigration and Jobs Talk Show. It's Napasa saying bye for now. Hello, everyone. Thank you for joining us once again here on Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and it's seriously an absolute pleasure to be here once again with another very insightful webinar lined up for you. But before we move ahead with today's discussion, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you once again for joining us here on Immigration and Jobs Talk Show. And this is a great place for you to be in, especially if you want to know more about U.S. immigration and business opportunities, because we are going to dive into a topic, that has definitely sparked significant interest. So, how entrepreneurs and investors can be on the ground doing business in the U.S. in under 6 months. And yes, to help us, dive deeper into the key insights on E2 and L1 visas, we are going to be honored by the presence of none other than our guest for today, um, Mr. David R. Fulmer, an exceptional immigration attorney and a leader in his field. So, Mr. Fulmer is a partner at WR Immigration with over 2 decades of exclusive practice in immigration law. He's been recognized as Immigration Lawyer of the Year and is celebrated for his expertise in assisting companies, entrepreneurs, and even entertainers, navigate immigration challenges. So, for all our viewers, whether you are an entrepreneur, dreaming of setting up a shop in the United States or your business, or maybe an HR professional overseeing visa processes. Well, thank you so much, all you immigration enthusiasts, for being here. And without further ado, please help me welcome our guest, Attorney David Fulmer. Thank you so much for joining us.
Thank you very much for having me, Napas. I'm thrilled to be here.
Absolutely lovely. And I'm so excited because this is the first time you're here. And we would love to get to know you better. Maybe tell us more about yourself and anything else is something interesting to share if you have any.
Well, I'm lucky enough to live in Los Angeles, and it's an amazing place to live. Our offices are steps from the beach, and I also live about 5 minutes from the beach. So it's an amazing place to be. It's an amazing place to welcome immigrants from other countries, and I think it really exemplifies the best that the United States has to offer. So I'm really happy to be here.
It's an absolute pleasure to have you here. And I can only imagine what a great vibe you must be surrounded with. I mean, the beach always gives you good things, I think, the sunshine and a lot of palm maybe. But yes, I can only imagine. So thank you so much. And well, with regard to today's topic of discussion, how entrepreneurs and investors can be on ground doing business in the US in under 6 months. So, what can folks out there who have joined us or will be joining us in this session, what can they expect from us today?
Well, today we're going to talk about e-visas and L visas, and these visas really do present an opportunity for people to kind of direct their own destiny. A lot of times people think about coming to the United States on an H1B visa, which is amazing and it's great, but it requires them to find a job offer. Or they think about maybe being petitioned under EB2 or EB3, and those are amazing as well, but it requires both a job offer and a very long wait. But E2 and L1 are really opportunities where if you're from the right country, in the case of an E2, and if you have the funds and if you have a business plan, that you can actually direct your own destiny and move to the United States, bring your family to the US. It's an opportunity for people's spouses to work or for their kids to be part of the US education system, all based on their own funds, their own business plans.
Absolutely, friends. Today we are going to discuss about E2 and L1 visas, and especially all you folks out there who are businessmen and who want to maybe expand your business or go start a business. Great place to be in. So, yes, I think without further ado, I have my first question for you, David. And this is with regard to this change of administration. How might President Trump's immigration policies impact pathways for entrepreneurs and the processing of L1 and E2 visas, considering the administration's historical focus on stricter visa regulations?
That's a very good question, and the answer is not necessarily straightforward. There's two things we can look at. First of all, we can look at the prior Trump administration and what they did, and then we can look at some other issues relating to the incoming Trump administration. So first of all, looking back historically, the prior Trump administration implemented a policy called Buy American, Hire American. And the idea of that policy was that in relation to any visa or any immigration process, they wanted to make sure that issuing a visa for that individual would not hurt the wages and working opportunities for U.S. citizens. So it was always a part of, during the Trump era, we always had to demonstrate that jobs would be created. With E and L visas, that's already part of the program. So that's one thing. Next, over the last few years, a lot of U.S. consulates have been waiving in-person interviews. And what that's done is, I wouldn't expect that interviews would be waived for E and L visas, but waiving of interviews for, say, people who are getting extensions of their H1B visa has kind of opened up resources for quicker processing of other visa types like E2s. And so getting rid of interview waivers will probably cause some delays. If you'd want, I can talk a little bit about another interesting aspect of it, Napasa, which is
Sure.
Everyone knows that Donald Trump has been very close to Elon Musk. Now, Elon Musk is a business leader from Silicon Valley, and so we're also hoping that Elon Musk will have President-elect Trump's ear, and he might influence him to be a little bit kinder and gentler and a little bit more efficient when it comes to visa issuance. So on one hand, we can expect things to be stricter and slower, but we're hoping possibly that Elon Musk might have some influence and might be able to influence things in a positive way.
Absolutely. And looking at how close they are, I think he might as well. And both of them business minded. They would love to soar with regard to business. So I'm sure this is going
Absolutely.
to be good. And right, right. But yes, on the other hand, like you were saying, like stricter rules, and maybe they are going to just make the situation even harder, that they, finally drain out or give up and just go away to their own countries. Who knows?
Absolutely.
So,
I mean, I think that we will have more RFEs. Normally, when you file an L1 petition, there's always going to be a chance that you could have a request for additional evidence. During the prior Trump administration, there were a lot more requests for evidence, and so I think we can
right,
expect more requests for evidence, which will cause processing times to extend a little bit.
right, right. All right. So, folks, we have mixed things to look forward to, but I think it's always best to stay on the right path and do the right thing and keep your documents right. And there is no limit to your dreams. So keep dreaming high and work for it. Yeah. All
Absolutely.
right. At this moment, I would like to say hi to Sneha. Thank you so much for joining us here on YouTube. I can already see your comments. Stay with us. All right. We are going to address your questions a little later in this webinar. Now, moving on, David, I have the second question, and this is, for entrepreneurs looking to establish their presence in the United States, quickly, especially, they don't have time to wait or don't want to wait that long. What are the critical steps to secure an E2 or an L1 visa within 6 months? Is it possible?
It is possible. So first of all, the key point with relation to an E2 visa is um, the individual needs to be from a treaty country. And the U.S. has E2 treaties with many countries, but not every country. We have E2 treaties with about 85 countries, but we do not have them with the BRICS countries. So not Brazil, Russia, India, China, or South Africa. But if you are from an E2 country, then the E2 is a possibility. Otherwise, you have to go through an L1 visa, which has additional requirements. So if you're from an E2 treaty country, the first thing you'll need to do is really set up a business plan, decide what type of business you would like to be in the United States. Then you'll have to set up an entity in the United States. You have to set up a corporation or an LLC, register it with the Secretary of State in that state, get a tax ID number, set up a bank account, and then you can fund the company, and that's really the first step.
All right. Thank you so much. Thank you so much, David. I think that makes us hopeful at least. And maybe, are there any tips or maybe additional things that folks can keep in mind when they are in a hurry to be out there in the US?
Well, I think it's good to be in a hurry, but more importantly, to be in a hurry is to make sure that they're in a business that's going to be successful in the United States. So first of all, I recommend that they look at themselves, look at their history, look at what they're good at, and look where they could be competitive in the United States, because the business environment in the US is very competitive. And so rather than being in a rush, I think people should analyze where they think they can have an impact, where they can be successful in the United States. Once they've done that, yes, then they need to connect with advisors in the US, both an immigration attorney, a business attorney, to set up the US entity. And then another key thing is to find a general manager in the US that can kind of help them be feet on the ground, because there's a lot of things that they may not be able to do from overseas before they obtain the visa. And even if they come to the United States, they wouldn't be allowed to work until they obtain the visa. So hiring a general manager to be really feet on the ground will also be very, very key thing to help them to be able to move this ahead quickly.
Right. Thank you so much. Thank you so much, David, for, walking us through and giving us tips on how to quickly, get yourself ready for an E1 or an L1, for an E2 or an L1. Thank you. Thank you. So now moving on to my next question is, how can, a startup entrepreneur from a treaty country, demonstrate a substantial and non-marginal investment for an E2 visa while meeting current USCIS standards?
Definitely. So really, that's two questions. There are several requirements to obtain an E2 visa. One is the investment needs to be substantial, and then the regulations say that the business cannot be marginal, which is
Mhm.
kind of a strange word. What does marginal mean? Well, they go on to explain that a marginal business is a business that only generates enough revenue to support the investor and his own family. And so the rule says the business cannot be marginal, which means that it needs to be successful enough and generate enough revenue to hire US workers. So, really, what it should have said is the business will support US workers. And so I believe that goes back really to the business plan. The government needs to be able to review the business plan and see that the businessman makes sense, business plan makes sense, see that it's logical and believable that the company will be able to generate revenue so that it can employ US workers. So that's marginality. You asked me about substantiality. The regulations also say that the investment needs to be substantial. And I have my clients all the time ask me, David, how much is substantial? And I wish that the government would tell us exactly what they want. In another context, in the EB5 program, the law specifically says 800,000 or 1,050,000. But in the E2 context, the rules only say substantial. So what is substantial? It really goes back to the same thing that I said relating to marginality. And the investment needs to be enough so that the government believes that the business will be successful and generate revenue both to support the investor and the US workers. However, I think there are some limits to what is substantial. Sometimes have people asking me, David, can I apply for a visa with a $20,000 investment or $50,000 investment? Lately, I haven't seen E2s being issued with under $100,000 investment, and I'm often seeing people investing, around 200,000. Again, the law doesn't say, doesn't give a specific amount, but usually lately I'm seeing people investing at least a couple $100,000.
Right, David. And that's a lot. I mean, for folks out there who were just expecting to start something within 20, I mean, they have to go 5 times more. So
Well,
there
that's
you go.
I
And
think we're gonna get
yes,
to that
yes,
later, I believe. But sometimes if somebody doesn't have that type of funding, then an L1 visa would probably be a better route.
right. So we're getting to that. Thank you, David. Thank you for, telling us about USCIS standards and the E2 visa bit. And also, Vikas has joined with a few questions. Vikas, please stay with us. We are going to address your questions a little later, but thank you so much for joining. And now, moving on, David, what are the key industries or business models that are currently seeing faster approvals for E2 and L1 visa applications?
So what I can't tell you is what models are being approved or being approved more quickly because it's really wide open. What I can tell you is models that won't work. And models that won't work are the passive businesses. I have a lot of people telling me, David, I want to buy a house. I live close to Malibu. I want to buy a house in Malibu. It's going to cost $10 million. That's a substantial investment. Can I get a visa with that? The answer is no.
Mhm.
It is an investment. It is substantial, but it's not going to meet the marginality requirement. It's not a business at all. It's not going to generate income for anyone. I have other people asking me if they can be passive investors in minority interests in companies. So, can they be essentially investors and get visas? And the answer is also generally no, because that is not an active business that generates employment for U.S. workers. So, what we're looking for is active businesses. Some common ones are restaurants. Restaurants require a lot of human capital and require a lot of funding. So that's a very common business. But I've seen people obtain visas from almost every industry. It simply has to be an active business and not a passive investment.
Okay. Okay. Thank you so much for telling us about that as well. And anything important about USCIS standards to keep in mind? Maybe something when people out there are trying to fit themselves with an E2 or L1? Anything else to keep in mind?
There are a lot of things to keep in mind. The focus really is on will the business support the U.S. workers? That's a
Right.
very key point to always keep in mind. A lot of people think, yeah, they can invest and get to the U.S. and kind of figure it out from there. But when they invest, they need to, when they apply for the visa, they need to submit a pretty detailed business plan. And the
Yes.
business plan needs to spell out, their business model, how they think they're going to be able to generate business, what they're going to do in the U.S., and how they're going to, generate enough revenue to create and maintain U.S. jobs. So I think that's a really key point, and it's going to be more
Right.
important during the Trump administration.
Right. So the question is it going to benefit the United States? And that's what you
Absolutely,
should keep in mind.
absolutely. I mean, I know that it will benefit the foreign investor, but what does the U.S. government care about? How it's
Exactly.
going to
Yes.
benefit the U.S. They want to see that those funds have been put into the U.S. economy and spent. So it's not just that they take that 100 or 200,000 and put it in their U.S. business bank account. They want to see that most of that has been utilized and spent and pushed out into the U.S. economy, and that U.S. workers are going to be hired. So it's a win-win. The foreign investor will be able to live in the U.S. Their spouse will be
Right.
able to work. Kids will be able to go to school. They'll be able to do business in the U.S. And the U.S. will benefit quite a bit from each E2
Exactly.
or L1 that comes into the U.S.
Absolutely. Thank you, David. Thank you so much for the detailed explanation. And now moving on, if a new entrepreneur already has an operating business abroad, what documentation is critical to establish the connection needed for an L1A visa?
Absolutely. So if they already have a business operating abroad, that's a huge head start, and so they will be able to obtain what we call a new office L1. But before they can apply, they need to set up their U.S. Entity, and the U.S. entity has to have a qualifying relationship with the foreign business. So that can mean that the U.S. business is a wholly owned subsidiary of the foreign business, that it's a sister company of a common parent, that it's at least a 51% subsidiary, or that the U.S. business has the exact same ownership in the same percentages as the foreign business. So we call this a qualifying relationship, and this is a very, very key initial issue that needs to be addressed each time.
All right, David. Thank you so much for that and for the detailed explanation. I think now we should move ahead to our next question, and that is, what factors should an entrepreneur consider when selecting the US location for their new business under an E2 visa?
Absolutely. So a lot of people just want to do business in the United States. Other people understand that the US is a very large, very diverse country with really 50 different jurisdictions inside of it. Each of the US states have their own cultures, their own laws, and they even have their own taxation systems. So before they set up business in the US, I believe that people should talk to a tax advisor to determine if one state will be better than another. I have a lot of people that want to do business in, say, Florida or Texas because there is no state income tax. I have other people that don't really care about taxation. They want to be by the beach. And so they're going to live in Los Angeles or Florida, some even in Hawaii. And so really it's a personal decision taking into consideration the business climate, taxation, and personal preferences.
All right, David. Thank you so much for, getting us through, for establishing a good connection that is required for an L1A visa. Now, moving on, I have another question, and that is about E2 visas. So, how can small businesses, now, especially after the pandemic, I think we see a lot of new businesses coming up. I think during that time, almost every household, or many households, they started their new businesses from home, online and everything. So, I think that trend is still on. And nowadays, I mean, everybody shopping online. I think it's become a very big thing, startup businesses and everything. So, how can small businesses, and first time investors overcome the common challenges of proving their business viability for an E2 visa?
That's a very good question. You talked about people doing business, kind of side gigs from home. The new E2, the Foreign Affairs Manual relating to E2 visas says that an E2 visa can't operate out of a home office. But how can they do a good job of establishing that they are a viable business? I believe number one, even though the regulations say they can have a home office, they need to have physical presence. Next, a lot of businesses nowadays are service businesses. I mean, even me as a lawyer, this is service industry. It doesn't take a lot of capital to set up a law practice. It takes a computer and a good connection to the internet. And many other businesses are like that. They don't require much capital investment. But to be a good E2 business, in order to obtain a visa, it has to be the kind of business that does require capital investment. So it has to be the type of business that requires an office or a plant or a facility and inventory. So these are some key points. That physical space, and it has to require that investment. And it has to be invested in the right
Okay.
thing. Yeah.
Okay. No, you were saying you can continue.
Okay. Yes. I was contacted by some people from Canada, and they had invested about 100,000, and they wanted to open up a business where they were going to set up Airbnbs. And it sounded good because I know in order to set up Airbnbs, they have to either purchase or lease a property. They have to outfit it with furniture and technology. And so I thought it could be good. When I looked at what they put their money into, they put their first 50,000 into courses on how to be successful in the Airbnb industry. And while those might be tax deductible according to the IRS, I didn't believe that those would be considered to be proper investments for the E2 visa. So the investment has to go into the right area.
Right. And well, when you say right area, like that has to still benefit US and only then they can be considered, right? So if in case they do not benefit the US or, there is like a chance that the US does not need this kind of business. I mean, there are chances that they can never start that business, right?
Well, so first of all, you ask, what if the investment does not benefit the U.S.? So I've seen some scenarios where somebody sets up a business, so they make an investment, they set up a storefront, and they purchase supplies and equipment, but then they purchase the inventory from a foreign country. And I'm asked, well, does that purchase count as part of the investment? It does, but I believe that it might not get full credit. I believe that the U.S. government will probably favor purchases that come from the United States, especially under the Trump administration, where we're going to have the Buy American, Hire American policies. And so, yes, if the government, if the U.S. consulate does not believe that the investment is substantial, and this is, again, the numeric number is not set in stone. They don't feel like it's enough. If they don't like it, they can deny it. They have a lot of discretion to deny the visa application.
All right, David, thank you so much for, walking us through, I mean, L1A visa and how important is it, for an entrepreneur to prove that they are going to benefit the US and, of course, that they are doing the right kind of business and maybe they are very innovative. So, yes, thank you so much. And now, moving on, I have
quick point. Oh,
sorry. Sorry, yes, David, please say.
if it's okay, one other quick point. The business that they're in the United States needs to be legal according to U.S. federal law. And I've seen a few people from countries like Canada operating in an area that's technically legal in some other countries and legal according to some states, but not legal according to U.S. federal law. What I'm talking about is anything related to cannabis or marijuana. In California, according to state law, it's generally legal to purchase and if you have the right licenses to sell. But according to U.S. federal law, it's not legal. So people, if they want to obtain a U.S. visa, they should stay 100% away from any industry that has the taint of being connected to something that's illegal, even according to U.S. federal law.
Right, very important thing to keep in mind. So, folks, I mean, thank you so much, David, for highlighting that. And folks out there, that's a very, very important thing. So, Vikas, thank you so much for more questions. We are going to come to that. But I think at this moment, it's time for a short break. So, folks out there, you can also have a one on one discussion if you're loving David's ideas, advices, and knowledge. And maybe you want to consult him with regard to your case. Why not contact him as well? You can call him on his number, and his phone number is 310-570-4065. And you can even email him dfulmer at wolfsdorf.com. DFULLMER at WOLFSDORF.com. And yes, go visit www.wolfsdorf.com. Don't go anywhere. Stay tuned to Immigration and Jobs Talk Show. Well, I'm Napasa Pradhan with none other than attorney David Fulmer. Hello and welcome back, everyone, to Immigration and Jobs Talk Show. This is the second half of the webinar we are having, and I'm Napasa Pradhan with today's guest, none other than attorney David Fulmer. Yes, he is an amazing immigration attorney who is based out of Los Angeles, and it's such a great honor and a pleasure to have you here with us. Today, we're discussing about how entrepreneurs and investors can be on the ground doing business in the US in under 6 months. So it's been a great discussion so far, and we have a lot more questions to cover. And also, folks out there who have questions for us, Vikas and Sneha, we are going to take up your questions. And I would also like to ask you folks to also join us in this conversation. You can participate by asking your questions in the comment section wherever you've joined us from. We are streaming live on YouTube, LinkedIn, Facebook, and X. And yes, David, it's been a great discussion so far. Thank you so much for doing this.
Thank you for having me. It's been a lot of fun.
Thank you. So I have another question, and that is what are the primary differences between E2 and L1 visas that we are discussing today? Both for entrepreneurs, and how should one decide the best fit based on their business goals?
Absolutely. So first of all, the first thing to look at is whether or not an individual is from a treaty country. So if they're from a treaty country, then both possibilities are on the table. But if they're not from a treaty country, then the E2 can be dismissed. Secondarily, the the business needs to be majority owned by individuals from the treaty country. So if we have a transferee from a treaty country, but the business is majority owned by his partners who are from another country, that's not going to work. So first we look at the treaty country. If the individual is from a treaty country, then E and L are both on the table. Next thing we would look at is whether or not the investment is substantial. As I mentioned before, E2 does require a larger investment. And so if the investors were thinking that they were going to set up a business with a lower amount, let's say $40,000, $50,000, then they would definitely, they should definitely go toward an L1 instead of an E2. Now, if the investment is substantial and they're from a treaty country, then which is better, E or L? There's some factors to consider. First of all, for a new office L1, they're only going to get a 1-year visa, where with an E2, depending on where they're from, they might get a visa that's valid for up to 5 years. And so if they're looking at saving costs and kind of getting it done and not having to worry about it in the future, then perhaps an E2 is better than an L1. However, with an L1, the L1 new office rules do allow them to apply essentially based on a business plan. And so theoretically, maybe it's a little bit less work in the business setup to obtain an L1 than it is to obtain an E2. Now, the other big difference is that an L1 visa is a dual intent visa, where an E2 is not technically a dual intent visa. That means that when you obtain an L1, you can have the plan and intention to obtain permanent residency in the United States. Where with an E2, you need to have the plan to depart from the United States once you're done doing business in the United States. That's a big difference. Finally, an L1 visa allows for an opportunity for applying for immigration or green card under the EB1C category, where E2 does not necessarily present that opportunity. So these are some factors to consider when you're trying to determine which is better, E2 or L1.
Thank you so much for highlighting the differences, David. And I'm sure, folks out there who are in a dilemma where to categorize themselves, they have a clearer picture now. Thank you so much. And moving on, now I have another question, and that is, if an entrepreneur's visa is tied to a new business that faces unforeseen challenges or restructuring, what options do they have to maintain compliance and their immigration status?
That's a good question. And this comes up a lot because plans are great. But once they obtain the visa and arrive in the United States, sometimes business does not go according to plan. In fact, maybe it never goes exactly according to plan. But what happens if, they get to the United States on their E or L visa and it's really slow. It's hard to get customers. And so first of all, on an E2 visa, if they obtain a 5-year E2 visa, they do have a little bit longer to turn the business around. Maybe they can't maintain all of the employees throughout the whole 5-year period, but they need to make sure that they have been able to turn the business around by the time it's time to renew the visa. And secondarily, they cannot close the business. So let's say that somebody has an E2 visa and it's tough and they can't maintain all of their employees. If it's a retail store and they close the store and they're no longer in business, then they're no longer in status. So they need to keep on trying. Sometimes that means investing more capital. It might mean changing the business model slightly. It might even mean changing the location slightly. But they need to stay in business, to stay in status and stay in compliance in the United States. If somebody gets a new office L1, they only get a 1-year visa. And so the pressure is on to be successful and to step up within the first year. And if business is tough, if the contracts aren't coming and the money isn't flowing in, they do have the option again to invest more money to maintain the business and to be able to get that extension after the first year.
Okay. Thank you, David. Thank you so much for, walking us through. And now moving on, I have this next question, which frequently comes in mind, and we find them a lot in our groups also. And, folks out there have this question. So how can entrepreneur, transitioning from a visitor visa to an E2 visa ensure that they meet the strict timeline requirements for operating the business in the US?
That's a good question. So first of all, I would hope that if someone is entering the US as a visitor with the plan of obtaining an E2, that they enter on B1 instead of B2. Because usually when people obtain a B visa, it's B1/B2. So if they enter the US on a B1, then they're going to have 6 months to either depart from the US, or technically they may be even able to file the change of status in the US from B1 to E2 status. So if they know what they're doing, and if they have 6 months, that should generally be long enough to go through the steps of, again, setting up the entity, registering with the Secretary of State, getting a tax ID number, opening a bank account, transferring the funds, and then setting up shop. So if they know what they're doing, 6 months is long enough. If they have no idea, then it's going to be more difficult. If someone has no idea what they're going to do, they should probably look into a franchise, because a franchise will kind of have the business plan spelled out. So they should probably talk to a franchise broker and see if there's an opportunity that they're interested in an area that they're interested in, and that's within their budget. And then a franchise should offer a way for them to be able to kind of roll forward pretty quickly, even if they don't know quite what they want to do.
Okay. All right. Thank you so much, David, for that advice and tip, I would say. So now moving on, I have this next question, and that is, for investors planning to use an L1 visa to expand their company into the US. So what strategies can help them build a stronger case for a new office, for a new office petition while ensuring the timely approval?
Absolutely. So first of all, it's really important to look at the foreign business and the person's role within the business to make sure that they're going to be able to be categorized as a manager. So, the L1A visa is the visa for foreign executives or managers that are transferring into the United States to be managers or executives in the United States. It's very important to kind of look at the position abroad first before you launch the case into the United States. So is the person a manager? A manager has 3 subcategories. It can be an executive in a large company, a C-suite executive. It can be somebody who is what's called a personnel manager, who manages 2 levels of staff beneath them, or it can be a function manager who doesn't necessarily have direct reports, but who manages a very essential function of the business through indirect reports. So first of all, do they qualify based on their current position? And that's really the first step before even thinking about launching that business in the US. If they don't qualify, they need a year of qualifying time. Maybe they should adjust their position and wait 1 year so that they qualify, and so they will not have any problems when they launch the business in the United States.
All right. All right. Thank you so much, David. I think that would really help all of us, and it has definitely given us a clearer picture on how to go about either E2 or L1, or where can they actually fit themselves in. And I think now we should definitely go address these questions we have from our viewers. And I will take up Sneha, our first viewer, and her questions. So she says, I've already set up a business in my home country, but I want to expand to the US. How quickly can I establish a US branch under the L1 visa? And what steps should I prioritize to ensure a smooth application?
So first of all, again, it's great that she has her business set up overseas. That's excellent. The question is there enough going on in that business to support an L1 visa? So, it's going to have a number of employees in order for her to be deemed to be a manager. So in an ideal world, I'd like to see it have 10 or 12 employees at least, and a structure that's with a hierarchy where she's at the top, there are mid-level managers beneath her, and then the workers below her. That would be what's called a personnel manager. So before she thinks about setting up in the U.S., make sure she's built up her foreign business. Also, the foreign business needs to be strong enough that when she transfers to the U.S., it continues to be in business. Because if she gets the L1 visa and the business outside of the United States, winds down, then the L1 visa is no longer valid. So it needs to be really built up and strong enough to be able to support the transfer. Next, the procedure of setting up the entity in the U.S. is really quite easy. But the first thing she should do is talk to tax advisors and see if they have any suggestions on the structure and the location. There are a couple of ways it can be done. It can be done as a subsidiary of the foreign business, as a sister company of a common parent, or the shares could even be owned by her individually, as long as the foreign business and the U.S. business are owned by the same shareholders in the same percentages. So strengthen the foreign business, get tax advice, and then get an attorney to help you set up the U.S. entity.
There you go. It's always best to have a U.S. attorney, to help you navigate or, guide you through any of your visas, because they are the experts and they know that each case is different and every case is special and every case needs special attention. So, yes, thank you so much, David, for taking that up for Sneha. And, I would like to share my screen now because we have more questions in our groups. So, I think I'd like to take them up first before we take up Vikas' question. So, let's take this one. This is from an anonymous participant asking, my L1B petition was approved on 15th of August in premium processing. Still, I have been waiting for the approval petition, and my company visa team is saying they are yet to receive the petition documents from attorney. Usually, how long does it take to receive the approved petition? That's the question.
So the question says that the application was filed through premium processing. And so when something is approved through premium processing, generally the attorney who filed the petition will receive the approved I-797 within about a week. And if it's not received within about a week, then the attorney or the petitioner should contact USCIS. Because premium processing was utilized, there's a little bit more customer service. And so the attorney or the petitioner can email premium processing to tell them they have not received the approved I-797. It should not take long. If it was approved in August, here we are in November, that's a problem. And that should be aggressively followed up on because there's no reason for that to happen these days.
Right. That means that is not a good scene. But thank you so much, David, for taking that up and for the answer. Now I have this next one. This is also from an anonymous participant asking, when looking at the wait times of interview waiver for L1 visa, it doesn't give any information on wait times. It's just blank. Also, when looking for an appointment for Dropbox for L1, it doesn't show any slots. Are there any changes to the process for L1 visa renewal stamping? Also, did anyone get it done in Mexico instead?
Okay, so we have a few questions here. First of all, I think they're asking about interview times for an L1 under visa wait time. So the Department of State has a web page that's called Visa Wait Times. So you can Google it, you can find it. It says Visa Wait Times. You type in the city, and it will tell you the common wait times for each different type of visa. And for some, and from consulates in some categories, it'll tell you the waiting time for interviews and interview waivers. So if it doesn't list it for interview waivers, sometimes what we have to do is kind of analogize it. So if it doesn't say L1 interview waivers, perhaps you can look and see what it is for H1 interview waivers and get a general idea of what it's going to be. Natasha, can you bring it up on the screen so I can see the rest of the question?
Sure.
When looking for an appointment, Dropbox L1 doesn't show any slots. It could be that they're not allowing for Dropbox appointments for L1s. If it's not showing any slots, or you may have to email the consulate and see if they'll respond to you about that. Processing in Mexico. So processing in third countries may be a possibility. I can't say I have done too many in Mexico lately, but it may be a possibility. What you want to make sure is if you're processing in a third country, you have a visa to get into that third country. That can be an issue sometimes.
Right.
And you may want to contact the consulate to make sure that they're open to processing the visa there if it's a third country.
All right. Thank you, David. Thank you so much for that insight, and that was really helpful, I'm sure. Now, moving on, I have this next one. This is from Naluri asking, is it okay to apply L1A extension in premium now? Bunch of thanks in advance for your response here.
There's no reason to not apply for an L1 under premium processing right now. It's available, and generally these days people utilize premium processing whenever it is available. Sometimes there are strategic reasons when you won't want to, but in most cases people are utilizing premium processing on any category that's available, and I don't see a problem with it in general.
All right. Thank you so much, David, for taking that up. Now, I have another question, and this is also from another Facebook group from an anonymous participant. What are supporting documents required for converting L1B to L1A category?
Okay, so that's a good question. L1B is for someone with specialized knowledge. L1A is for a manager, and so the assumption is that you were probably in your home country were working in specialized knowledge. When you transferred to the U.S., you were working specialized knowledge, and now you've been promoted into a manager, or you will be promoted into a managerial category. And so you'll have to prove that the employer does have a position for you that fits the managerial category. And so what does that mean? Usually you're going to have a detailed job description. You'll have to have an organizational chart to show the people that are going to report to you. And you usually have to demonstrate what titles and what duties those people have so the government can see that you really are turning into a people manager from a specialist.
All right. Very interesting. Thank you so much for taking that up, David. And um, thank you, anonymous participant, for the question. Well, I have another one. This is also from another group. Another anonymous participant asking, has anyone recently got their L1A extension stamped in Canada? Please share your experience. We don't want to travel all the way to India. So this person is from India originally.
Absolutely. Canada and Mexico technically have jurisdiction over people who are physically present in the United States. And so it is theoretically possible. I'm not saying it happening a lot these days, but it is possible. Obviously, it's a shorter trip. A lot of people still want to go back home because if they stay in Canada, they're going to probably get a visa to get into Canada. They're going to have to stay in a hotel for a week or 10 days. And there's usually a longer wait time if you're applying in a third country. So people from Canada will have priority over people who are third country nationals. So even though it's theoretically possible, a lot of people would rather go back to their home country.
Oh, that's very, very interesting, really. Maybe could you tell us more about it?
Well, yeah. So, if someone's on assignment in the United States from India, they're away from their parents, their siblings, and a lot of times there's a need to kind of go back and see family. So if they go back home to India, they're going to be able to see all of their family, kind of check that box off, and they're probably going to be able to stay with their family for free. But if they're applying in a third country, again, they're going to have all the expense of a trip, and they're not going to be able to see family. So a lot of times people prefer going back home instead of and kind of making it into the annual family visit while they're getting visa stamped, as opposed to doing it in a third country.
Right, right. Very interesting. Thank you so much, David, for taking that up. And moving on, I have more questions. So let's take this one out. Another anonymous participant is asking, hi everyone, I'm heading to India for my L1 blanket visa stamping and currently see Chennai as the only available option for scheduling. Has anyone managed to book appointments at other consulates recently? Also, is it possible to schedule both for OFC and consular appointments on the same day since I see that option in the portal? Thanks in advance for your help.
So I can't say I have all of the information on exactly what the appointment booking is in India.
Yes.
Um,
But I
yeah, so
think we
maybe
didn't speak about the blanket visas, no? L1 blanket. So maybe if you have anything to say or especially highlight the important points about blanket petitions, it would be
absolutely.
great.
Yeah, I mean, blanket petitions are an excellent tool. Employers should definitely obtain a blanket if they qualify, because they don't have to submit every single application to the U.S.CIS. Instead, they
Mhm.
can apply directly at the U.S. consulate. However, at the U.S. consulate, there will be a little bit more adjudication, and the standard for adjudication of an L1 blanket at a consulate is a little bit higher than it is at the U.S.CIS. And so you want to make sure you have a very strong case if you're utilizing the blanket.
All right, that's very important. Thank you so much, David, for taking that question up and also telling us about blanket petitions. Now, moving on, I have another question, and this is from another anonymous participant asking, hello, this one we've taken actually, right? We just took it. I think that's it. Okay, this is one last one. Hi guys, I need help. My husband's L1 extension petition and my L2 extension I-539 have been filed together on October 2024, while L1A extension is filed in premium processing, mine is not. So it's still under process. My I-94 is expiring on December 20th this year, but I have a valid stamped visa till 2027. My husband received his approval notice. My questions are, if I travel outside the USA, will my I-539 be abandoned given it's the extension of the same visa category? Let's
So
take
the
this one
answer to
first.
that is yes. The I-539 is abandoned when you depart from the U.S.
Okay. And the second question is, can I re-enter USA with my husband's L1 approval notice and current visa?
Yes, you should be able to. Um, you have a visa, you have your husband's L1 approval notice, he's still employed, you're still married. There shouldn't be a problem with that.
All right. Now, the third question is, if my I-539 is abandoned, do I need to apply for extension again with USCIS?
No, you do not. You will be admitted on a new I-94, so you do not need to file a new
Extension.
I-539.
All right. I think the last question is, I heard about flag polling where I get my I-94 extension using my husband's L1 approval. That's right. Will it
Correct.
affect my I-539 if I cross border to extend my I-94 based on my husband's approval notice?
So I think that's really a combination of questions 1 and 2 and 3. And so, yes,
Right.
I-539 will be abandoned, but yes, they should be admitted on a new I-94.
All right. All right. Thank you so much, David. I think with that, we have covered most of the questions from our groups. And well, we have another live audience who has joined us on YouTube. This is from Rajesh. Hi, Rajesh. Thank you for joining us. He's saying, I am a Canadian and would like to know if I can apply for E2 visa based on my rental properties in USA and start a rental and property management business. Does this business apply under E2?
Yes, it could. So while just owning one rental property probably would not qualify, if someone had a number of rental properties and perhaps contracts with other companies to manage their properties, and if that business, again, meets the other requirements, substantial investment, if it had employees, so it met the marginality requirement, absolutely, this could be a valid E2 business.
Okay, there you go, Rajesh. I think that's good news for you. All the best. Now, let's take up Vikas. I'm so sorry, Vikas. I kept you waiting for so long, but here we are now. Let's take up your questions. He has a series of questions actually. So Vikas is saying, if I already have a tourist visa and want to explore potential business opportunities before applying for the E2 or L1 visa, are there restrictions I should know to avoid complications during my transition? Let's take this one first.
Absolutely. So number one, as I mentioned, they should enter on B1. So when they get to the airport, they'll be asked business or pleasure. They should say business. And if the government, if the customs officer asks them what kind of business, they can be honest and say, I'm thinking about applying for an E2 or L1 visa. I'm here to explore the opportunities. Next, if they get here and if they find the right business opportunity, they can do things like meet with a lawyer, meet with a corporate lawyer, meet with an accountant. They can do business meetings in relation to setting up the business, but they cannot work in the business. So once they've set up the company, if they want to do a soft launch before they obtain the visa, which is a good idea, they need to hire a general manager to perform the day-to-day management until they obtain their visa. Getting that first key employee to manage is very important in obtaining the visa. It also keeps them in compliance because it shows that they're not working illegally in the United States.
Right, right. Thank you. Thank you for taking that up. And he has more questions, so let's address them. If I apply for an L1 visa as an executive, how do I prove my role in my current company and show that my position in the US branch is necessary? And can you give examples of supporting documents that work best?
So it's really two questions. So first he's asking, how do we prove the position in the US is necessary? The government is generally not going to ask you to prove that it's necessary. If the company wants to launch an office in the US, obviously it has to have a genuine, profit motive. And if you have a business plan that shows that it will be profitable, that's all you have to prove. You don't have to prove that it's necessary, only that it appears that it'll be profitable and that it will be able to sustain business in the United States. So the next question you ask is examples of documents. Can you read the question again, Nipasa?
Can you give examples of supporting documents that work best?
Mm-hmm. Well, again, I think that the question might not be accurate, but the main supporting document to show that the business in the U.S. will be, again, generate profit will be a business plan. So that's the key document. It should be pretty detailed. And in the business plan, there'll be sections that will spell out, who the principals of the business are, who are the founders, what history they have, what plans they have in the United States. That's where you really make the sale to the U.S. government that this business will be successful, will be sustainable, will hire U.S. workers.
All right. Thank you for taking that up for Vikas. And Vikas, I think we've covered all of your questions. But if you still have any more further questions, you can keep commenting. And now let's take up Ganesh's question. So, what are the most effective and cost effective visa options for entrepreneurs and investors seeking to establish a business presence in the US within a short time frame under 6 months? And what are the key requirements? I think we've covered this in this
I think
entire.
that's the whole topic, right? But I think the
Exactly.
answer is this. There in the U.S. there are two investor visas. First, we have EB5, which is an excellent program. It requires a minimum of $800,000 investment, and if somebody's not already in the United States, it's going to take them a number of years to get to the United States on the EB5 program. So the cost-effective option is the E2 because it does not necessarily require 800,000. It could be 100, 150, 200,000. So that is the answer. It's E2, which is the topic of our discussion today.
Absolutely. And I think with that, it also helps us wrap up a bit and probably summarize rather in a nutshell this whole topic for today. But before we go, David, I would really like to say thank you first. But also, if you could, end this session with an end note and maybe some key pointers to keep in mind so that you can leave folks out there with some bullet minds they can think about as they leave this session.
Absolutely. Thank you very much for having me. I think that the key point is that you don't have to beg a friend for a favor or for a job in the United States. Sometimes it's very hard to search for jobs from overseas. So if you have the funds or if you have a business, then you can kind of you can direct your own fate. You can make a plan to be able to move you and your family to the United States within a reasonable amount of time using either an E2 or an L1 visa. And it's not going to cost 800,000 like the EB5 program would. Now, if you have the 800,000, EB5 is definitely a wonderful route. And if you're in the United States already as a foreign student or on an H1B visa, and EB5 is a great route. But if you're not, then you might want to look at an E2 or L1 as a way to move you and your family to the United States within a reasonable amount of time.
Wow. Absolutely. Thank you so much, David. And I wish we had a lot of audience. I mean, live audience, I would say, like, please give a round of applause for our guest today, none other than David, our filmer, who joined us from WR Immigration as a, and also like folks, to add to how incredible David is. Well, he's a top rated immigration lawyer and the past immigration section chair of the LA County Bar. So he was selected for inclusion in 2023 edition of the Best Lawyers in America, and in 2021 he was recognized as Best Lawyers Immigration Lawyer of the Year in Los Angeles. So I think that is a very great achievement, and thank you so much, David, for joining us and for sharing your very I mean, your time with us and all this knowledge that you could impart in this session. I'm really looking forward to have you join us again very soon.
Thank you very much.
And here's wishing you a very, very happy Thanksgiving, happy holidays to you and your family out there. Thank you so much for joining us. All right, so friends, thank you so much for joining us in this session. It was really great. Do not forget to check out David Fulmer and contact him if you want to have a one-on-one consultation, and also visit his website and send him an email. Yes, and these are his contact details. You can call him in this number 310-570-4065. You can also email David. I think it would be best to email. So note down this email address, dfulmer@wolfsdorf.com, and go visit www.wolfsdorf.com. Thank you for joining us today. You can also email me, by the way. You can contact me if you have any questions with regard to immigration or jobs in the United States. And my number is 408-335-6444. You can email me, nipa@staffingly.com. And I have another great news, and that is Monday to Friday, 4 p.m. Eastern Time. Me and my co-host, Sam, we join you with daily immigration dose here on Immigration and Jobs Talk Show. So I would like to say, please join us there in less than an hour. And until then, of course, don't forget to like, share, and subscribe to our channel. And also hit that bell icon so that whenever we have discussions and webinars like these, you are notified and you can join us. Thank you so much once again. Here's wishing you a good day ahead. Bye bye.
And welcome to Immigration and Jobs Talk Show. I'm your host Sam, and before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice, so use of information is at your own risk. All right, once again, guys, welcome to Immigration and Jobs Talk Show. And today, our topic is ready to start your American dream. Which immigration options are right for you? So, folks, millions of people around the world are actually dreaming of making their way to America. And for many, that dream is actually stuck, not because of the confusion or fear of the process, but also not knowing where to start. But you know what? It actually doesn't have to be that way. In fact, you just have to discover the right immigration options that are easier, clearer, and obviously more accessible than you think. So, today we are here to change the way you see your American dream and guide you through the process step by step, making it all less daunting. And to help you navigate through these choices and find the best for your dream, we have a very, very special guest with us today, joining us for the very first time, one of the best immigration attorney in America, Karen Lee Polak. Karen Lee Polak is the managing attorney of Polak P. LLC, an award-winning immigration boutique with offices in Dallas, Texas, and Florida. Polak PLLC provides full service legal immigration counsel to large corporations, small businesses, families, and individuals too. So, welcome, Karen, to Immigration and Jobs Talk Show. It's truly a pleasure having you with us today. And obviously, an honor to have you. So, how are you doing?
Hi, thank you, Sam, for having me on your show. It's an honor and privilege for me to be here today, and I'm excited to talk to you about all things immigration.
Absolutely, me too. Well, folks, I would also like to share that Karen is truly an all rounder. She is a frequent speaker, writer, author, and of course, highly skilled immigration attorney. So, Karen, you grew up in South Africa, right? And you did your schooling from there as well, if I'm not mistaken.
Yes, that is correct. I was born and raised in South Africa. I went to law school there. I then came to America. My father had he had been transferred for a job to Germany and then to America. I came over and I didn't actually intend to live here, but then I met my husband, who is an American,
Oh,
and the rest is history. And we now have two adult children who are American citizens. So our life now is here in America. So I've been through the actual immigration process myself. So I know what a daunting task it is, not only from a legal perspective, but from an emotional perspective as well, to immigrate to another country.
absolutely. So, Karen, I think you are one of the best person, who can share with our viewers, like, what were the major challenges that you actually went through when you actually migrated to America?
I think the biggest thing is really getting the information up front to know what the process is going to be like to immigrate. What is the legal process? What is the mental process to go through? What paperwork do you need to get ahead of time? In certain countries, it can take a long time to get birth certificates, marriage certificates, name changes, things like that. So I think it's very important to know upfront what is the process like, what is the time frames that you can expect to go through the process, and what are the documents that are required.
Right, right. So, Karen, I think it's a great start. We have got to know about your background and also the challenges that you faced too when migrating to US. So, Karen, let's begin with our very first question of today's episode. That is, what are the main immigration options available for those looking to start their American dream?
Well, there are a number of options available, and different visas have different alphabet numbers. So we like to call it alphabet soup. There's visas that start with A all the way to the end of the alphabet. But the most common visas that we see in our practice is, first of all, family-based immigration, where a parent, spouse, or child over 21 can sponsor a family member for citizenship or permanent residency. And then there is also sibling sponsorship. Depending on the relationship between the sponsor and the beneficiary, that can take, if you're sponsoring a spouse and you're a US citizen, that can take a year. If you're sponsoring a brother or sister, that can take, right now, it's at least over 10 years to get citizenship through a sibling. So that's the first way we see immigration. We get a lot of cases which are marriage-based green cards, where a US citizen or permanent resident is sponsoring their spouse. We see parents sponsoring children, or adult children sponsoring parents. So that's the most common family way of immigrating to the United States. The next way we see job offers, where a US company offers a job to a foreigner. Those classifications are called EB2, employment-based 2, or employment-based 3 categories. Employment-based 3 categories are if you have a bachelor's and less than 5 years of experience, or you're a skilled worker, which has 2 years of experience, or an other unskilled worker for somebody who has less than 2 years of experience. That's the EB3 category. The EB2 or employment based 2 category is for people who have a bachelor's degree and at least 5 years of experience, and or a master's degree. Then also on the job realm is the intercompany transfer, which is an EB1 visa, employment based one. That is if the person is in a managerial position, they can be sponsored by a company in the United States that has a branch in a foreign country, or if the foreign company wants to open up a branch in the United States, they can sponsor somebody who is in a managerial position or has specialized knowledge or is an executive to come over to the new branch in the United States.
All
So
right.
that's the job aspect. There is also the diversity visa lottery, where you can win a green card. That is only available to certain countries. India is not on that list. It opens every year in October. It's a lottery system. You can win a green card. Then the other common way that we see immigration is through the investment green card or permanent residency. That is called the EB5. You would invest $800,000 into your own business located in a rural area or high unemployment area. If you're investing in your own business and it's in a regular area, the amount is $1,050,000. There is also an investment in a regional center where the amount is 800,000. You would have to work with the regional center, which is a partnership with the government, where you would essentially be loaning them the money for a period of time. And that way you can purchase a green card. That is a permanent green card. And as I said, you'd be loaning them the money. There is also something called an E2 non-immigrant investment visa that's only available to certain countries. And that is if you invest $100,000 into your own business in the United States. That is a way of getting in. It does not lead to a green card in most circumstances. Visas are generally valid from 2 to 5 years and can be renewed indefinitely as long as the business is operating. So those are the most common ways that we see immigration to the United States. We also deal with aliens of extraordinary ability or national interest waivers, where people have risen to the top of their field and it's in the national interest to bring them to the United States. They don't need a job offer from an employer. So if you can satisfy the criteria, they're very tough criteria, that is a way to go for aliens who are of extraordinary ability. Some of the evidence that we would show is presentation at conferences, media about the beneficiary, publications in leading journals, high impact scores on Google, things like that.
All right. So I think, Karen, you have already, given us in a very great way about the overview of the main immigration options, and I'm sure our viewers are literally getting an idea of how and what are the options that are available for them. So I think, Karen, it was really great, and you also touched all the little details about each and every visas. So it was great, and of course, you're a great speaker. So it's very obvious that you literally spoke so good. And now, Karen, I would also like to know some of your political view. So, as we know that Trump has won. So, firstly, I would like to know that were you expecting Trump to win?
Um, well, I thought he had a good chance. I thought he had a good chance of winning. I did not believe he would win by an overwhelming majority that he did. And so that was a surprise to me that he won by that. In total candor, I will tell you up front, I'm not a Trump supporter. So my answers may be biased in this presentation. But I did think he had a good chance of winning.
All right. So, Karen, how do you see America's future now in terms of immigration? Will it be a new era under Trump's administration, or will the immigrants has to have some kind of nightmare effect, what it will be?
Well, I think pros and cons, we've been through a Trump administration before. So we have had 4 years of Trump. We know what to expect. And he is very knowledgeable. The people who he has placed under him who are going to head immigration are very knowledgeable about the procedures and the processes. That could be a good or bad thing, depending on where you are in the spectrum. I do believe that he is going to make it a lot harder for immigrants. I think there's going to be a lot more paperwork involved, a lot more scrutiny, and there's going to be a lot more scrutiny, a lot more paperwork, and a lot more delays. Having said that, he's also has promised on day one to provide green cards to immigrants with master's degrees from U.S. universities. I'm not a betting kind of person, but I'm pretty sure that's not going to happen. But I hope he proves me wrong.
Absolutely, absolutely. And I think an immigration attorney obviously want more and more green cards to be available for immigrants. But let's see what happens under Trump's administration, and we should hope for the best. Okay, so also, Karen, I would like to ask that you have given us the overview of different types of visa types, family-based and marriage-based green cards. So, out of these, is there any specific visa type that Trump that we should look that there will be some kind of major backlogs or that will be restricted under Trump's administration?
Well, in the last administration, in the family-based category, he required what was called public charge documents. It was called an I-944, I believe. My team will know the numbers better than I will, but I think it was an I-944 public charge document. You had to prove that you will not be a public charge or burden on the United States. We still do have an affidavit of support, but it's not as rigorous. I believe that he's going to bring that 944 back or something similar to it, which is going to require a huge amount of financial information from the sponsor to show that they have the ability to sponsor the beneficiary and that the beneficiary is not going to be a burden on the United States. I don't do much immigration with undocumented immigrants, but I think that any relief that is available to them is going to go away in the next administration.
Right. And Karen, also we have seen in the recent news that we have been through that Biden is actually trying to help the immigrants, I mean, the undocumented immigrants to by, launching some ICE app or something like that. So I would like to know that, with the Biden administration's recent moves to loosen some immigration restrictions and also Trump's some potential second term promises, how this is going to impact people who are looking to start their immigration journey right now.
Well, I think it depends on, are you already in the United States? And if you are, what is your status in the United States? If you are legally in the United States, I would start your process as soon as possible. Or if you're outside the United States, start the process as soon as possible. If you can, in the next 60 days, I would do that. If you are in the United States without lawful status, I definitely would not file anything right now. I would stay under the radar, because anything that the Biden administration has done to grant relief to the 11.5 undocumented immigrants in the United States, or portions of that demographic, will be taken away. And I think it's better not to put your name and your details on any government website.
All right. I think that's very insightful, and that is something that a viewer should know. So thank you so much, Karen, for taking that up. And, as you also mentioned that some of the potential, impacts that the people are going through. So what are some key strategies or tips that you would like to give to people who are looking to immigrate to US successfully?
I think the first thing is to really understand the process. What category do you fall into? What options are available to you in terms of visa processes? Is there more than one possibility available? What are the pros and cons of that process? What are the timelines or expected timelines for the process? Do you have deadlines? For example, do you have children who are turning 21 who may age out and not be able to be included with you? I think it's important to talk to an immigration attorney to really understand what your goals are, what the time frames are for your goals, if it is doable, and to understand what documents you would like. Often we get cases that we take over from other attorneys, and there are delays in getting documents that make people lose precious time, children age out, all sorts of scenarios. So I think it's very important to know upfront what you are getting into, and for the beneficiary to really understand the process and be an active participant with the lawyer in making that process go smoothly.
Absolutely, and it's really important to stay, updated with all the news that is happening right now. And also, guys, we are live on YouTube, LinkedIn, Facebook, and Twitter as well. So, in case if you still have any questions or doubts that you want to ask regarding the topic or anything related to immigration, then me and Karen are here for an hour. So please utilize this opportunity as much as possible, and we are definitely going to take them up. So, Karen, also, I would like to ask now some questions related to family based immigration. So, we
Sure.
that family based immigration has really been a hot topic in recent years, especially with the debates around chain migration. So, what are the most important things that families need to know when they are applying for visas like the K1 fiance visa or family sponsored green cards?
Well, I think we also need to look at the administration that's coming in and what they have said. They are very anti what they call chain migration. I don't like to use that word, but that's a term that they've coined. And chain migration means that you're in the United States, so you can now bring your family. I don't believe that they can just get rid of it on day one, but President Trump can sign an executive order. I believe that there would be litigation. So it would take really an act of Congress to do away completely with family sponsorship. I think it's relatively safe to say, although I don't have a crystal ball. If I did, I'd be in Vegas. I wouldn't be a lawyer. But I think it's safe to say that you still will be able to sponsor your parents and children. I think it is possible that Trump will take away the sibling category of sponsorship. But, the devil's in the details, and I don't think that an executive order alone can change immigration laws without there being a fight all the way to the Supreme Court.
And Karen, I would also like to ask you one more question that we know that Trump is trying to implement a new law where if the parents are illegal immigrants, but if the child has been born in the US, then he won't be recognized as a US citizen anymore. Whereas earlier it was completely vice versa. So I just want to know your views. Do you think it's fair enough, or do you think that it should be, it's correct? Just that. Yeah.
Okay, well, there is a concept which is called anchor babies, where people are coming to the United States where they have no ties to the United States, using taxpayer money to give birth to children in the United States for the sole purpose of having babies, and that has been abused. And I understand that there is some cause for concern. You can't come to another country, have your baby here, expect the taxpayer to pay for your hospitalization and everything else, and then leave the country just so the child can be a US citizen. Having said that, it is our law that if you are born on US soil, you are a citizen. I think it's going to be very tough to get rid of that.
Absolutely, and that is something that is literally very shocking and very different as well to understand. But let's see what happens. And okay, so Karen, let's move ahead with our next question. That is, What are the current status of the H1B visas and what changes can applicants expect as competition for H1B visa rises? So, what strategies can applicants use to improve their chances of approval?
Well, there's no way to, I get asked this all the time, there's no way to actually improve your chances in the lottery system. The H1B is a lottery, it's an electronic, as far as we know, it's an electronic lottery system. So being picked in the lottery, there's no way to really improve your chances unless you have a US master's or higher degree. You'll have an extra chance in the lottery. That's a way to improve the lottery, increase your chances by having a master's or higher degree from a US university. But the actual system is computer generated, or that's what we've been led to believe, that it's computer generated and it's random. So there's nothing you can do to improve the actual process of getting selected. Having said that, once you're selected, it is very important that you work with a seasoned immigration lawyer, that you can have all your documents together for a successful H1B application. Make sure that the job description is in fact a professional occupation, that the person has the education and experience, that their degree is related to the occupation. If the degree is from a foreign country, that you have the degree evaluated ahead of time by a authorized credential agency that is recognized by United States Citizenship and Immigration Service. Having a support letter that thoroughly addresses the H1B regulations, that it explains what the company does, why the company needs this employee, how the employee relates to what that company does, and that finally that employee has the education and experience for the position. So the key, we see a lot of mistakes. People are lucky enough to get selected in the lottery, but then their application doesn't pass muster. I think under the Trump administration, there is going to be more scrutiny of H1B applications. So it's very important that you work with a seasoned professional who is going to be able to get together the best application possible.
Absolutely, absolutely. That has to be. So I think folks out there, I hope you're loving our session and you're loving all the insightful words that is delivering by Karen Lee Polak. So thank you so much, Karen, for taking these questions and answering all them very patiently. So Karen, there's another question. What are the biggest challenges that people face right now in terms of green card processing and how they can stay informed about the delays?
I think you've hit the nail on the head. The big problem right now is the absolute big delays in immigration processing. Processing times for certain countries have almost doubled. In fact, they have doubled. For countries other than India, the average wait time has gone from 2 years to 4 years. With India, thinks wait times can be up to 10 years waiting for a green card. And I don't anticipate that that's going to get better soon. I think if anything, there are going to be further delays. We've also heard rumors that a Trump administration will freeze filings of green cards because of the delays. So certain categories may not be available at all to file in.
Oh my God, this is really shocking. But is it somewhere that Trump has said it, or is it like people are assuming?
That he speaks in code, for lack of a better word. So we don't know. He hasn't outright said,
Right.
I am going to freeze the visa bulletin, but he has alluded to the fact that there is a huge backlog and he may stop immigration in certain categories until that backlog has been remedied. But we just don't know. We don't know. We have his architect of immigration is a guy named Stephen Miller. He is very knowledgeable of the immigration process and how it works. And he is the mastermind behind immigration, and he is very, very anti-immigration. He is a nationalist, and he believes we've got too much immigration. So he's got a clean slate board to do whatever he wants to do, unfortunately.
Absolutely. And also, Karen, as you mentioning about Stephen Miller, I would also like to know about the picks that Trump is picking for his administration. See, we obviously know that all of them are nationalist, very vocal, and obviously they will be loyal to Trump. But do you think that the way they are, the way they deliver, or the personality they are having, is this going to benefit America?
It depends on which side of the fence you're on. If you're anti-immigration,
Mm-hmm.
um, then yes, that's going to be, and you don't want any immigration to the United States, any anti-immigration administration is going to be advantageous. Just
Absolutely.
depends on which side you see. The Trump administration campaign ran on millions of people coming in daily to the United States illegally, and he's going to stop that. And that's his primary concern. His primary concern is not legal immigration, it's not business immigration, it's not job sponsorship or investment into the United States. So if you are undocumented, I would be very concerned.
Absolutely. And I think they need to be updated and they need to be thorough with all the information, all the policies that is being updating. So, also, Karen, is there, I mean, we obviously know that there's going to be a very tough time for illegal immigrants. So, what about the legal immigrants? Are they also going to be affected by Trump's administration or they'll have a normal, how they are having now?
Definitely going to be affected if the laws don't change for legal immigration. I do expect delays. I do expect daily executive orders coming out. Whether they'll be enforceable or not, we'll have to see, which will change the laws and the way and the processes and procedures for filing for non-immigrant and immigrant visas. So, there's a Chinese curse and it says, may you live in interesting times. And we definitely will be living in interesting times. I know in the last administration, I'd have clients calling me and go, what does this executive order mean? How does it impact me? And I'd have to say, hang on one moment. It's 3,000 pages. I'm on page 3 and it came out 5 minutes ago. So we will definitely have our work cut out for us.
That might be so hectic, right? To answer all of them at one. And I think people are so much restless now. They all are like, what is going to happen? Are their identity is going to be safe or is there something new? So I think, Karen, you have to answer and you have to go through these situations, I think, very often, right?
Right, right, right. So he will definitely make our work cut out for us. But on the positive side, he has said, as you know, I've already told you, it doesn't make sense to have people educated in the United States and then afterwards they've got to rely on a random lottery, or they've got to leave the country. So basically, we are educating these people in America and then they can't stay. So they take some of the best and brightest are not allowed to stay and they've got to leave the country and they start businesses in other places of the world. So we lose those businesses. A lot of US companies saying we can't rely on a workforce that is determined by a lottery. So they're offshoring a lot of work. So it's actually taking jobs away from America. And President Trump has alluded to the fact that he understands that and will rectify it for people who get degrees in the United States. But again, proof is in the pudding. We'll have to see.
Absolutely. And with Trump, it's completely unpredictable. We can't rely on him completely. We just have to, keep our fingers crossed and see what's going to be the next step of Trump. All right. So, till now, I think we have almost touched a good amount of portion of today's topic. And Karen, we also have, some of our viewers who has joined us on today's episode. And hi, Riz. Hi, Ritika. Hi, Sahil. Welcome to Immigration and Jobs Talk Show. So I think, Karen, let's take one question from Riz. So
Okay.
So Riz is asking that I'm Australian citizen and my partner is American citizen. We plan to marry in America. I'm wondering when she file a petition for me, how soon will this be approved and when do I get working rights? I think it's somehow similar situation to you as well, right?
I'm sorry, can you repeat that?
I'm saying that you were also earlier in South Africa, then you get married, want to get married from American citizen, and then you, right? It's almost the similar process.
Well, I went through a roundabout way in that I did H1Bs as well. So,
Mhm.
but yes, I understand the question. You're an Australian citizen and you emigrating. Sorry, that's my associate, my dog, who's in the background. So forgive me on that.
Okay.
Um, so um, you're marrying a US citizen and you're going to do that in the United States. Generally, the process is taking a year. You would file the application. I'm sorry. I've got to just let this dog out. I apologize.
That's absolutely fine. So, guys, in case if you still have any questions or follow up, then Karen is here, and I think your dog is not in your room, right?
Sorry about that. So I'm working from home today. So um, that's my associate. My senior associate is my dog. So, but my real team is my dream team, and they're located in Dallas, Texas. So coming back to your question, my apologies, is if you're an Australian citizen and you get married in the United States to a American citizen, the process is taking about a year, is the typical timeline that we have advised clients. Within a month of filing, you will get receipts and a notice to go for fingerprinting. At the 6 month mark, you will be given work authorization. So you can start working 6 months after filing. At the 9 month mark, you would be issued a travel permit. And at the year mark, you would be scheduled for an interview. That is the typical timeline. However, lately, under the Biden administration, we have seen that people are getting their green cards in 6 months. So they are not issued a travel permit and they're not issued work authorization. They're going straight to getting a green card after 6 months. So that has been exciting. I don't expect that to carry on in the next administration, but I may be wrong.
Absolutely. All right. So thank you so much, Riz, for your question. And in case if you still have any follow up or would like to share any topic that we would like to have discussion in next videos as well, please go ahead and we are happy to have them all. Okay, let's take from Sahil another question. So Sahil is actually saying I'm currently on an H1B visa, but I'm considering starting my own business. What are my options for transitioning to an entrepreneur visa and what are the key requirements?
Well, that depends, Sahil. First of all, you can open up your own company on an H1B visa. You can own shares in a business on an H1B visa. You can earn dividends on an H1B visa, but you cannot work for the company on an H1B visa. You can only, as you may know, work for the sponsor of your H1B. So options for you will also depend on where you are from, where you are a citizen of. A possibility could be an EB1, Alien of Extraordinary Ability visa, where if you can show that you are an alien of extraordinary ability, you can open up your own business as long as it's in the field that you're an expert at. There is the EB5 investment visa if you have the funds to invest in a business and get a green card. Depending on where you are from, there is also the E2 non-immigrant visa if you invest $100,000. And then there is also a startup visa if you have funding from a US entity.
Right. Okay, so thank you, Sahil, and thank you, Karen, too, for your answer, and Sahil for your question. Karen, I would like to ask a follow up question from this. Like, we have seen more interest in the E2 investor visas. People look to build businesses in the US. So, can you explain the types of businesses that typically succeed in securing it? And of course, with the current state of the economy, how might changes in investment opportunities affect the E2 visa process?
I think as long as we have the NAFTA and North American Free Trade Agreement in place and agreements with the various countries, I don't think that that will change because the E2 is creating jobs for US citizens or uh, people lawfully in the United States. We have seen E2 success across the gamut with all sorts of businesses, from cleaning businesses to franchises to restaurants, real estate, B&B, bed and breakfast. All sorts of businesses qualify for E2 visas. We've seen people who are personal trainers, um, that kind of thing, all have been able to get visas.
Right, right. So, I think that's really great, and that's really insightful. Okay, so let's take our another viewer's question from K. Vishwanathan. So he's asking Karen that I'm currently at L1 petition stage. Is that difficult now with Trump? And what's the next option or steps Cliff my GC with family?
I'm sorry, can you repeat the last part? He's on an L1.
Yeah, I'm repeating it again. Its question is I am currently at L1 petition stage. Is that difficult now with Trump? And what's the next option or steps Cliff my GC with family?
Okay, well, first of all, you have to get the L1 petition approved first. I assume that he meets all the criteria for that. Once he's in the United States, then if he likes it, depending on the strength of the company, how many employees they have, what their revenues are, they could immediately sponsor him for a green card. If he's in a multinational managerial position, we often get L1 approval and then go immediately and turn around and file the green card. It will depend, though, on how many employees are in the business already, if it's an existing US entity already, or if if the business is only starting up. Then the L1 would, if the business is only just starting up in the United States, the L1 will be issued for 1 year. We like to get the L1 renewed after that 1 year so that the person has 3 years in L1 status, and then we turn around and apply for the green card immediately. Because if they satisfy L1 renewal criteria, then it's likely that they'll satisfy the EB1 criteria. We don't typically do an EB1 for a company that hasn't already set up and established offices in the United States with at least some employees, at least 10 employees.
All right. So, thank you, Vishwanathan, for your question. And Karen, we have another question from Cable Cross. So, he's asking, good day. I am a Jamaican citizen, F11 visa category, and documentarily qualified since February 2023. So, how long does it take to get an interview?
So I'm not sure what he means by F11. I think he means F2 category, or
I
I'm
also,
not
yeah,
sure.
maybe.
But generally, once you documentarily qualified, it depends on the consulate, but you're waiting at least 6 months to a year for an interview.
All right. So I think Abel has got his answer. And Karen, we also have questions from Facebook group as well. So we would love to take them as well.
Sure.
Yeah. So I hope my screen is visible. Yeah, it does. Okay.
Okay.
Yeah. So Karen, here's the question that is asked from Ritesh. Hi everyone, I'm preparing my docs for EB1B myself. I need some information regarding filing information in ETA 9089. What parts or sections in ETA form we need to fill specifically for EB1B? Yeah.
Well, for an EB1, you don't need to file form ETA 9089. For the viewers, an ETA 9089 is a labor certification form. So that's a permanent labor certification. It typically is required to be completed by the employer and the employee in the EB2 or EB3 category. In the EB1 category, there is no ETA 9089 or labor certification. What he may be filing is an EB2 national interest waiver. And in an EB2 national interest waiver, he does need to fill in parts of the ETA 9089 form. That will be his biographical details, name, address, his education, his work experience, all needs to be completed to show why he's an expert.
All right. So I think now we should move ahead with our next question. That is from Kiran K. Rao. Okay, I think we should take some other questions as well. So let's take from Zachary Winston. So here's a question that he's asking: help to immigrate to US by EB4.
Okay, well, I think what he's meaning is a religious worker visa. And a religious worker visa, there is two visas. One is called an R1, which is a religious worker non-immigrant visa that is valid for 2 years and can be renewed again for 2 years. Then there is also a religious worker green card. There's severe backlogs in that category. You would have to be employed in a religious position, so such as a pastor, priest, imam, or in a religious related position. So we've even done religious workers for graphic designers, but they have to be well versed in the New Testament, have to be very familiar with Catholicism because they will be doing graphic design. So you don't always have to be an ordained minister. You can be in a secular job, but that it has religious undertones and requirements.
All right, all right. So I think thank you so much, Karen, for taking these questions up. And I hope our viewers are also getting such information from you, so they are loving it. Okay, so here's another question that I am a 23-year-old software engineer with a bachelor's and master's degree in software engineering, with 5 years of experience, four in remote work and one in office. I specialize in software design, development, and optimization. I'm committed to contributing to US technological advancement and economic growth, and I'm also exploring the EB2 NIW pathway. So, could you please provide the insight into my chances for approval along with any suggestions to strengthen my application?
Okay, that's very, very broad. I would need a lot more information, but things we want to see with a software engineer are: do you have any patents? What programs have you developed that are very unique, that will benefit the national interests of the United States? Have you spoken at preeminent conferences? Have you published articles? Do you have 7 to 10 reference letters from experts in the field who can explain why they are experts and why you are an expert in your area, why you have risen to the national interest and are an alien of extraordinary ability? We want to see citation publications to your work, that you've reviewed peer journals, that there are citations to your work. So it's not just that you're a software engineer. There's hundreds of software engineers in the United States. What makes you better than a US citizen who's a software engineer with a master's degree? And what will you do in the national interest of the United States that is required?
Absolutely, absolutely. That's great. And I think, Karen, you literally mentioned it in a very good way that one has to be best in that particular field. And after all, when Trump is under the administration, it's too becoming very difficult, for most of the applicants to apply. So I think the one who will be the best among the rest. I think the competition is too high. So they need to be very much, confident and need to be filled with lots and lots of information. So I think with this, we have another question from Chloe. And she is saying that I have seen too many posts where people request to share the format of the petition, and I have not seen anyone sharing the sample of petition. Is there any format, or just we can use the guidelines of USCIS and write a petition accordingly?
Well, I don't know what petition they're talking about. There's hundreds of
Yeah.
petitions. So different petitions have different formats. But if you're doing it yourself, regardless of which class the petition falls into, I suppose, follow the USCIS format that they put on their website and follow what they require. But I really can't opine to that without knowing what petition. I kind of get upset though with questions like this. It's not a matter of filling in forms, it's a matter of a package. The form, although has to be completed thoroughly and correctly, your supporting evidence is just as important as the form. Using legal counsel to help you draft the form is important, but the legal counsel can assist you with strategy in showing what are good documents that will help your case and those that may even harm your case.
Right, right. So I think, Chloe, it would be great, if you could let us know that which type of petition you're actually talking about, so that Karen can literally guide you. Okay, so here we have another question that, hi, I'm currently working on L2S. Shall I apply for EAD, or do you think the new government will continue to allow people to work on L2S, which does not require EAD?
I see no harm in getting an EAD if they apply. But whether they get an EAD, are they talking about getting an EAD through some other type of visa status, or are they just saying that they on L2S and can get an EAD? I don't think a new administration is going to impact whether, if they get rid of L2 being able to work, it's not going to matter whether you have the L2S, which is evidenced on your I-94 card, or if you have an EAD. If they get rid of that class of document, then they get rid of the class of document, and it won't matter whether you have an L2S or EAD. If you're saying that you qualify for an EAD in some other category, for example, you've in the process of adjusting status, then I would say go ahead and get an EAD, because a Trump administration may get rid of work authorization for spouses of H1B holders or L1 holders.
Right, right. Okay, so I think we are really getting so much information from you, Karen. I think we should pick few more questions from Facebook too as well. So, yeah, here's the question that I'm doing a follow to join for my spouse. I finally got the NVC welcome letter for him. I was asked to fill a DS 261. So, how long did that take to invoice? Also, did you upload documents or were asked to post to NVC? I'm wondering if this is peculiar to EB2.
No, it's not peculiar to EB2. First of all, the form is called a DS260. You should get, my team is experts at this, but you should get fee invoices within 2 months of requesting them. You then would pay those pay the fee invoices, and then you would submit your DS260. Different posts have different requirements. Some posts require you to upload documents. Other posts require you to mail documents to the National Visa Center. So it depends where the consular interview will be.
All right. Okay. Uh, I think we have few more, but let me just check and go through once. All right. So I think, Karen, we have almost gone through, so many questions, and then we have different questions from viewers too. So I think
Okay.
let's take those questions because I don't want to upset my viewers as well. So here we
Okay.
have received from LinkedIn. Oh God. Okay, it's fine. I hope, Karen, you don't mind if we are going to hide you from this.
No problem.
All right. So he's asking, hi, for EB3, what are the requirements? I have exact 2+ years experience and my old company is no more and very small company. Nobody is responding. If I get signed from my colleague, will it cause an issue and whether DOL will do verifications?
And it is possible the Department of Labor will do verifications or ask for additional information, but highly unlikely. In situations like this, it's not ideal. Uh, for the EB3 category, you do have to show at a minimum that you have 2 years of experience as a skilled worker. So it's not enough that you have 2 years experience, but it's the job that requires 2 years of experience. You can get affidavits from colleagues or supervisors who were at the firm if the company is no longer in existence and provide proof of payroll records that you worked there for 2 years. It's not ideal. We always prefer to have a letter on letterhead from the company, but sometimes it does happen that companies close down. You're unable to get an employment experience verification letter, and we do get affidavits from supervisors, colleagues, and show payroll records or bank statements which show the deposit of your salary in bank accounts for at least 2 years.
All right, all right. So this is the question that we received from Tarun. Somehow I can't see his name, but that's okay. Thank you so much, Tarun, for participating. And if in case you still have any follow-up question or any other question that you would like to ask from Karen, then please go ahead. We would love to take those questions from you. And also, Karen, we have few more questions from. Let's take from Ritika. I have a degree and 8 years work experience in my home country. What are my options for obtaining a work visa or green card in the US? And what documentation do I need to provide?
Okay, well, first of all, it's very vague. We would need to see if you qualify as an alien of extraordinary ability for an EB1 visa or an EB2 national interest visa. In that, if you do qualify for either of those visas, you would not need a job offer. If you don't qualify for those visas, then you would need a job offer from a US employer who's willing to sponsor you and pay you a prevailing wage, which is the required wage for the job position. You could then apply for a temporary visa called an H1B, which is for professionals who have a degree. If the job is in a professional position, in a specialized occupation, the employer could also sponsor you for an EB2 green card or EB3 green card. From what you're saying, you have a degree in 8 years of work experience. So if the employer is willing to pay you the prevailing wage for the job, I would go in the EB2 category.
All right. So, Karen, we also have a reply from Tarun, and he's saying that this is like 10 years ago, madam. All right. Okay. Thank you so much, Tarun, for sharing this information. And okay, we have also response from Vishwanathan, and he's saying thanks for adding that question and sorry for the typo. That's completely okay, Vishwanath. That's okay. And thank you so much, for participating, guys. We are really loving this conversation. And control, I would request to just display the previous question that we have also received from. I think I can't pronounce the name, but okay, let's read it out. That is, trust this mail finds you well. Notice that you an expert in H1B visa issues. Please, what is the implications of not entering US after 1 year of H1B visa stamp? The reason is that the US facility has a delay in resumption time, which has prolonged beyond expected time. Would to this delay after the employee?
Well, if you don't have the job available, um, then you can't come into the United States. You don't want to be here not earning a salary. So I don't think a delay of a year, though, will impact the H1B as long as you enter within the 3 years of the H1B stamp. I think you will be fine. You don't need to enter immediately. It often happens that, particularly with staffing companies, the projects go away. So you may come in 6 months or a year or even a year and a half later. But as long as you come in during that duration that's stamped on your H1B visa, I don't see there being a problem.
All right. So I think that is very much clear from our side. And next up, also, Karen, we have a follow up question from Vishwanathan. And he is asking that I am part of MNC company with its location in 7 states in US land. Should I take the EB route with the employer sponsor and that too not takes 10 plus years?
Well, it depends where he is a citizen of, but if he's a citizen of India, it is going to take 10 years. But he could also apply for an H1B visa now, and he could come in sooner if he's selected in the lottery.
All right. So I think Vishwanathan, it would be great if you could let us know where you are watching this session and actually where you are trying to apply the application from, so that we could be little specific and could answer it well. Okay. So also I think we have few more questions. So I think let's take them up and yeah, let's take it from Ritika. The another question. So, Karen, Ritika is asking that what are the key difference between temporary and permanent immigration options, and how do I determine which one is right for me?
Well, first of all, it depends on what your long-term goals are. Do you want to permanently live in the United States, or do you want to just come here for a couple of years and then go back to your home country? A temporary visa or non-immigrant visa is a temporary visa that allows you to stay in the United States only for a certain period of time. If you want to continue staying here after that time, you will have to renew the visa. And certain visas, like an H1B, have they have an expiration time. So you can only live in the United States on an H1B visa for a maximum of 6 years, unless you have also been sponsored for a green card and have an approved I-140, which would allow you to extend the H1B past 6 years. So if you only planned on being here for 3 years, then an H1B may be an ideal visa for you. If you are planning on living here, after a period of time, you want your employer not only to have sponsored you for an H1B, but you want them to sponsor you for permanent residency, which is an immigrant visa, which allows you to live and work in the United States indefinitely.
All right. So thank you, Karen, for taking these questions. I'm really sure that our viewers are definitely, getting so much information from these questions. And also, we have received a follow-up from Vishwanathan. He said that he's from India. So, yeah, Karen, I think it will take 10 plus years longer or, yeah.
Yes,
Can you please go ahead?
unfortunately, I'm so sorry. And it's probably wait times are going to get longer. So if he doesn't have a non-immigrant visa, I would recommend that he apply for an H1B visa.
All right. So I hope that Vishwanathan, you understood the session, and it would have been really grateful for you too to go ahead and attend this session completely. I'm sure you will definitely understand and go through so many things on this topic. So, Karen, we have almost touched an hour and we didn't realize. That's a great thing. So, Karen, from my side, I really enjoyed this discussion and, is really looking forward to continue these discussions and have more and more sessions together in the future. So, from my side, it was great. Yeah. How was you? I mean, how was your experience?
Thank you. Thank you very much for having me on. I really enjoyed it, and I'm happy to do another session with you. Next time, my little associate dog will not be interrupting us, so I do apologize for that.
No, that's all right. After all, he's your associate, so he needs to keep an eye on what Karen is doing. But that's
Right.
completely all right. That happens. And any last message, Karen, that you would like to share with our viewers about the topic, how they can, have their American dream come true.
Do as much research as you can on the type of visas, on attorneys that you're going to use. Make sure that you thoroughly understand the process before embarking on it. It's a relationship with your lawyer, and especially in the case of India, you are going to be working with that lawyer for over a decade. So it's important that you understand each other, understand your goals, that you understand timelines, and just do a lot of due diligence. Immigration website, the USCIS website, which is uscis.gov, has a lot of interesting, very informative information on the various types of visas. We also have videos and blogs and information on our website on all the visas that we've discussed today.
Wow, that's great. And that's absolutely fantastic. So, Karen, thank you. Thank you so much, for making this session an amazing one. I really loved it. Our viewers too. And thank you also, guys, for participating in today's session. Sahil, Ritika, then Riz, Cable, and Tarun, and also Vishwanathan. Thank you so much, guys. It was lovely, lovely answering to your questions. And also to our viewers, guys, if you still have more questions or want to connect with attorney Karen Lee Polak, then please feel free to reach out on the given contact details. That is, the number is 214-504-1227. The email ID is karenlp@polakimmigration.com, and the website is www.polakimmigration.com. All right. So thank you so much, Karen. It was really lovely, lovely having you, and honored too to have you with us on Immigration and Jobs Talk Show. Thank you so much.
Um,
Yeah, wish you and your family happy Thanksgiving. So
Happy Thanksgiving, and thank you for the privilege of having me on your show today.
oh, pleasure, pleasure. Thank you so much, Karen. And guys, don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. We will bring you more insightful sessions, and we are definitely going to cover a lot and lot of different topics related to immigration. So don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. And thank you so much, everyone, for joining us. See you next video. Thank you so much. I'm Sam signing off for now.
Hello and welcome back, everyone, to Immigration Talk. I'm your host, Pastor Pradhan, and today we have an exciting and highly informative session lined up for you. But before we move ahead with what our topic of discussion is going to be, and I even introduce you to our guest for today, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided to you by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, friends, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook. And let me tell you that you can also participate in this session by commenting. So, whatever questions you have, especially with regard to the topic of discussion for today, it'll be very nice if you can comment them. And we will definitely make some time later in this session to answer to your questions. So thank you so much for joining us. And definitely, I mean, the 2024 US presidential elections have really stirred up a lot of discussions, and people are really anxious also, especially when it comes to immigration policies. So, with potential changes on the horizon, many of you are wondering maybe what will happen to US study and work permits in 2025. So, to help us navigate and dive into this really very critical topic today. I'm really thrilled to introduce you to our esteemed guest who is going to join us today for the first time on Immigration and Jobs Talk Show. None other than Attorney David Garson. David is the founding partner of Garson Immigration Law, one of Canada's premier immigration firms, and he is a certified specialist in citizenship and immigration law, recognized by the Law Society of Ontario, and is ranked among the top 9 immigration lawyers in Canada by Chambers and Partners. So David's extensive knowledge and expertise and experience in this field definitely makes him the perfect expert to help us in this topic today. So without further ado, please help me welcome David Garson for the first time on Immigration and Jobs Talk Show. Thank you so much, David, for joining us.
Thank you so much for having me. It's a pleasure to be here.
Absolutely lovely. And maybe you would like to tell us a little more about yourself, something you may want to highlight or tell us about yourself, anything at all.
Sure. I've been practicing immigration law for over 30 years. I'm dual licensed in Canada and the United States. We help individuals enter Canada and we help them go to the United States. So, we've seen a lot of what has been going on over the years, and immigration as it's been influenced by politics, and frankly speaking, politics has been influenced by immigration. So it's a very interesting time that we're facing right now, without a doubt. There's an old curse, though, may you live in interesting times. So I imagine that there's a lot of anxiety and a lot of questions that people have, including me, because I know we're going to get into questions, and you may hear this a lot from me going forward, but we really don't know much yet. We know what the intent is. We know what this administration had done previously when it was in power, or this president, but we don't know necessarily what is going to happen in the next 4 years. But there have been some indications. There's been some statements on the campaign trail, and I think we can try to piece together or guess, prognosticate as we go. So I look forward to it.
Me too. And definitely with your expertise and experience, I'm sure your perspective is going to add a lot to the viewers out there, who are all anxious, want to know more, what is going to happen. And some of them are even maybe, fired up to even acting quickly. So maybe you might want to warn them or give out some tips to relax them. So thank you so much, David, once again for joining us. And as we already have said about the topic of discussion, today's topic is U.S. study and work permits, what to expect in 2025 after the elections. So I'm sure folks out there are very, very excited. And I can already see some comments popping up. So thank you so much, Supriya, our first viewer who has commented with a question. Please stay with us. We will address your question a little later. So, David, are you ready for our questions now?
Sure, let's go.
Let's go. So how do you anticipate changes in U.S. study and work permits under the new administration, particularly for international students and foreign workers?
Well, it's an interesting question because, as many people may remember, under the last administration, they did try to enact legislation or presidential orders stopping people from coming or stopping students from coming and regarding work permits, but the courts overturned them on various occasions. So whenever they were attempted to try to sort of enact things or move forward, the courts sort of made them take a step back. So in the end, they didn't really get a lot done legislatively, meaning they didn't pass a lot of laws with regard to be restrictive. But what they did do, and what they can do again, is you can work within the system to make things more difficult if you're so inclined. I'll give you an example. If somebody makes an application for a student visa, as many people who are watching probably know, you have to satisfy the State Department or the consulate of a few things, one of which is that you have temporary intent. Now, that's a very broad concept, temporary intent, right? You have to show that you are willing to go back to your home country at the end of your studies. So to do that, you present a lot of documentation. You show you have bank accounts, or you have ties, you have family, you may own property, job offers, things of the sort. So you keep doing this and you go to the consulate and you say, okay, I've been accepted for University of Pennsylvania. And here's the proof that I've been accepted. Here's my I-20, which is the document you have to present. And here's my proof that I have ties. A consular officer can look at it because it's very discretionary and say, okay, I'm satisfied with those ties. Fine, we're going to give you the student visa. Or a consular officer can say, no, not satisfied, not good enough. Now, if an administration wanted to curtail the number of students that come into the country, then what they can do is simply tell the State Department, which tells its officers, perhaps look at these applications a bit more critically. Maybe there may be another set of criteria we want you to examine in that regard. So they can make things more difficult without changing any legislation for people from getting student visas. So let's say that somebody does get a student visa and they come into the country and they go to school. As many people know as well, at the end of their schooling, they can get something called an OPT, optional practical training, for a year. And then subsequently, under the Obama administration, they said they can extend that by 2 years, okay, if you're in a STEM field, okay? They could take away that. That was something that the Obama administration put into effect. That's not something you have to have. And certainly that means that in terms of being able to work at the end of your studies, they could make that 1 year, they can make it shorter, they could play with the STEM time frame, they could play with the OPT time frame. So I guess what I'm saying here is, what do we think is going to happen? I think that if they want to make it more restrictive, they can do a lot just with what the legislation and the rules that are on the books. And then subsequent to that, in terms of working afterwards, they can make it more difficult based on how they want to work the work permits after you graduate.
Okay. So we can definitely expect another layer of scrutiny or maybe tightening of.
I was going to say, and there may be a question going forward that we want to, yes, I think based on previous experience, but remember when I started, I said that politics play a huge role in immigration, meaning especially the people that advise the president with regard to this. In his last administration, there was a fellow named Stephen Miller who was advising President Trump on immigration. Now, Stephen Miller was a pretty restrictive guy with regard to immigration. He had thoughts and policies that meant he wanted to narrow the ability for people to come to the United States. I don't know, or I haven't heard that he's advising President Trump this administration. In fact, he's taking a lot of advice from Elon Musk. Now, I'm a guessing man. If you guess, Elon Musk would know the value of foreign workers, and especially people in STEM fields, with regard to what he does. So if he's advising President Trump and he says, okay, listen, we need people, let's say, with regard to the H1s or OPTs, because these are the individuals that we need in the tech sector or the manufacturing sector or the innovation sector. And so maybe let's not be as harsh as we were previously.
So there we go, friends. And I think along these lines, we are going to definitely dive deeper and we have more questions and more people joining us. So I'm really happy. Hello to George, if I'm pronouncing it right. Hello, George in LinkedIn. And we have Namrata Reddy, Jayakumar. Please stay with us. We are going to take up your questions for sure. So David, my next question is, what specific policies do you expect Trump administration to implement in 2025 that could affect students applying for F1 visa or those already in OPT?
I'm thinking, as I said before, that they are going to be more restrictive with regard. This is what I expect. Everything I'm saying here is I'm just guessing the same as you, but based on what I've seen and based on what I've heard, I do expect them to be somewhat more restrictive with regard to issuing F1 visas than they have been. I also expect them to be somewhat more watchful. I mean, I don't think they enjoyed seeing, and especially they spoke out on the campaign trail, all of the occupied at the universities in terms of the encampments. I think that was something that was not something that this Republican Party, or certainly this president, wants to see going forward. So I think there may be somewhat more restrictions and or variations that are imposed on individuals with regard to what they do when they do come to the United States, if they get their F1. And if they do act in a certain way when they're here that doesn't exactly or expressly have to do with going to school, then there may be further actions that can be taken against them with regard to leaving the United States. In terms of work permits, as I said, they got slapped a lot last time they were in power with regard to changing the law. So they acted or created situations that gave them what they wanted to do. They slowed down processing. They made it, the amount of denials increased in terms of the percentage. So they can do things like that. I would guess, based on what they've done before, that that's what they'll do again.
Okay. But it's really nice to have, your point of view, your perspective on this. So thank you so much, David, for doing this with us today. And also, since we're talking about students, maybe you could tell us what challenges should students be prepared for, especially student visas on F1 and work visas H1B.
So when you're coming in, and as I said, when you're asking, I mean, if somebody's applying for an F1, the easiest way to refuse a person, if they have the money to pay and if they have the money to support themselves and if they have been accepted to the school, the easiest way to be refused is on temporary intent. So if you are applying for a visa, to document yourself with regard to temporary intent and your ties to your home country, I think is going to be crucial. I think you have to have as much documentation as you possibly can with regard to your case and with regard to your ties, so that when you go to the consulate and you apply, that you are able to convince the officer that you do have that temporary intent and you can come to the United States and you will leave. I think that's going to be paramount with regard to that. In terms of the student visa, I mean, once you get a student visa and you get your OPT at the end, the issue is that, of course, with the lottery on the H1s, and it makes it difficult to get an H1 in any event. And we are, for instance, contacted by companies all the time that have an individual who is in OPT status and has applied, and they've tried to get that person in H1, and they can't. They've not been picked. And a year goes by, and if they're on STEM, they have the extension, but they don't get picked. And so the company is looking to see if they can go work in another place for that company elsewhere in the world or something of the sort. So the advice I would have, realistically speaking, is that once you're here on the OPT, I mean, it's not, you don't really have control of this situation. And unless they expand the number of H1s that they're willing to give in a year, realistically speaking, I would probably look at, on practical advice, working for a company that maintains as a multinational corporation that can send you other places if they need to, if that's at all possible.
That's good advice. I think that we should consider for sure, folks out there. I think you should look onto that too. And, David, I think we'll quickly take Jayakumar's question, if that is fine.
Sure.
So let's go with it. I got 221G issued with white slip, and after a week got an email that intend to revoke from consulate in India. What are the chances of getting approved if my employer responds back?
Oh, that's a very good question. So first of all, for anyone that wants to know, 221G means they need more information. So there's various ways that a consulate can refuse you. It could be under a section called 214B, which is that temporary intent section. The one you don't want is something called 212AC, because that's misrepresentation and that's horrendous. 221G means that they need more information, or so they're refusing the case pending more information coming in. It's a refusal, but it's kind of not a refusal, because it means that they're still considering the case and are okay to get more information. Now, I don't know the background of this case in the sense, why is there an intent to revoke? Is there an intent to revoke because they came upon other information that sort of speaks against what was previously submitted? Have they perhaps done an investigation and figured out that there isn't something here that they need that didn't occur or something of the sort? So in answer to your question, what are the odds? It depends on why they're going to revoke. If they're going to revoke because they have definite objective information that's not good, then the odds may not be that high. But if the intent to revoke is based on a misunderstanding or information that they didn't get or thought or they misread, then it could be fine. Realistically speaking, I mean, whatever you do, when you file that information that is supposed to, that they want, please make sure it's as fulsome as possible, because you're going to get one crack at this. So if you're filing that information that's in addition to what they want to try to address the revocation, make sure it's as fulsome and as packed with whatever you need as possible. Don't play games with it. Because also, and again, I don't know the background, if you submit information that isn't helpful and they are looking at it and saying, well, we're revoking this because we think there is misrepresentation, then you could get slapped with that 212A6C, which is never a good thing. And it could be very deleterious to the case.
Right, David. Thank you so much for taking that up for Jaya. And Jaya, thank you for your question. Really great question. If you have any further questions, you can keep commenting. And we have Jorge saying hello, and he has a question. What can an experienced engineer in the IT industry that is a non-US citizen do to get a working visa, any type?
In the US or anywhere, I guess, in the US?
Yes, that is a non-US citizen, maybe in the US. Yes, in the US.
Yeah. I mean, realistically speaking, it depends on your citizenship, of course. If you're Australian, for instance, you may be able to get an E3 visa. Or if you are, let's put it this way. So there's different types of visas you can get depending on citizenship as well. So if in the normal course, everybody knows about the yes, in the US. Okay, good. Everybody knows about the H1, right? You have to have an employer. The employer has to register. You have to register that expression of interest. The rates of acceptance haven't been that high. They've had a lot of applications and a lot of people have not been chosen. But that is the normal way that most people do get visas. There's something called an L1, an intercompany transfer. So if you, for instance, are an engineer and you go work for a company overseas for a year, and that company then wants to do this L1 intercompany transfer, they can do that to send you into the United States. If you go work for a company that has your nationality, there's treaties of navigation and trade. It's commonly called the E visa. So if you have the same nationality as the company ownership, then they can try to get you a visa under the E visa category. If you're Canadian, then you have the free trade agreement that you can look at, or Mexican for that matter. So there are various possibilities. That being said, the most common way an individual gets to the United States, all things being equal, is if a US company petitions for them under the H1 category. Actually, there's one more as well. If you are a person of extraordinary ability, and in that you are one of the top individuals in your field, you've written articles, there's been news about you, all that kind of thing, then you can apply for something called an O1, which is extraordinary ability. You have to be a very high level, though. It's not, they realize with the cap on H1s, a lot of people are going to try for O's. So you can't do it if you don't have at least, unless you've written a lot of articles or some scholarly, and unless you've been featured in a lot of different ways, it probably wouldn't be relevant.
Definitely. And by free trade agreement, you mean NAFTA, right?
Well, it used to be NAFTA. The US calls it the USMCA now. Canada calls it the CUSMA. And to be honest, they have no clue what Mexico calls it at this point.
Okay, but Jorge, you have a lot of options out there. Depends where do you actually fit. So you might as well go consult an expert. And I would always say, yes, you need an attorney. So it'll be good to be guided by an expert. Thank you so much. And now going on to our next question. And definitely, if you want to have a one-on-one consultation with David, you have his contact details on the screen. You can email david@garsonil.com. And you can go visit www.garsonil.com. Thank you so much. And let's go to our next question, David. And that is DJ4496 asking, hi, my husband is primary. We are from India on EB2. We got our green card EAD for 5 years. Our priority date is September 30, 2014. So my question is, when can we expect green card?
Yeah, it's going to be a long time. It'd probably be within that 5 years. Well, right now, I'll take that back. Right now, it could be within the 5 years, but it is taking 5 to 7 years in that regard. However, that is also something else that may change come the new administration. These things could get elongated out. As you probably know, many people find themselves in a priority date that is current, or you think it's almost current, and then it doesn't move for a long time. The issue is that come the new administration, one of the things they can do as well is slow down the priority date processing, so that takes a while. I mean, the fact that you have a green card EAD for 5 years is good news. I mean, that keeps you there for a long time, and hopefully, there is also the president-elect did go on radio and talk about the fact that people that graduate from U.S. universities should be eligible for green cards as long as they do everything right and they've done everything that is appropriate. So, you can't always think that he's going to, or they're going to do anything that's that detrimental. It could be that if he's looking at who is applying and that they need individuals in that field that are applying, and I mean, he may speed up green card processing in certain situations. He may be tougher in others, but to your point, your husband has the EB2 approval. You have a 5-year work permit. Hopefully, within the next 4 years or so, you should be able to get a green card.
I think 4 years is not so bad. I mean, for
Not
many
easy.
folks out there, it's decades.
But again, we don't know.
We don't know.
That's the problem with having this in November when a new president is taking office in January, and you have no clue what he's doing. Somebody asked a question about Tom Holman being appointed today as the new border czar. Yeah.
True.
I'll answer. I was just looking at that. What do you view as Tom Holman being appointed as a border czar by Trump administration? Should people be scared given his known stance on immigration and mass
Deportation, Drive 10, yes.
Well, he was the head of ICE before, and he is a tough guy on this. In terms of being scared, I think that Trump is sending a message, certainly. One of the cornerstones of his campaign was talking about deportations, right? I think Vice President-elect Vance talked about deporting 1 million people a year. I don't think they're going to be able to do that. Let's be blunt. They're not. First of all, how are they going to find them? I mean, where do you, if they're out of status in the States, where do you go? I mean, you have to locate people. But I think Mr. Holman is a very tough guy. I think that it is sending a message. I think that if you're going to look to deport people and you're going to look to be restrictive, he would be the man for the job. Yeah, I think that's what he's doing there. That all being said, the courts are there for a reason. And like I said, in the last Trump administration, a lot of what they wanted to do was thwarted by the courts. So once somebody is taken into custody and they move towards deportation. I mean, I'm not a deportation lawyer, an enforcement lawyer in that regard, but there is access that a court can comment on with regard to any of this. But yes, I think I think having Mr. Holman as the border czar will mean that the Trump administration is going to try to do what they said they were going to do.
Right. And this could be one of the biggest mass deportation in the history of the United States, I guess. Let's see what it holds.
I think that he wants to try. I mean,
let's see.
Yeah, and then somebody said they were talking about deporting illegals. If you're there illegally, there's nothing to fear. I agree with that.
Right.
I agree with that. I think if you're in the United States legally, I don't see anybody wanting to deport you. I don't think they can. They can't if you're there legally. The question is that they could create situations where you can't extend your status, or that it would be too difficult to extend your status. And in those situations, then you have to leave. But in terms of being gathered up by ICE and deported, no.
True. Thank you so much. David, for taking that up for Drive 10, and even Jorge, thank you again. So we have our next question. This is Akshay. Akshay is on YouTube asking, would the consulate officer check my past employment history after my MS? Now, if I am applying for a PhD, what should I be careful about?
So they're going to check my employment after my master's degree. Well, yeah, if they have information. I mean, realistically, when you fill out, when you're at the consulate and they're asking you questions, after you got your master's degree, I'm assuming you did your OPT. If that's the case, then they may look at that. certainly, yes. If you're applying for your PhD, if you're not extending status and you're going to a consulate and apply, then it pretty much is what I've just discussed, and that is the temporary intent issue and the fact that you're transparent with regard to what you're going to be doing and what you're doing and how you're going to be doing it. The fact that you're going for a PhD should, by practicality, make it easier to get a visa, because it does show you have certainly serious intent towards your education to get a PhD. And it's normally, when you get higher in the educational sphere, it normally would make it not easier per se, but the officer would understand you've had, especially if you've had visas there before, that you've adhered to U.S. immigration policy, and that you've been someone that is credible. Okay, and I think that has a lot to do with it, credibility, when you're applying for any visa. Because if you do things that they don't particularly care for, or have done things they don't care for, then you lose your credibility with immigration, and that's when things go awry. And that's good. You did your OPT in STEM and then return back to your home country. I think that's very good. It shows that you adhere to U.S. immigration, that you follow the rules, and that they can count on you to follow rules. And I think that having a track record like that is important.
True. And I think that is a plus point for you, Akshay. Thank you so much for your question. And if you have any more questions, you can keep commenting. Well, he says, yes, I did my OPT in STEM and then returned back to my home country. Very nice. Following the rules. There you go. And thank you so much. Even DJ4469 says, thank you for answering the question. Great. Well, David, now I have another question, and that is, if an F1 student's OPT is set to expire in 2025, what options do they have for extending their work authorization, especially with the potential changes in U.S. immigration policies? What do you suggest?
Yeah, this is an easy answer, not much. There isn't that much to do in the sense that if your OPT is expiring, and you don't have if your OPT is expiring and you don't have a STEM OPT extension that you can look at, or you can't get another type of work permit based on nationality or a treaty or something of the sort, then there really isn't that much for you to do. As I said, though, we have seen companies, multinational companies, where somebody has an OPT and they're with them for a year, and then the company says, you know what, we are going to put you and you're going to work for our subsidiary or our parent or our affiliate in another country. Then that being the case, if they do that and you're with that company if you're with that company in another country, then if you work there for a year, they can then look for an L1 intercompany transfer to bring you back to the United States. By the way, that is another possibility where they may be more restrictive going forward. There's such a visa called an L1, and an L1 is an intercompany transfer. And you can do an L1 for a manager or executive or a specialized knowledge person. And specialized knowledge usually means a unique knowledge. It's both proprietary to the company and a knowledge of the field. So if they wanted to slow down people who are coming to the United States in specialized knowledge L1s, they could do so, again, not by changing legislation, but simply by making the criteria more rigorous and saying it's going to be harder for you to get an L1 because we want to see a lot more within what you've done and your history and your experience and things like that. So that could be something else that they look at. But if you're in OPT and you don't really have any, you can't extend it, and you can't qualify for another type of work permit based on, as I said, other factors, and unfortunately there isn't really much that I can see that you can do.
Well, thank you so much for that, David. But I think that's all we can do for 2025 then. And I'd quickly like to say hello to Jemshid. Thank you so much for joining us on LinkedIn. And then we also have Ezzy Lydia. Lydia, thank you so much for joining us. Hello, everyone. I am Lydia. She says, hello. Now I have my next question to you, David, and that is, what impact will the expected changes to work permits and student visas have on industries that rely heavily on international talent, such as technology and healthcare?
That's a good, well, and this is what I was talking about before, that it would be very, I think it could be pretty detrimental in those situations, which leads me to believe that there will be individuals surrounding the president-elect that could talk to him about this, i.e. Elon Musk or someone of the sort. I mean, he doesn't want to, cut off his nose to spite his face necessarily. He understands that there are areas where people need employees, and if you don't have them, then things are going to not be as I guess you could say, they won't be they won't go as well as they should for that industry and for that company. So realistically speaking, I think it will have a deleterious effect on those companies and that industry, which leads me hopefully to believe that they will see that and make allowances in certain areas.
Okay, but definitely, I mean, people, I mean, especially where US needs talent from, I mean, different countries where, US may not have theirs. And I think this is something that is going to be affected for sure. So, David, thank you for highlighting that. Now, I have another question, and that is, if a university student on an F1 visa receives an unexpected job offer before graduation, what immediate steps should they take to ensure compliance with the new work permit regulations under the Trump administration?
Yeah, well, they won't be able to do, again, they'll have to, I mean, realistically speaking, they can do their CPT, which is part-time work within the context of when they're studying, and that's fine. And they have to be able to do that and get approval to do that. But realistically speaking, if under this administration, we don't know what they're going to do with the OPT and what they're going to do with regard to the student visas, because in the normal course, you can't work if you're on a student visa. You have to go to school. In certain circumstances, a spouse may be able to, if things go very bad and in hardship circumstances, there may be ways for a person to get a EAD. But in the normal course, they can't do much in that regard. They have to be compliant. I think that is a lesson that going forward is going to be as important as anything. And that is, under this administration, you have to remain compliant to the letter of the law. Because I think that if you do anything that's not going to be completely by the book, you could find yourself in a situation where you will be removed from the United States, or put yourself in a position where you could be removed from the United States. So in any event, if you get an offer of employment, you can't necessarily you can't necessarily start working. You have to wait until you're eligible to work. You wait for that, then you can start to work. And any employer that is interested in hiring you, and frankly speaking, has worked in the system before, will understand that. Remain compliant. More than anything else, remain compliant.
Thank you, David. I think that is a great advice. And folks out there, you definitely need to stay vigilant, compliant, go by the rules, be on the right track, and stay hopeful. I think that is what I can say for now. And yes, absolutely. Go contact Attorney David Garson, and he's definitely going to direct you at least how to go about it if you have any confusions, or especially that every case is different and you might need special attention. So why not email David? His email address is david@garsonil.com. And you can also go visit his website, www.garsonil.com. Thank you, David. And okay, Akshay is back saying, I'm sorry I missed the first 15 minutes of this session, but I wanted to ask about the implications on OPT and STEM OPT going in the future. Do you want to say that?
Sure. As I was saying, we don't know. There's been a lot of discussion regarding it, to be honest with you. In fact, this is probably the area that has been focused on the most by pundits and newspaper reporters and things. So what is this administration going to do with the OPT and STEM OPT? The STEM OPT was established by the Obama administration. I think that the Trump administration, in this first go around, tried to get rid of it, as I recall, or tried to limit it, and they weren't able to do so. That doesn't mean they aren't going to try again. The OPT, I mean, I don't see them stopping the OPT. I really don't. I don't know why they would. I think that it's helpful to employers. It's helpful to the individuals. But I don't know that it would be expanded in any way, shape, or form. Unless, and I mentioned this at the beginning, as I said, under the last administration, the person who was responsible for advising the president was a fellow named Stephen Miller, who was pretty restricted. I don't know that this person is advising the president under this administration. I think Elon Musk is having a lot of say in this. And that being the case, if he listens to that kind of individual, then he may understand the importance of people who are in STEM or technology or even trades, to be honest with you. I mean, let's be honest, a lot of people, they say there's 11 million people who are out of status in the United States. I don't know. I haven't looked at the statistics, but I'm kind of thinking that a lot of them are in construction and in trades in places that need them. So for instance, there was just a hurricane in North Carolina. There's always hurricanes in Florida, things like that. They have to rebuild their infrastructure. And I'm not sure there's enough people who are US citizens or green card holders who can do that. So I think practically, and I think I don't want to say it's a secret, but I think most people believe or think that a lot of the people that are working in trades and construction and I was going to say technology, not so much, but trades and construction are probably people who are out of status. And so if the president or this administration wanted to look at something like that, there may be a possibility of I don't want to say an amnesty because people freak out when I say the word amnesty, but of a possibility of creating a pathway for individuals who work in certain sectors and have worked in those sectors for a while to get permanent residence, especially if they're needed.
There you go. Okay, thank you. Yes.
Somebody just made a comment that Elon will be the savior of the STEM people.
He's the same guy. Akshay is the guy only. So he was also saying, also it is true that you can use STEM OPT only once. For example,
That's
if I
true.
used STEM during my master's, then I
No.
cannot use it after my PhD. Please clarify.
Correct. Yes.
That's true. That's true, Akshay. So there you have it. Thank you. Thank you so much, David, for taking that up. Jorge says, just want to thank David for this session. He's very well spoken and knowledgeable. Definitely. Thank you so much, David, for joining us and making time for this.
That's very
Now,
nice.
my
Thank
next
you.
question, yes, thank you. Next question for you, David, is how will the proposed restrictions on OPT affect international students pursuing STEM degrees, and what steps can students take to mitigate these changes? We've been discussing this over and over, and maybe if you have any more points to...
Yeah, no, I think I pretty much said everything I can say. We don't know what they're going to do. Everything may change or nothing may change. You know, I know I sound, that's an easy thing to say. It gets me out of a lot of questions, but
no, but
I do think based on previous experience, meaning the government's previous governing, or this government's previous governing, that things will get more restrictive. It will be tougher to get cases approved. They don't need to change the law to do that. The L1s, the H1s, they could take away spousal. I'm going away from OPTs, I apologize, but they could take away spousal work permits from the H2s or the L2s. I'm sorry, the H4s and the L2s. They could take away, meaning if right now, if I'm on an H or an L, my spouse can get a work permit. They could take that away. And by taking that away, it lessens the, I guess, desirability of people coming to the United States. Because if your spouse can't work, then what are you doing? That's not very fair. It's fair, but it's their country. But what I'm saying is it's not as attractive to somebody who's coming. So they could do all sorts of things. So in terms of the OPT, I don't know that they'll do anything significant. I think the STEM OPT, that in itself is up for grabs. And to that person's point of view, Elon may be the savior. Who knows?
For sure. Okay, well, what do you want to say about the H1B lottery? Maybe we are going to expect changes, everything immigration related. But do you have anything to say on that H1B lottery system?
Yeah, I mean, the 65,000. It's always it's a mad rush when cap season comes and employers file the expressions of interest and wherever it's usually 15, 20, 25% that get picked. I can't see them going a lot higher than that. if they wanted to do things that were, I guess you could say, innovative, and then they could change that cap for the various industries that people go into. So for instance, there's a lot of people in STEM, a lot of US citizens, and a lot of green card holders in that sense. So if you have if you have a degree in a STEM field and they need STEM people, then they can absolutely say, you know what, we can raise a cap in this area. We can get more people in this area. Why we need them? Or it could be another field or something of the sort. In the sense of that. So they could be innovative. You never know. Things could go better than it has been before. In that way, they could be somewhat creative and think outside of the box when they're doing these kinds of things, or they may just be completely restrictive. In other words, it may be a very good hedge, and it would be a good legacy for this administration if they changed the immigration policy and made it something that was more utilitarian for everybody, so that it's functional and practical, not necessarily a one size fits all.
True. And maybe everything you say cannot happen. I mean, even Trump cannot say that whatever he has said can happen, right?
Right. No, that's exactly the case. I mean, in the end, it will depend upon who the president surrounds themselves with, right? It goes to the fact that if you are in a field or in an area that the president believes is important to the country, then he could basically he could do things that would be a great help to the U.S. And then, as I said, he's very concerned about his legacy. It could really help his legacy.
Right. Thank you so much, David, for that. And, I had some more questions from people who keep commenting on our groups and YouTube channel. So I think I would like to share that. But hold on, not this one. Okay. So this was on nationwide protest on Canada 2 months back when they were talking about deportation. But if you find it relevant and if you want to take them up, you may want to give out some views or perspective on this. So when you apply as an international student in Canada, you are required to write a letter stating you will return to your country once you complete your studies. That was the agreement they signed.
Yep. Sorry, is there a question or?
It's just a comment. I mean.
Oh, yeah.
Then we have. Let me take this up for now. This is from Dixit, asking urgent. I went for my first H1B visa stamping yesterday and learned that my F1 visa was revoked. I was sent for second interview on same day, but my visa is cancelled. The interviewer told me that I was involved in a fraud with my first OPT employer. My other friends have worked with this employer, but they had no visa issues. Did anyone else? Do you want to say anything on this?
Yeah, I've seen this before. It's a scam.
Okay.
So what it is that I've had people consult me on this, and that is they get an OPT for an employer that they're not really working for. And so, but the employer says that they're working for them. And so, and they go ahead and they have their OPT, and then they can get the extension on STEM and things of the sort. But realistically speaking, they're not working for the employer, and either I think in the worst case scenarios, they pay the employer to basically say that. So, that unfortunately is a fraud scheme that I've seen before and keeps turning up. It leads me to believe that the authorities or the State Department or USCIS or CBP have been alerted to it and are now looking for it. So when somebody gets an F1 and they get an OPT and then they say, okay, I'm working for Mary's company, being a systems analyst or a software developer, and they're not really working for a Mary's company, they may be working at the Walmart or something of the sort, but they get that letter, and then when they go to get the H1, if they're picked, or they go to get a STEM extension, and it comes out, then that's pretty bad, because then you do get charged with misrepresentation, and you lose your ability to stay in the States and or go to the States.
Okay. Thank you so much, David, for taking that up. And now I have my next question, and that is also from this is with regard to the I-20. Got admission offer for spring, haven't filed I-20 yet. Now wanted to change my term to fall. At what point should I request for change of term before getting F1 visa, or after I get F1 visa? Or should I select defer in I-20 form to next term and submit and get confirmation from university for fall, file the new I-120 then, or submit I-120 for spring now, get visa, and then ask university to change term to fall? Which one of the options will be better?
So I need to see it. Can you make it bigger so I can read it? I can't.
Sure. This is, I think, how it goes.
Okay. So I'm going to do it myself here for a second. Sorry. Got an offer for spring, haven't filed it. Now I want to change my term to fall. At what point should I change? No, don't go to the consulate if you're not going. Should I select defer in I-20 to next term and submit? If conference or submit I-20 for spring. Well, I would advise, this is my opinion. And again, it's not, I can't give you legal advice, but if you got admission to the offer for spring, and when you say file your I-20, or you mean going to the consulate, I'm assuming. Now, if you're changing fall, don't go to the consulate with an I-20 saying you're going to spring term, because that's misrepresentation. You're telling them you're going to it and you're not. So in the I-20, when you go to submit, get confirmation of the fall, fill in, yeah. I would get a proper I-20 for the session you're going to before you go to the consulate, and then apply to go for that session. I wouldn't go at all. I wouldn't play with going to, especially now. I wouldn't go to the consulate with an I-20 that has a different session than you're actually going to attend.
Okay. Thank you so much, David. I think that will be very much helpful. Thank you for that advice. And now I'll quickly take up my next question. And that is, my wife got admission in MBA in US. Should we apply F2 visa for spouse and kids along with her F1 visa application in one go? Or after she gets F1 and lands in the United States, then we apply for F2 visa?
It's a very good question. I get this a bit in the sense, what strategically is probably the better way to go. Either way, they're going to be looking at it in the sense of temporariness of intent, right? So if you're going to your MBA, and it depends, realistically, this is going to sound, not fair, but it isn't. It depends where you're applying from, and it depends on your monetary situation, and it depends on the circumstances surrounding yourself. Meaning, let's say you you apply from a country that the U.S. has, their statistics show that people don't come back or they stay, and meaning you are not from a family that is wealthy or you have wealth, and in that regard, it's again, it doesn't sound good, and it kind of makes people say, well, why can't I go if somebody else goes? But the truth is, if you're applying for a visa and the consulate is convinced you will return to your home country, or you have the resources to support yourself and go to your home country, they're going to be a lot less restrictive. So to your question, if somebody's applying for an F1 and the F2 and for your spouse and children, you can all go at the same time if you are confident that you are from a certain situation that make this, again, less restrictive. If you go separately, it's no guarantee that your spouse is going to get it if you didn't all go together. I guess my point is that I don't know if it makes too much difference. I think what matters most in that circumstance is whether or not you are of a certain individual or person that the consulate is confident that everybody will come back. So in the end, if you are from a certain strata that unfairly is treated a bit differently, then you can all go together. If not, then you can go separately, but it doesn't mean that your spouse and kids are going to get the visa if you go separately. You're still going to be subject to those issues and that kind of scrutiny.
Thank you so much, David, for such a truthful opinion and help. Thank you so much. I wish I knew this participant's name, but it's anonymous post. So thank you so much for taking that up. Now, moving on, this is my next. This is hi guys. I need your suggestions. I am admitted to UT Dallas for masters with a scholarship. However, I realized that I could have applied to UT Austin, Rice, UIUC. However, my visa is scheduled later this month. Do you guys recommend me to defer it and apply to these universities? Is it worth it? Or should I just go to UT Dallas?
Yeah,
What do you suggest?
I don't think it much matters, to be honest. I don't know that it matters. Somebody asked a question about, do you expect positively, negatively affecting any policy?
Yes, Hari Guru, let's take that up. Yes.
Okay.
Thank you.
Yeah, I don't know, to be honest with you. I don't see anything. If you are in valid status and you have the 485 is a change of status, by the way, and then you've made application to change status and you're in valid status and you're doing everything right, I don't know that it'll affect it negatively or positively. I don't think it'll affect it at all. I think it's being slow as it is. To your point, you've been there for 3 or 4 years waiting for your priority date. So I guess only negatively if they decide to slow down processing instead, which they have the ability to do. So if that's the case, then sure, that's negative. But in either event, if all things being equal and they're not looking to cause trouble to people in that situation, then I don't think I think it's a neutral answer. The only way it will affect negatively, as I said, if they decide to slow down processing as a means to limit immigration, meaning they don't have to change legislation to change processing and the law and how many people come, because they can make it more difficult within the parameters and the tools that they have already.
Okay. Thank you so much for taking that up, David. And now I have another question. This was on our YouTube channel. This was asked by Vijay Kumar. I am on my F1 visa OPT and recently got approved for H1B I-797B consular services. Since I am in US and working for employer on OPT, can my employer refile for new I-129 as change of status so that I can continue working on H1B and no need to travel for stamping? Thanks.
Yeah, they could, but I'm curious as why they didn't. To be honest, I mean, I don't know why they wouldn't. To begin with, there must have been a reason necessarily. The second is that even if you do get you change your status, you can't travel at all unless you get that visa. So once you get a 797 and you don't have a change of status, then you have to travel to the consulate that you need to go to even to travel. So it probably wouldn't be a bad idea to do it, to be honest with you. I would go and do it, especially if you get the approval and you were in the States and you went to school in the States. There's no temporary intent for an H1. So that's a good thing. So you don't have to satisfy that. So the only thing they could really refuse you under is if they think that it wasn't a real job offer, or you don't have the qualifications or things like that. But given that you went to school in the States, given that you work for the employer in the States, if it's real, then I wouldn't be afraid of the consul.
Okay. Thank you so much for taking that up for Vijay Kumar, David. And I think we'll just go on with one last question. And I think that should be, let me just see if this is the one. Or I think we've taken up all of them for now. Yes, but if you want to give a view on this. Hello, in my case, I have an F1 status to H4 status. I am in USA, but I just have the status, not a visa stamp. Would this process... be the same for me? And once I upload my documents, do I need to keep studying during the processing time?
So if they've already changed their status to H4, they don't study at all because they can't. They're on H4 unless they get approval to do it. But that's what I was just talking about, in the sense that they have a visa, they have status, so they can't go anywhere. And until, I mean, you're changing status from F1 to H4, and they're asking, okay, well, can I keep studying? Do you have to keep studying? No. Are they studying? I mean, did they finish? You know what I mean? Every situation is as it is. If they are still in F1 status and they file the change of status to H4, realistically speaking, they should stay in F1 status until they get an approval to H4, right? They shouldn't. So should they, if they're supposed to keep studying? Yes, keep studying. If you are done, then you nothing to study. So you are in that status until you change your status, until you get an approval to change your status. By just filing the application to change status does not give you the new status. So you have to wait until the new status is approved before you can do whatever you want to do or not do whatever you want to do. In this case, not study. And in terms of travel, correct. They can't go anywhere. And if they do, they need a new visa.
Thank you so much, David. I mean, that was really wonderful, taking up all these questions so patiently and giving us all your point of views and expert advice, I would say. So thank you so much. And maybe we could wrap up if you want to say anything about maybe AI or these latest things that are trending right now, technology-wise or student-wise. And maybe even Akshay's last question. DHS says you can use STEM OPT twice. Please confirm.
Yeah, actually, do you want to contact me on that? Because I want to look at something. So if you want to contact me, I'm happy to answer it. Okay.
Absolutely. And so, yes, David, maybe you would want to say anything with regard to AI.
Well, it's funny. As I said, I'm dual licensed in Canada and the U.S. And Canada uses AI a lot in adjudication. And frankly speaking, I hate it. It's just because what happens is that if anything is out of the ordinary, it picks it up. Meaning, if you have a difficult case, and then it makes it more difficult. It goes to the officer becomes increasingly suspicious. And when the officer becomes increasingly suspicious, they're harder on the case. And AI as well is refusing a lot. Refusals have gone up, I think, by 12% using AI. So the US isn't quite there yet. It isn't really using AI per se, but it will. And I can only say that when they start using AI, refusals will rise. Because just psychologically speaking, right? If you get a case as an officer and you adjudicate it, fine, that's great. It can be a yes or no. And then when you have AI, if AI says, yeah, you should approve this case, you should approve this case, you should approve this case, you start to rely on it. But then when AI takes a case and says, well, there's something different here, you should look at it, the officer's perspective right away becomes negative, thinking, well, why didn't AI approve it immediately? And so that creates a harsher result, in my opinion, with regard to adjudication.
Thank you so much, David. Really such a great session. I wish we didn't have to wrap it up as quick, but thank you so much. And folks out there, do contact Attorney David Garson, and maybe when you do, let him know that you found him here on Immigration and Jobs Talk Show, and tell him about your case, and maybe for sure he's going to be happy to help you. So his email address is david@garsonil.com, and his website is www.garsonil.com. So definitely go visit and contact David. Thank you so much, David, for doing this today.
Pleasure. Have a good day.
You too, have a good day, and I hope to see you again very soon.
Thank you. Myself as well.
Thank you. Thank you, David. And folks out there, thank you so much for joining us once again. It's really lovely that you did. And please do not forget to like, share, and definitely subscribe to our channel. It's Immigration and Jobs Talk Show. You can hit that bell icon so that, whenever we have sessions like these, you are notified. And definitely, if you resonated and if you think that your friends and folks out there can also resonate with this kind of content, don't forget to share, please. And also, my Number is where you can also contact me on WhatsApp. This is my number, 408-335-6444. You can also email me. My email address is nipa@staffingly.com, and go visit www.staffingly.com to get to know more about us. Thank you so much for joining us. Y'all out there have a great day and a splendid week ahead. See you again. Stay tuned to Immigration and Jobs Talk Show.
A big hello and a warm welcome to all of you to Immigration and Jobs Talk Show. I'm really happy and thrilled to have each one of you join us. I'm Nipasa Pradhan and I'm going to be your host for today's session. And we are streaming live right now on YouTube, LinkedIn, and Facebook. And before we start with our webinar today with our guest, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, very, very thrilled today to be here with all of you to explore this topic that impacts countless lives out there and the future of our workforce. Definitely, today is election day, and we are looking ahead to ask, what will US immigration look like in the next 5 years? I'm sure this is very, very exciting, overwhelming for all of us today. And with so many recent changes today, we are going to discuss and basically talk about what does America's future look like. And joining us today in an expert with decades of experience in immigration law is, for the first time, joining us here on Immigration and Jobs Talk Show, none other than Mr. Charles Cook, who is the founder and managing partner of Cook Baxter LLC, where he leads the firm's global immigration practice. So it's really very, very exciting and such an honor to have you with us here, Charles, today. Thank you for joining us.
It is a joy to be with you today. Thank you so much. What an exciting day in the United States.
It is, it is. And I'm sure, I mean, you are a new face in our channel, but folks out there know you and they would love to know you better. So could you please tell us more about yourself?
Well, thank you. I'm actually the former national president of the American Immigration Lawyers Association, otherwise known as AILA. I'm also a founder and former president of the Alliance of Business Immigration Lawyers. I've been doing immigration law for 36 years. You can tell by how old I am and all this gray hair. I've represented more than 75,000 people in their immigration journey through all types of immigration, not just H1Bs and labor certs and Ls, but literally everything from asylum to adoptions to naturalization. I've done it all. Including lots and lots of federal court litigation. I am one of America's leading immigration lawyers in the area of litigation and bringing justice to people whose cases have been pending for a really long time. I've also done a lot of lobbying in Congress. I've testified in Congress a couple of times. And I do a lot of commentary on the Twitter machine as well as it relates to immigration. But most of all, I am the grandson of immigrants. I grew up in an immigrant household, obviously not from India. Obviously, look at me. My grandparents are from Germany. My dad's first language was German. He was born in Brooklyn. I was born just over the river in New Jersey and spent my growing up years there living in my grandparents' house. And today, as quintessential American story, I don't speak German. You're
Okay.
I speak Spanish fluently. So quintessentially, I am the American experience. I mean, you look at me, I know I look like, well, he looks like an American. And in reality, I'm the grandson of immigrants, like everybody here in America is. So for me, America is a very special place. It is a place where you can truly make your dreams happen regardless of who the president is, just sometimes it's easier than other times.
It's really, truly an honor and a pleasure to have you here with us today, Charles. You look vibrant and radiant and so full of knowledge already. I'm super excited to have you burst out whatever you've got to say today.
I
Thank you
should
so
be
much.
nervous because of the election, but oddly enough, I'm not nervous about the election. I have a feeling of confidence in a good outcome. So it's where we stand.
Definitely. So, what can folks out there who have joined us expect from us today?
Well, let's talk about what immigration is going to look like. Obviously, where immigration is going depends on who the president is. Now, keep in mind, only Congress can change the law. And the law is 40,000 green cards in EB3, 40,000 in EB2. That's the law. No president can change that. Presidents can change interpretations of the law, however. So, for example, a long-time interpretation of the EB1, EB2, EB3 numbers is that it includes family. So it's not 40,000 EB3s a year for 40,000 workers. It's only 18,000 because the average family size is 1.1. So the numbers are drastically reduced by counting family. That is an interpretation of the law. It can equally be interpreted to say, no, it's just people. Congress clearly didn't think that only 18,000 foreign nationals should get a job and a green card in America each year. It's a silly interpretation. But that takes a president who believes in it to get that interpretation changed. So a lot of what's going to happen in the next 5 years really depends on who's at the helm of the USS United States. And so today is the election. And although I think something like 73 million Americans have already voted early, America's very weird on elections. There's not just an election day. It's an entire season that starts 3 weeks before the election. And Trump's been campaigning since he lost the last election. So a lot will depend on what happens today. We don't know the vote total. So 73 million people have voted, but we don't have any idea how they voted. They don't release those numbers until after 7 p.m. Eastern time, which is tonight. I'm on Eastern time in the United States. They begin releasing the vote tallies from those that close. And each state controls when their polls close. Sometimes it's 7, sometimes it's 9. Sometimes judges order they stay open because there's long lines. American elections are a mess. But here's what happens. If you're elected, let's say Trump wins, he doesn't become president right away. He doesn't become president until January 20th. That's when our presidents are sworn in. So Biden would remain president really for the next almost 3 months, and then Trump would take over. Same thing with Harris. And we're not going to know tonight it's possible we know tonight, depending on where Georgia goes, where Florida goes. But unlikely we won't know until 2 o'clock in the morning, 4 o'clock in the morning, when we get poll results out of Wisconsin, Pennsylvania, and really further west out in Arizona and Nevada. We don't know. I mean, it's just literally a toss-up. Every pollster says 50-50. One thing I will tell you this. Our law firm, we have 45 folks that work here. 40 of them can work and can vote. 40 of them are citizens. And every one of them already voted. Every single one. That's highly unusual in the United States. And they all voted for Kamala Harris. And that should tell you something about where we think and who will be a friend to immigrants and who will not be. I see far too much on the Twitter machine from folks from India who think that somehow Donald Trump is going to be really good on immigration. And Nabasa, that's just not going to happen. The very first plank in his platform on immigration is, day one, issue an executive order that children born in the United States to parents who are not citizens themselves are not citizens, which of course is illegal because we have a constitutional amendment that says they are, but that lets you understand who he is as a person and what he believes about immigrants. Now, while Donald Trump hates immigrants so much, I don't know. He married 2 of them. Once again, immigrants doing jobs Americans won't do. Pretty
You
funny.
don't know
And
why
of
is
course,
it so
Kamala is, her mom's from India, right? So she is half Indian. She is the quintessential American. Dad from Jamaica, mom from India. How does that even happen? How do they even meet? So, and the thing about Kamala Harris is that she actually understands immigration law, which is crazy. Very few presidents do. But she has delved into the area. She was involved in it as a lawyer. She was involved in it as a prosecutor. And she was one of the best friends that immigrants had when she was a U.S. Senator. So she gets it. Now, unlike Biden, honestly, he's a nice guy. He's a nice old man, and he saved us from Trump. But he doesn't get immigration. He was never, ever, even when he was in the Senate, he was never good on immigration. He just wasn't. And same thing with Obama. He was never good on immigration. So we have a lot of hope for Harris. But let's talk about these policies, all right? So in the United States, there are 4 ways that you can come here legally and immigrate. You can get asylum. It's not happening right now from India, right? You can win the green card lottery, which of course India can't participate in. And you have employment/investor immigration and family immigration. Now, family immigration itself is pretty fixed, delineated by Congress. Congress has written the laws. There's not much you can do as a policy perspective on family-based immigration, except you can do what Trump did the first time, which was stop adjudicating cases. I know that because I sued him hundreds of times for not adjudicating cases. They just don't do them. They just put them in a box and don't do them. So you have to get courts to intervene. So that's all they can really do. On employment-based immigration, however, there's a lot of bad things that can happen in a Trump administration and some good things that can happen in a Harris administration. So, for example, if Trump is elected president, one of the things that could easily happen on this employment-based immigration stuff is he can get rid of STEM OPT. So you're in the country, you're in a STEM field, STEM OPT gone. They are definitely going to do that. They're going to publish a regulation. STEM OPT is gone. One proposal written by Vice President Vance when he was in the Senate actually bars anyone from immigrating under EB1, extraordinary ability, or EB2, national waiver, until they have lived outside the United States for 10 years after they graduate from a U.S. college. That would be crazy. That would eliminate a lot of people, including many Nobel Prize winners, from getting green cards in the United States. They can change how the H1B lottery works. Right now, this next year is the first year of the higher fee, $215, I think. And you're gonna pick by the foreign national. So you, not your employer, but you are going to put in for the H1B. Whereas what Trump will do will say, no. H1Bs are by bidding. It'll be like the eBay of H1B. Who will get paid? We will give H1Bs to the highest paid people. That was his proposal last time. They just didn't get it published in time. That's going to be published in February of 2025. We're going to see drastic changes to the L visa program, where they're going to make it very hard, not that Biden hasn't done a terrible job with the program anyway, but make it much harder to prove who's a manager or executive. H1Bs are already now more limited under the new Biden administration. They're going to crack down on what jobs require degrees. One of the things that's been happening in the United States over the last 10 years is there's been a movement away from requiring degrees for jobs that have historically required degrees. A great example is a software programmer. Why do you need a bachelor's degree to be a software programmer? You don't. Heck, look at all the people losing their jobs because AI is doing it, right? So a lot of negative things can happen in a Trump administration on employment and family-based immigration. Now, Harris, on the other hand, obviously will keep keep in place the program for STEM, obviously, probably expand it to a certain extent. But what she will also do is look at the H-1B program a little more critically so that it works more effectively for the United States. Because she's a prosecutor, I think they're going to go after job shops, companies that just throw in thousands of applications for visas that don't really have work for them. Or where they abuse the employee and say, we're not going to pay you. I think there's going to be a massive crackdown under the Harris administration for H-1Bs in that regard. I think we're also going to see some attempts to change some of the interpretations of how regulations work. We're also on family-based immigration with her. The new Biden family parole program will keep going if we win the court case, which is today, by the way. And I don't think a lot of people in India realize this, Napasa, but there are a lot of undocumented Indians in the United States. Do you realize that? There are a lot. There are hundreds of thousands of Indian nationals in the United States who do not have immigration status, who came as students and overstayed, who came illegally. Hundreds of thousands. Many of them are helped by the Biden family parole program. And so I think that will definitely continue if we win the case today. Literally, the hearing is today on whether that program is legal. I think it is legal, but we'll see. I'm not the judge. So a lot of these key immigration issues will be drastically impacted negatively if Trump wins, and not at all, or positively if Harris wins.
You're absolutely right. I mean, if Trump or, they have similar stances like what you have just said, and on immigration, everything is going to be heightened with a lot more scrutiny and stricter enforcement. I think it's going to be even more hard with regard to immigration, for sure. But thank you so much. I mean, those were great insights. I mean, so much in the first 15 minutes already, so much processing and so much happening, I'm sure.
There's so much going on. Now, one of the questions you gave me was on, what is going to happen today? All right. So I don't know. I mean, I'm not a prophet, but I will tell you
discuss on the questions, but I think I'll just quickly say hi to our folks who already have questions, and you might see some of the comments
I love
popping up there. Right. So big hello to Anjali and Luan, Dial, Luca. I think we should pick up a few before we go
that's
on
great.
with our
Anjali's got a great question here. How might the election outcome impact the likelihood of establishing a pathway to undocumented immigrants? Well, I think you hit the nail on the head. If Trump is president of the United States,
Anjali, we're taking your question.
There is 0% chance that there will be anything to help undocumented immigrants. 0%. In fact, there will be a crackdown, as he has promised, to deport 11 million people. Now, that is a great way to destroy an economy. That's how it works. You want to destroy an economy? I don't know if you know this or not, but we've done this before. This wouldn't be the first time. We did this in 1957 and 1958, and 1959, 1960, on something called Operation Wetback, which today is, of course, a slur. Back then, we deported over 1 million Mexicans who had come to the U.S. during World War II to work in our fields and work in our factories while we sent men abroad to fight. Eisenhower created this, and we deported over 1 million Mexican men and 500,000 U.S. citizens. So it's not like the U.S. is fully capable of doing stupid things, which then led to a recession. Because that's what will happen. So, yeah, there's nothing coming from this. Now, Harris, on the other hand, has said repeatedly she voted for bills that were pro-reform when she was a senator. She will advocate for them. And think about this. This is actually really important to understand. Biden was always walking a tightrope on immigration because he wanted to run for re-election, and he knew he was running against Trump, who was anti-immigrant. If Harris wins, there's a whole new dynamic. Trump's not running again because he's probably going to be in prison. So he's not going to, I mean, maybe not. Maybe she'll pardon him. But he's not running again. So, and I believe that as Trump is defeated, so will we defeat this anti-immigration rhetoric. So it puts her in a much better position to work with Congress on not just passing this border bill on asylum that she says she'll pass. By the way, that bill would never pass again unless you add in some sort of legalization and take away the per country limit. Increase, and it's not just, hey, taking away the country. I mean, I've been an advocate for hey, the limit's the limit, and that's it. And people have really ragged on me about that, because if you're going to take the women away for employment, you got to take it away for family. But that doesn't solve the problem, right? Because all that does is share the pain, right? And now,
it's not proportionate. It's not
no,
proportionate
and now that ROW is the same, is terrible too. You have to increase numbers. You know, if I've got a lot of clients who applied for their green card in 2012, 2013, 2014 from India, and they're not getting a green card for another 10 years, 15 years. Even if we reduce the number, even if we said, okay, everybody, Indians can get them all, it's still 20 years. And then that cuts the rest of the world off, which makes no economic sense to anybody. So there's a really good thing that would come from a Trump defeat, is that would be defeat for anti-immigration forces. That would relegate them back to the ash heap of history and would embolden the president, I would hope, to work with Congress and look, let's fix this problem once and for all. We can do that. So there you go.
Thank you so much for taking that up for Anjali. Very passionately answered, I would say. Thank you, Charles. Well, let's go on. We have a lot of comments on LinkedIn as well. So let's take this Luan Dial, if I'm pronouncing it right. Do we pay for visa or trips when we get jobs in USA?
Well,
Okay.
That's a great question. And the answer is no, you should not be paying for the visa. So let's say, I'm going to assume you're talking about the H1B visa. So the H1B visa, the employer is required to pay for that, the lawyer fees and the filing fees. You also should not be paying an employer for the job. That if immigration knew about that, they would deny the visa. I can assure you. I know people do it, but it's and I can't tell you it's illegal. I can tell you that immigration thinks it's fraudulent. But the trips, the airplane fares, that's on you, unless you've got a really good employer. I mean, that's been my experience. You got to differentiate out the visa fees, the lawyer fees, and then travel expenses are different things.
Thank you for taking that up for Luan Dial. Thank you for your question. Now let's take up Luca. This is on today. Trump's advisors are already preparing massive cuts to legal immigration as soon as he enters office. That's what we were discussing. And everything from families and refugees to skilled workers is threatened. Economic insanity. What do you have to say about this comment?
What do I have to say about that is 100% accurate. Keep in mind, on refugees, there were essentially no refugees that came in 2019 and 2020. None. And keep in mind, that was when there was massive refugee crises abroad. Remember Syria? People forget about Syria. Germany took in 1 million Syrians. Not us. Not the Great White Hope. Not the Statue of Liberty. Not under Trump. So, yeah, it's America will revert to a 1924 close the borders, shut the system down kind of country, and we will enter a massive recession, the likes of which we probably have not seen since 1929. That's a reality. And then tariffs on top of that, which of course are taxes on U.S. citizens. So there you go.
It's crazy what can happen today. But what do you think? I mean, let's take on when can we expect the election results to be out?
That's a great question. So in some states, so America has 4 time zones. I don't know how many time zones India has, but America has 4. How many time zones does India have, Napasa?
One.
You have one? You have one time zone?
Just one only.
That's crazy. It's a huge country.
It is, but we are under one time zone.
We have 4. So we have East Coast, Central, Mountain, and Pacific. What that means is, and about about 70% of the population lives on the time zone Eastern, on the Eastern time zone, up and down the Eastern seaboard. Those polls, no election announcements are after the first polls close. The first polls close at 7 p.m. in some states. Some close at 8, some close at 9. Some states like Florida and Georgia count during the day, and then you will get initial results, especially on early votes, right at 7 o'clock. And but you won't get final results for Florida and Georgia until 8 or 10 o'clock at night, maybe midnight. States like Pennsylvania will give you initial results for maybe 20% of the votes at 7, but you won't get final results till 2 o'clock in the morning. Some states, we already know who won, like New York. Harris is going to win New York. All right, she just is, because that's just the way it is. I mean, it's most of the states in the Northeast are going to go for the Harris. So these swing states are what matter. So I have a home in Tennessee. Tennessee is red. It's as red as red as red as red. Trump wins it. So, and then you move every hour more in the night, you get the next set of polls. So this, if you've never watched an American election result, go online to one of these news sites like CNN and watch their video, because it's just fascinating. By the time California, and I will tell you, Western time zones, the last time zone, Pacific, we call it Pacific time, California, Washington, and Oregon, Hawaii, Alaska probably go Trump, but they don't have a lot of power. Hawaii will definitely go Harris, California Harris, Washington Harris, Oregon Harris. Then there's Arizona, which is the only other state in the Pacific time zone. They're a toss-up state, but the election may well be decided by the time their polls close, which are at 11 o'clock Eastern time. I will likely be in bed because I like waking up at 2 in the morning and seeing what the results are, or what they aren't. I will tell you this: in 2016, Florida reported at 8 o'clock, at 9 o'clock, that Hillary lost. I went to bed because I knew the election was over at that point. She was the first Democrat to lose Florida. If she lost Florida, she lost the election. Now, that's a different thing today. Now we know Florida is going to go Trump. We know that. So we don't really care about Florida's result. It's Georgia, Pennsylvania, and Michigan, all in the Eastern time zone. And then Wisconsin in the Central time zone. And if or North Carolina as well. If she wins 3 of those states, she's won. It's over. It's just over. And then the rest is just gravy. So that's kind of what to look out for.
Great, but still, then, so that's what we are expecting, folks out there. And I know how exciting this is and overwhelming at the same time. But I hope you're all vigilant and doing the right thing and practicing your right. Well, we have Bikram's question now. This is also on LinkedIn. We should take this up. But Charles, who is better precedent for tax cut for green card holder and citizens?
Well, if you're a billionaire, Trump. But if you're not a billionaire, not Trump. It's Harris, because Harris is not going to tax anybody. Taxes are going to go down for anybody under $400,000. Now, I know that sounds like a lot of money, and it is a lot of money. I get it. But in the United States, there are millions and millions and millions of people making more than $400,000, and billionaires that are paying essentially no tax. So she's going to go after very, very rich people. If you're, the average, ordinary American green card holder, citizen, Harris is your best friend on tax cuts, because Trump only wants cuts for the rich people. And that's you can Google it. It's a proven fact that the people that benefited from his tax cut were, in fact, people that were billionaires. I will tell you this, something that a lot of people don't realize, Napasa. If you're a green card holder in the United States and you die here, basically all of your assets are taxed at 50%. Whereas if you're a citizen, there's a $4 or $5 million exception. So if you're a green card holder and I don't really want to get a citizen, and you've got assets, you're a fool not to naturalize, because your relatives that you leave behind are going to be paying a lot of taxes. Just FYI.
Thank you for that very important information, Charles. I think that's a very important point you pointed out to be kept in mind. I think we should take up some of our questions now, Charles. Yeah. So
Okay.
let's go with mine. How might the election outcome directly impact key immigration policies such as family-based and employment-based
Oh,
visas?
we talked about that. I talked about that for the first 10 minutes. I mean, the
Yes,
reality
okay.
is there's going to be impacts either way, but Trump, they're going to be mostly negative, and with Harris, they're going to be mostly positive.
Right. Well, and now let's take up another question. Let's take up Vikas's question.
Oh, I
This
love
is on
Vikas's
YouTube.
question. This is a
Yes.
great question. Great question.
Right. Indian Americans have historically favored the Democrats, but there has been an incremental shift in the community's voting behavior in favor of the Republican Party this election. Do you agree? And what,
Oh,
according to you, is making this change, Charles?
well, this is 100% true. We've seen a lot of Indian Americans that favor Republicans. And that's because Indian Americans are very entrepreneurial. They are the wealthiest immigrants in the United States by far and away, wealthier on average than many native-born Americans. And that's just reality. And when you have wealth, you tend to go towards the Republican Party. Because historically Republicans have taken care of wealthy people, and Democrats have historically, and I'm talking since about the 1960s, not before. Before 1960s, it was reversed. The parties kind of switched positions, and Democrats will kind of focus on the poor, the disadvantaged, and help people, which means taxes. You got to take money to pay for that, and so we've definitely seen that, which is with Trump kind of an irony. Because he clearly does not like immigrants. It's just clear he doesn't like them. And so it's just, the irony doesn't escape me, but it's absolutely true, especially over the last decade or so. And I would think that if Republicans had nominated a normal Republican who actually believed in Republican policies, because in many respects, Trump's not a Republican. He was a Democrat most of his life. Did you know he gave Kamala Harris $2,500 when she was running for Attorney General like 15 years ago? Yeah, he was a Democrat for most of his life, so he's not really a Republican. But the reality is Republicans tend to be more favorable towards businesses, and that's why.
Well, thank you. Thank you so much for taking that up. And Vikas, such a lovely question. Thank you for participating. You can keep commenting if you have any further questions. Let's get back to Luan Dial. She's back with another question. I applied for a job in U.S.A. New York, and they told me that I must pay for work permit. Is that legal?
No, that is quite illegal. And in fact,
And that's
if you really want to
ethical as
burn
well.
it, make a complaint to Wage and Hour. Go online to the Department of Labor, Wage and Hour, H1B complaints. Just Google that and file a complaint against this employer so they stop doing this.
There you go. There is a permanent solution to that. Thank you, Charles.
I like this question. Go to this question from 1233. It's a great question.
Let's take this one.
It's a great question.
Anonymous, I wish we knew the name, but yes, we have seen a lot of reduction of tech jobs, which was caused by mass layoffs in the last 2 years. Which candidate could be the one trying to get back those jobs and stabilize the job market again?
Well, you have to ask yourself, this is a great question. Why were there layoffs? Were there layoffs because the economy reduced? No, the economy's growing like crazy. We're at 3%, worldwide envy for the growth of our economy. The problem you have with a lot of these tech jobs is they can be done by AI. This is a problem. This is a big problem for tech. I don't think either president is going to say, you can't use tech to do this work. Let's use Elon Musk as an example. Elon Musk buys Twitter and eliminates, 80% of the people working there? Now, initially, that meant the platform was garbage, but now it works again. What do you think the lesson learned from big tech was? You don't need all these people. And I'm going to tell you, tech jobs in the United States are not necessarily the future. First of all, you're not going to be able to get, within about 10 years, H1Bs won't be available to many tech jobs. They just won't be, because we won't be able to prove that you need a degree to do the job. So the reality is, I don't think either president is going to do anything to stabilize the tech market, because both presidents, to me, seem all in on technological advancement. Maybe the better question is, how are they going to help people who are displaced by modernization, mechanization, and AI? That's the better question. And the only party thinking about that is Harris and the Democrats. Republicans are like, well, go shovel poop at the chicken house. That's what they think. Go find a job somewhere. Whereas the Democrats are planning for that with retraining and rehiring and things like that. So Democrats, I think, your only option in that respect. Now, keep in mind, I'm a lifelong Republican. I've got a picture of Ronald Reagan hanging on my wall over here. But the reality is, the party of Ronald Reagan is dead. It's gone. That's the reality.
But I mean, too much of everything is scary. I mean, look at technology advancement; it's scaring us now.
Well, I could be talking. In a year, I could be talking to AI for this interview, an AI video, right?
Yeah, they will need me.
You can
And
go
who knows?
online.
You would have an AI version of yourself doing your job online.
Yeah, I mean, you could just put me as an avatar, and they're talking to me, and they talk about that. There's no doubt that that's the future. If we can build enough power plants, we have to build more power plants. So that's going to happen. But the reality is, what does that mean for human beings? Does it mean that we're all going to be online playing video games all day long? Or does it move us to the next level? Hopefully it moves us to the next level. I'm a big Star Trek fan, so I believe in the future. I believe in the future. These things make us better. So there you go.
Definitely. Thank you. And Lawandile is back with saying, thanks, Charles.
You're welcome.
And we have another question. Do we have to pay for anything when you meet all the requirements for the job after the interview?
No, you don't pay for anything other than your plane ticket. No.
I think she's making her budget, but definitely thank you for your question.
Wanda, don't be deceived by this. The internet in the job market is full of scammers. It's full of scammers. And sometimes you just hire a lawyer, have a consult with a lawyer who's got a good reputation, so you can get an answer about something's real or not. That is not real. That is a scam. Don't do it.
Now let's take up Shubham's question. There are two parts to this. Could the judiciary overturn immigration reforms passed after the 2024 election, potentially influencing policy implementation and enforcement?
Well, the courts do not overturn statutes in immigration law. There's actually, I'm actually a law professor in my free time. I've been teaching for 25 years at Emory Law School. And the courts have a doctrine called the plenary power doctrine. What that means is that when Congress legislates on immigration, that's it. That's the final word. The courts will never overturn an immigration statute. What they will overturn are executive branch or presidential policies and regulations. And we have a very conservative Supreme Court that is not necessarily friendly to immigrants, but generally speaking, they have not been super hands-on on immigration policy. For example, DACA is a great question. I mean, they could have ended DACA years ago and they didn't, because they realized this is going to hurt people. So could they overturn it? Yeah. I mean, they let a Muslim ban stand, right? The Muslim ban stood. So I would not suspect there's going to be a lot of overturning. And there's been a couple of recent cases out of our Supreme Court that limit different parties' ability to actually sue, whether they have what's called standing, whether they're actually allowed to sue, and then what jurisdiction the courts have over those cases. So there's a lot in play there, but I don't see them invalidating any congressional reforms. I do see them playing a hand in permitting some regulatory policy changes.
And he was continuing to say that the federal courts, including the Supreme Court, have the power to review and invalidate reforms deemed unconstitutional or non-compliant with existing laws.
Well, yeah, they clearly have that power in certain circumstances. There's actually an immigration statute that limits the power of the courts. Our courts what's called jurisdiction is defined by Congress. It's not defined by the Constitution, except as it relates to constitutional matters. And immigration issues are rarely, very rarely, constitutional, except when it comes to things like immigration detention and some deportation contexts.
Right. Thank you so much, Charles, for taking up all these questions. And thank you, folks out there, for participating. Keep commenting. We're really happy to have you participate. And maybe, Charles, you could tell us more, since we were talking about DACA. What could the election outcome mean for DACA recipients and other undocumented individuals who are in the U.S. currently?
DACA, if Trump wins, DACA's gone. It's gone. It's history. It's over. He will end it with a regulatory publication in February. It's gone. If Harris wins, it's still kind of hanging in the ether sphere. It's still kind of, and there are something like 50,000 DACA recipients who are Indians, from India. So it's not, this doesn't just affect Mexicans. There's a substantial number of Indian nationals who have DACA. Right now, DACA exists for people that received it before September 2017. Biden republished DACA and allowed new applications between January and May of 2021, but then a court stopped it. And that case has been ongoing now for 3.5 years. And there was oral argument in the Court of Appeals of the Fifth Circuit last month on DACA. That court will likely find that DACA is illegal, but will allow DACA recipients to keep renewing. And then it will go to the Supreme Court, and we will get a decision probably sometime in late 2026 or early 2027 from the Supreme Court if Harris wins. The hope, of course, if Harris wins, Congress just says, look, if you've got DACA, first of all, the youngest DACA recipient today is 22 years old. 22. The oldest DACA recipient is 42. These are no children. These are not children anymore. These are adults, many with families, many with kids, and it's just time. They're not going anywhere. This is their home. Fix the problem. The refusal to fix this is not just frustrating, but it's immoral. This is a morality issue at this point. When people have spent essentially their entire lives in the United States, deportation becomes banishment. It becomes maybe an unconstitutional punishment for them. And, an argument we can go into in the future.
And I mean, there's so many families who are breaking apart just for this reason, and it's so sad to see.
So I had 2 consults this morning for 2 people who had criminal convictions, unfortunately, both long-term, one from Vietnam, one from Mexico, long-term residents of the United States. They got addicted to drugs. They made some bad choices. They're gone the rest of their lives. They're never coming back ever. Ever. Our immigration laws are mean. I don't know if you've ever seen the play Les Miserables. Les Mis. I don't know if you've ever seen that play. It's a great story. And
I think it's Black Man, and it was like a musical. Right?
The story of Jean Valjean, who represents mercy, and Valjean, and then Javert, who represents justice. Our immigration laws were written by Javert. They're all about justice. There's no mercy in our immigration laws, and that's what makes them so terrible.
We have Shubham back again. He has another question saying, thanks for taking my question. I would also like to know, how will the outcome of the 2024 U.S. presidential election impact the future of immigration courts and the processing of asylum claims?
Well, there's a lot of Indians that come to the United States in the last couple of years seeking asylum. Honestly, I don't know where they're seeking asylum from. I don't know. Good question. I don't want to be in a pro-growth country. I don't know. Something. But our asylum system is completely broken. We have two different asylum systems. We have a defensive asylum system in immigration court, and then we have an affirmative system with the Immigration Service. There are over 1.6 million asylum cases in the affirmative part of the process. There's only 300 officers. 10 years. If you file today, 10 years before you get an interview. If you're in immigration court, There are over 3.5 million cases in immigration court. We have 675 judges. So if Trump comes in, they're going to want to hire judges. But here's your question. Who wants to be an immigration judge? What kind of person do you have to be that would enjoy the job that requires deporting people? And you have to be a lawyer for 5 years. I'm not sure there are enough lawyers willing to sell their soul to do that 24/7. That's just awful. Harris wins. The reality is, they will find more positive judges who will want to grant asylum and work these cases more efficiently. But we're never going to be able to deport our way out of this problem. And of course, if Trump really does win and want to deport people, you just can't pick people up you can't pick them up on the streets and deport them. If they've never been in proceedings before, you actually have to put them in front of a judge. And now you have 3 million people in front of you. That's why I said the system is entirely, completely, and utterly broken. There you go. All right, any more questions?
I think we'll quickly go for a short break and be right back. And by then, we'll take up a few more questions, Charles, if that's fine. Welcome back, everyone, to Immigration and Jobs Talk Show. I'm Napasa Pradhan, and this is the second half of this webinar we are having today on Election Day. What will U.S. immigration look like in the next 5 years? And we have with us none other than the very, very amazing guest for today. We have none other than Charles Cook. Thank you so much for this very insightful webinar so far, Charles.
My pleasure. It's great to be with you today. I love talking immigration.
Absolutely. And so are viewers out there. They have such amazing questions. It's really lovely having your questions and have you participate with us. Thank you. So, Charles, I think, yes, we have Luandi thanking you. Thanks for the eye opener, Charles. Thank you. Well, I think I would have this next question. If you can tell us, how might enforcement priorities at agencies like ICE and USCIS shift depending on who is elected?
Well, for USCIS, it's really important to understand that Trump has promised through the individuals in his campaign who have immigration background and will work in the agency that every application will have to go through a fraud review and supervisory review before approval. That's not currently happening. That will slow things down to a crawl and will result in a lot of false claims of fraud by the Immigration Service, because they are notoriously bad at identifying fraud. So it's going to be very, very slow at USCIS if Trump wins. I don't expect any changes if Harris wins, other than hopefully getting better management. Immigration, the USCIS is so terribly managed right now. They basically promote from within, so they don't really have people that have outside business type of experience, how to run a large organization. And as a result, they're really bad at their job. ICE, on the other hand, as for the last 4 years, they've kind of just been twiddling their thumbs like this, waiting for the chance to deport people. So ICE, which we call ICE, will be very proactive in looking and searching out people with removal orders and working with local police as they arrest immigrants for various crimes or driving violations and put them in removal proceedings. It's going to be big changes for both agencies.
I would also like to know, what impact could this election results have on the backlogs? I think that's what most of us are concerned about. And also the visa bulletin and family-sponsored visa categories.
Well, of course, the visa bulletin is constrained by the law. Only Congress can fix the visa bulletin. It can't be fixed by anybody else. So you could, as I mentioned earlier, the administration could reinterpret who is included in the 40,000 in each of the EB3 category, EB1 categories, to only include actual workers. They could do that. I'm not sure they will, but they certainly can do that. We tried to get Biden to do it, and he wouldn't bite. But I don't think he had the right people on the bus. I think we might have better. I know the person currently advising Harris on immigration. He's fantastic. And I think we've got an in on getting that interpretation done. But as far as the other aspects of immigration, Trump's going to make it worse. The backlog you have today will be much worse under Trump. And Harris, keep in mind, Indian nationals have a friend in the White House, right? How does it get better than that to have someone with an Indian mom in the White House? It doesn't get any better than that. And she loved her mom. So I think there's going to be a movement, and I think we will see aggressive movement by the White House to kind of cut back on that backlog and increase legal numbers. But ultimately, it's Congress that controls it, not the president.
Definitely, but I mean, America being land of immigrants, I think we are so much excited to know what changes will happen in the immigration front, and I'm sure that's going to be a lot.
Rich guy. Well, all I can tell you is what should happen, not that it will happen. I mean, I've been fighting for immigration reform since the last time Congress destroyed our immigration area in 1996. So it's almost 30 years that I've been going to Congress every year, lobbying them, talking to senators. The thing is, most of them know what they have to do. They're afraid of losing an election if they help immigrants. And that's why defeating Trump is so important, because it will allow us to throw that anti-immigration rhetoric out the door, out the trash can, and embolden some Republicans to say, I love immigrants, like George Bush always did. I want to fix this. So that's what will happen.
We really need some solutions for so many of these loopholes to be covered and be fixed as soon as possible. But definitely talking about those, the visa bulletin, the dates changing, I don't know when will that happen. But yes, we have some comments. Let's take up Dheeraj from LinkedIn. He's asking, will there be any effect on H1B holders after the elections?
Not after the election, but if Trump wins after he takes office in January, you will see rapid changes to how immigration works. I would suspect they will immediately republish their rules, which I was one of the lawyers that beat back the rule on prevailing wages. And they will publish right away, probably with immediate effect for the March lottery, the H1Bs based on job income, so that people with the highest salaries will get H1Bs. I think that will be an immediate thing in February and March of of 2025 if Trump wins. If Harris wins, you won't see any changes. None at all.
Thank you, Dheeraj, for your question, and thank you, Charles. It's been lovely having you. I wish we didn't have to wrap up so early, but I think this is it. And thank you so much for joining us today. But before we leave today's discussion, if you could leave all of us, especially our viewers, with an end note, it would be great.
All I can tell you is this: America is a great country. It's a great place to live. It is land of opportunity for immigrants. One of the things I've dedicated my career to doing is helping immigrants achieve that American dream. Not everybody can come legally. Not everybody has that opportunity. Not everybody's got a degree. Not everybody's got a relative here. Some people come seeking refuge, and that's okay too. America's got room. We have room to grow. We have room to be. The only thing we have to worry about in America is if people stop coming here. People stop coming here. We do have massive problems. But until then, until we talk again, good luck. Pray for America tonight. Pray for a Harris win, and we'll move forward.
Thank you. Thank you so much, Charles. It was really lovely having you. I'm really looking forward to having you back as soon as possible for such passionate discussions on immigration. Lovely having you. Have a great day ahead and enjoy your day ahead.
Thank you. Bye-bye.
Bye-bye. Thank you, folks. Thank you so much for joining us here on Immigration and Jobs Talk Show on today's discussion on Election Day. So who is going to win and what is the next 5 years going to look like on the immigration front for the US? Well, I think we'll just have to stay tuned, and you have to stay tuned on Immigration and Jobs Talk Show because we are coming up with a lot more updates on today, Election Day. Thank you so much for joining us. This is Nipasa Pradhan saying bye for now.
Hi everyone, welcome to Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and before I move ahead, let me very quickly read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to Immigration and Jobs Talk Show. I'm your host Rajni Bharara, and today we are diving into a timely and relevant topic, especially as we are on the cusp of a pivotal US presidential election. The upcoming election could dramatically reshape US immigration policies, making it more crucial than ever for startup founders, entrepreneurs, and tech innovators to understand their visa options. For many, the H1B has been the traditional route, but as we know, that path can be limited. So today we are exploring alternatives and uncovering solutions that might be better suited for startup founders looking to build their vision here in the United States. I'm thrilled to introduce our guest, Alyssa Hussain, who brings a wealth of expertise and insight to our discussion. Alyssa is a business and employment-based immigration attorney who represents companies and individuals seeking temporary or permanent legal status in the US through employment, trade, or investment. Her background is impressive. She has experience working with multinational technology companies, growing firms, and innovative startups. Alyssa's approach is all about strategizing with clients, guiding them through each stage
See, I'm so excited to introduce you that I've started fumbling. So I'm really sorry about that. So Alyssa's approach is all about strategizing with clients, guiding them through each stage of their immigration journey with dedication and passion. She earned her honors Bachelor's of Arts from the University of Toronto, majoring in gender studies, political science, and history, and holds Juris Doctor degrees from both the University of Windsor's Faculty of Law and Detroit Mercy School of Law. Licensed in Michigan and Ontario, Alyssa has handled complex immigration cases across Canada, the US, the Middle East, and Asia. Her work has spanned roles on the US immigration team at Deloitte with boutique firms specializing in startups, and now she's leading her own practice focusing on TNs, H1Bs, O1s, EB1s, and NIWs, which is national interest waivers. So without any further ado, let me not fumble anymore and welcome Alyssa Hussain on Immigration and Jobs Talk Show. So Alyssa, very warm welcome to Immigration and Jobs Talk Show. This is your first time. How are you feeling?
I'm feeling good. Thank you for the very warm welcome. I'm excited to be here and excited to kind of share as much knowledge as I can.
Right. And, Alyssa, this topic is pretty unique and a little different than what we usually do. So what do you think? What can people, what would you like to say? What can people expect from today's episode?
Yeah, I think there's, a common perception that in order to work in the U.S., to gain permanent residence in the U.S., that you need to have an employer who's willing to hire you and sponsor you. And the purpose of today's presentation is to focus on kind of taking control of your own immigration journey, and especially for those who want to be entrepreneurs and run their own companies, and also take control of their immigration journey into their own hands instead of being tied to employers, which for many immigrants, especially born in certain countries, including India, those wait times, those like dependence on your employer can be very challenging in terms of making life decisions. And so, yeah, I hope that this information is helpful in the sense of being able to recognize that there are other alternatives available, and kind of taking control of your own immigration journey.
Right. So, being an entrepreneur in your own country is so difficult because being an entrepreneur and starting your own startup, it's a difficult path than usually opting for a job because that's the most conventional way, right? And this is a little different than what usually people do. But if then trying to make it in a different country, in a foreign land, it must be so much more difficult than the normal path, right? So, what kind of cases have you handled? Let me just start with that. And how difficult is it for people to actually make it into a foreign land and build a successful business or a startup?
Yeah. I actually think that, I'm obviously biased, but I think that my foreign founder clients are, because they have so much more to navigate in terms of not only are they starting a company in the US, which is already challenging to begin with, they are, the odds are set against them in having to additionally handle US immigration, which has a further impact, right? When you're dealing with, fundraising and talking to potential investors, you also need to be able to explain to them that you're not an additional risk, when they're doing their due diligence. So if anything, I think that foreign founders are the most equipped to handle, growing successful businesses in the US because they're just already faced with so much adversity in additionally having to navigate the US immigration side of things. In terms of the types of clientele I work with, it really ranges. I have people in tech. I have clients who have started retail companies. It really is so industry wide. It ultimately, which I think really allows for a lot of opportunity, and really is focused on people's plans and career goals and what their long-term plans are. So I think that in some way it is, US immigration is very limiting, but on the other side of things, I actually think that it is also, there's like the world is your oyster in terms of what you want to pursue and how you want to pursue it. I think top advice I give to all my clients is as soon as you want to start your own company, I would say try and understand the US immigration side of things simultaneously while you're kind of thinking of your long-term strategies for your company, for yourself, and your long-term plans, because there is a way to align those. You just need to think strategically about it sooner than later.
Right, right. I mean, that's a great advice. But also, is it easy for a particular startups or a particular type of companies to make it, and in comparison to other kind of businesses, like maybe like you mentioned, tech companies? Is it easy for them in comparison to the ones who are making maybe getting into a restaurant business, or
Yeah.
different businesses basically?
Yeah, I would say, there's no one route that's easier than the other. It again is very case specific. But in terms of for professionals, those who are kind of pursuing a tech company for the most part, there is an easier sell in the sense of it's less of an investment, right? You don't need to make as much purchases in physical premises, in inventory. So in terms of like the cost perspective that you would need to demonstrate to the US government that this is a real and operating company and that it will be, you need to show that you have put enough into it to demonstrate that it'll get there. And that's harder on the more brick and mortar side of things. But that doesn't mean it's not impossible. There's other routes. E2 visas are generally more recommended for restaurants and for more of the brick and mortar companies versus like an O1, but that doesn't mean it's not doable. It's just more challenging, but yeah, I think that answers your question.
Right, right. It does. It does. Thank you so much for getting into it and answering the question. Now, let me quickly, get into my questions that I've prepared for you. So, my very first question to you is: so, what key trends do you see in U.S. startup visa programs compared to those offered by other countries?
Yeah. So I obviously focus on U.S. immigration, and most of my clientele are startups. I'm also licensed in Canada and am involved in some Canadian cases as well. I think the current climate of immigration, at least for the past 6 months, probably because of upcoming elections, because of economic, in terms of economies kind of struggling right now, there seems to be a tightening of immigration, at least, when it comes to the US, when it comes to Canada. But that doesn't mean that, you can time the system and necessarily wait it out, because I think there's no way to really kind of figure out when is the best time to pursue US immigration, and even international immigration for that matter, when it comes to investments, because, when you start your own company, everything's not going to align at once. I think it's really about paying attention to your company, what your goals are, and then using that to inform your decision about strategizing on the immigration front of things. So in terms of key trends, within the US, there's been, I think people are fearful of what's going to happen with the new administration and how matters are going to be adjudicated. And so there's been an influx in filing of cases. And so with that means that there have been more requests for more evidence. In terms of denial rates, I think I haven't in my own practice seen an increase. It still seems very, standard, based off of what I've seen. But again, that's my sample size. But I do see immigration on the Canadian side of things where there are changes constantly happening, and it does seem like they are limiting immigration because there was in the past few years there's been an influx, and so they're trying to limit that. They also have an upcoming election as well, so these are considerations in terms of kind of how these programs are adjudicated or available. But on the US side of things, these programs don't really close down, right? The legal framework of temporary work visas and the green card routes have been available since the 90s. What changes is USCIS's guidance on how they're adjudicated, the reality of how they're adjudicated, and the types of evidence that can be used. So, particularly, we'll dive into this later in the section too, but in terms of for startups, USCIS has kind of broadened what H1B founders and O1 founders can do to demonstrate that they meet the requirements so that they can sponsor themselves as a beneficiary through a company that they own. And their framework has allowed for this. However, that can change because of the political landscape or because of a change in administration. So these trends are, I think, always moving, but for the most part on the US immigration side of things have stayed fairly consistent. It's just how we need to document the eligibility that kind of has changed.
Right, right. So, but do you think, have you noticed that maybe the recent US policy changes has influenced, the attractiveness of the startup visa for international founders?
I don't know if it's just an increase also of people starting their own companies. I think there was some statistic, and I don't quote me on who published it or where it was from, but I think it was post-pandemic where people really did start to take control of their own, just like their own employment overall, and did start to pursue, entrepreneurship. And I think that with that also means that immigrants are part of that conversation. And as there is, an increase in investment, the US obviously wants that investment to be inside the US. And so as they kind of open up these programs, and guidance on how they define the eligibility criteria, I think that has allowed for more startups to kind of pursue these routes with a little less challenge than they were met with before, because there was less clarity in the law. But that doesn't mean it wasn't happening. I think that USCIS has kind of moved with how the adjudications were going and provided clarity on this is permissible, to kind of make it more clear to founders that it is doable and that they likely will, so long as they meet the requirements and can demonstrate such that they will approve those applications.
Right, right. But then, also I would like to know, Alyssa, that do you think that there are specific sectors? I asked this question, but still I would like to know that. Do you think there are specific sectors like maybe tech, biotech, where other countries are outspacing the US and attracting founders through their visa program? Because we recently had an attorney from Portugal, and we spoke with her regarding golden visa, and then we also have golden visa in I guess Dubey, right?
Right,
so yeah. So do you think that is also happening?
I think that the US market is very unique. There's always, everyone's going to always want to enter the US market, even if these other countries are available. I think that for periods of time, the availability in these other countries may be, based off of people's life situations and their choices, that those may be options that they choose over going to the US. But I think that, it's one of America's, everyone just, not everyone, but there is always going to be this market of wanting to grow your company in the United States, to be able to kind of grow to that next level. So I say that to say that even while international countries are kind of opening up in their investment visas and even in their nomadic visas for freelancers, as we've seen an increase in, especially since the pandemic, as people are moving abroad and wanting to live internationally and work remotely. I think that there is and will continue to be a US market for startups. And I don't know if the opening of those programs has necessarily impacted the US immigration side of things. But that's, again, just my opinion, right? Like that, yeah.
No, of course. People can choose whatever countries, but they're always attracted to US. That's absolutely true. And
Yeah.
but then, could you provide like an example of a particular country that you feel that you must have noticed, notable success with startup visa program that you would want US to learn from?
That's a good question. I actually think that I'm not too well versed in the other programs, but it seems like for the most part, if you have sufficient funds, you can, they're kind of framed in that way that if you have sufficient funds, you're going to put that money at risk and purchase either a property or a business in these respective countries, that is leading to a side of permanent residence or just residents in general in those countries. And I think that there's also been some pushback from what I understand, again, not licensed abroad, but I think that the EU overall has been kind of looking into these programs specifically because there's some countries like Portugal that have opened up investment because of the nature of their economy and wanting to increase more international movement into their country. But then the rest of the EU isn't so open to those, everyone having access to those open borders. So I think that in some ways it's been working, but I feel like they're also kind of narrowing it down now in a way that is a little limiting. Whereas the US has just been fairly consistent. And if anything has made it a little bit more difficult, right? I don't handle too many EB5s, but obviously like that pathway to an investment green card essentially is a very high threshold. It requires a large investment financially. But for the most part, most of the clientele that I'm dealing with are eligible for other work visas and even green card routes that don't require a huge financial investment. Those who can do it and generally and are eligible and have the funds available to do a 1.5 million plus investment, they will, right? That's the route that they're going to take. But I think that there are opportunities in the US based off of the current current work visas and green card routes that allow for little to no investment, but still a clear trajectory and plan of what that company and investment will be in the US, which is in some way an opportunity, but it is also very limiting because you need to meet certain eligibility criteria, right? Like for an O1 visa, it's great, but only if you can show that you're of what the USCIS defines as extraordinary ability. And sometimes that doesn't make sense in certain industries, right? Someone who is maybe pursuing retail or is pursuing a restaurant business may not have these particular awards and have earned this, a certain salary or have scholarly articles. Like it's very academic focused in terms of how it's been framed. So I think for those in tech or who come from a professional background, it does seem easier and that there are more routes available. Purely investment routes do require a little bit more of a financial commitment to have that opportunity in the US as well. But I do think, right, that if the US kind of lowers that requirement of what kind of investment is needed, it will open opportunity for more investment into the US. I just don't know if they're going to be open to that.
Okay, okay. I would also like to tell you, thank you so much for answering the question. A lot of people have also joined us and they are constantly posting their questions. If you can see, let me quickly say hi to them. Dharmesh is here, Ishani is here, and I'm also getting questions on WhatsApp. So hi guys, a big hi and a hello to you. And thank you so much for your question. We'll be taking them in a bit. But before I take your questions, I would again like to tell you that we are live not just on YouTube, but also on LinkedIn, Facebook, Twitter. So make sure you subscribe to us. The handle is Immigration Talk Show. And yes, you can also, post your questions on these platforms too with, of course, YouTube. So we'll be taking your questions in a bit, but before that, let me again discuss a few questions with Alyssa. So Alyssa, you mentioned different visas. So now let's discuss those visas which are for startup founders. So what are the key differences between O1A visa, EB2 NIW, and EB1A visa for startup founders, and which one would you recommend for someone just starting their business in the US?
Yeah. I really like this question because I think it allows me to also clarify something where I think sometimes people have a common misconception is that green card routes are very different from temporary work visa opportunities. And so from the three that you listed, right, there's O1, which is a temporary work visa, and then EB2 NIW, which is the national interest waiver, and EB1A, for those of extraordinary ability, is an eligibility criteria for a green card. So when assessing which one to pursue, I think it depends again on the circumstances of the founder's situation, but ultimately the EB2NIW and EB1A are more long-term plans. They don't provide any work authorization in the US. So if you are abroad and you're not inside the US and you've already started your own company, but you know you eventually want to grow into the US and you don't have so much of a quick timeline on your hand, like an immediate rush to go to the US, then pursuing an EB2NIW or an EB1A, depending on, you know, your eligibility and demonstrating that, which we can kind of dive into, is a good idea, especially for people who are born in India, because wait times are very long for green cards for Indian-born nationals. And it's based off of country of birth, unfortunately, not on citizenship. So even if you did become a Canadian citizen, that won't really open any opportunity for a shorter queue for the green card. So what you do by kind of getting to this sooner than later is you are locking in what's referred to as a priority date. And your priority date is what determines when you can eventually apply for your green card. So locking this in sooner than later shortens your wait time for eventually securing a green card. I say that to say that if you are, you know, if you have a quicker, if you need to be in the US immediately and you want to start working on your US based company, then you need to secure underlying work authorization, which includes an O1 visa. There are other work visas that are options as well, which can be H1Bs, L1s, E2s. I think these are the 4 main ones that my startup clients will pursue in terms of underlying work authorization, while simultaneously either building up their profile to be eligible for an EB2NIW or an EB1A, or pursuing that and submitting that application while they're growing their company inside the US. So in terms of which one is the best, it'll be very, you know, case specific. I would say that, I mean, for people who aren't too familiar with the eligibility criteria, an O1A visa, you need to have a petitioner, which can either be your direct employer. It can be an O1 agent, which is a US citizen who kind of oversees your work and will be authorized by a lot of gig workers will use that. So they have like existing contracts and they freelance. And so the clients that they freelance with are willing to authorize this O1 agent to petition the O1 visa application for the individual. And then the third option is to have a US entity that you own petition you for your work, which is the startup founder route. You can, you know, have a co-founder depending on your circumstances, or you can have a majority stake in the company as well. And there's certain requirements you need to meet to demonstrate an employer-employee relationship, which we can also dive into on this session as well, because I think that's the biggest crux of eligibility for these work visas that is specific to founders. But not only that, you then need to demonstrate that you are of extraordinary ability, which high level is, you know, layman's terms may mean something different to everyone, but USCIS clearly identifies what those 8 criteria are. You need to meet a minimum of 3. And for different founders, for different industries, the types of evidence that we can kind of submit to demonstrate that you meet this criteria varies. Like I said, the regulations and the law is written in a very academic nature. So it's pointed towards, you know, there's a criteria for scholarly articles, but someone who is in an entire, I'm trying to think, who's in retail, right? And in design, I mean, they may have written scholarly articles related to design and while they were in university or pursued academia, but for the most part, that's not the case. So really, it's about delving into what your industry is, the nature of your startup and your specific work, and then how you can use your experiences to date to demonstrate that you kind of have this corroborating evidence in those criteria. And so that's the O1A. In terms of the green card routes, then the O1A criteria is very similar to the EB1A criteria. Instead of 8 criteria, there's 10, 2 more that are related to arts. And it is a way higher threshold. For an EB1A, you don't need an employer to sponsor you, so you can self-petition. It is a first preference employment-based green card route, which also means that priority dates for green cards are a lot. It's a much shorter wait time. which is why they are very heavily sought after. But meeting the threshold for an EB1A is a very high standard. And so generally, based off of my client situation, we'll get them going on the O1 and we'll come up with a game plan of how to enhance their profile so that they're EB1A ready in the next year or two, depending on, you know, where they're at with their application at that point. We kind of do an assessment, we work together and identify what is feasible with their career. You know, sometimes getting publications going takes a long time versus one of the criteria is peer review. So that requires less work in terms of having to sit and publish content, but it does require more networking and engagement in the industry. So we kind of strategize on what makes most sense, because you're also creating and growing your startup at the same time. And so there's only so much you can do while also pursuing your goals, right? You get so focused on the US immigration side of things, and then your company fails because you're just so focused on that. So it's really an alignment of understanding this is a long-term journey, but it's doable, and it's really about being as targeted as possible in your approach. And then the EB2NIW has been a great route, I think, again, for the last 6 months in adjudication for both EB2NIWs and EB1As. There's been an influx of people just applying to get their foot in the door. And not all these cases are viable cases, unfortunately. And so it's kind of backlogging the system and making it difficult for people who actually have viable cases to get approved, and it is increasing RFEs. And so, but like I said, you can never really game the system and figure out a best time to apply. If you are in a position where you are eligible, I would say still go for it. Work with an attorney who knows what they're doing and will work with you on kind of presenting the best case, but be prepared to be met with potentially an RFE, to be met with a bad adjudicator who may deny, and you may need to refile or you may need to litigate. The system, unfortunately, is not the best system, but there are mechanisms to kind of eventually get there. It's just, you got to be committed. But the EB2NIW, just like high level, is demonstrating that you're going to be pursuing a proposed endeavor. Technically, this endeavor doesn't need to be clearly defined, but it won't be approved if there isn't clarity on what it is. So you need to identify what your proposed endeavor is, and then on top of that, demonstrate that it is in the national interest of the U.S. so that they can waive the labor certification process, which is the more classic employer sponsorship route for green cards. The EB2NIW also allows for self-petition, so you are not tied to your employer, which allows for greater flexibility too. But there are like additional eligibility criteria, but just high level in terms of whether you're selecting to pursue the EB2NIW versus the EB1A. EB1A has a higher threshold. Most people who will pursue EB1As are primarily Indian borns, because for an EB2NIW, if you are eligible, wait times for a green card aren't ridiculous, and you will, be likely eligible in the next few years to be able to either adjust your status or get a green card. So, and if you did pursue the O1 or any other of the startup visas, be it through an L1 or an H1B, you likely have at least 2 to 3 years of work authorization while you're waiting out for your priority date from your green card to be current.
Right, right. And also in cases like these, the role of the right kind of attorney for you also comes into play, right? You should have the right attorney to help you with your case, right? So guys, if you're looking for an attorney, and if you have a startup and if you want to get a visa and if you're looking for an attorney, so you can get in touch with Alyssa. Here are her details. You can email her on info@crossingfrontiers.ca, info at crossingfrontiers.ca. I want to spell it right so that people can note it down. And also, you can also please visit our website, which is www.crossingfrontiers.ca. Yes, do visit our website, and also you can write to her. You can email her. And now, Alyssa, so Thank you so much for that detailed answer. So I would also like to know for you, for founders who are early in their careers, so which visa option would you recommend for them so that they can that would offer them the most flexibility to pivot or expand their ventures?
Yeah, I think it is, like I said, of the main four, the go-tos, it really is dependent on, the nature of how they're kind of developing this startup in the US. And then there's also some like case specific based off of nationality for the E2, for example, versus if this is an intra-company transfer where someone has their startup that they started abroad and are now bringing to the US. So those are all considerations, but I'd say high level, like the pros and cons of the four, I can kind of go through those. Like for the O1, a huge benefit is that, there's no limit on how many times you can extend. You first can get up to 3 years, and then technically every time you request an an extension, you can only get one additional year each time. But if something major has changed in the trajectory of the company, we can kind of file this as a new employment. And so we can request 3 years on an ongoing basis with that. So the benefit of an O1 is that you're not limited in number of years like you are with many of the other visas, including H1Bs and L1s, which are limited to 6 years for an H1B and then 7 years for an L1A or 5 years for an L1B, which can be quite limiting. That time goes by so fast. So that's a benefit of the O1. A downside is that your spouse doesn't get work authorization from you having an O1 visa. They would have an O3, which has no employment associated with that. They would need their own employment visa in order for them to be eligible to work. And that is quite limiting for some families who both spouses do work. In terms, again, another limitation of the O1 is demonstrating that you're an extraordinary ability and that you meet that criteria. But I do find that many founders actually do not realizing that initially. So I would say, do your research, look online at the criteria, at the 8 criteria. You probably will check off at least 2 based off of, like, think deep about it, about your portfolio, about things that you've done to date. And most clients, when they come to me, at a minimum, have at least 2. And then we kind of work on pulling their profile together, seeing if we can kind of reach a 3rd or a 4th, or, I give them like a 3 to 4 month time frame. And I'm like, okay, focus on these ones and then come back and we'll reassess. So that can be limiting because you need time to do that and you need authorization to grow your profile if you're in the US. So you need a backup visa or something else that's keeping you inside the US if that's your plan and you need to start working immediately. So that is a limitation. In terms of H1Bs, they are beneficial in that you don't need to demonstrate this extraordinary ability. As long as your role is in a specialty occupation and that you will be paid the prevailing wage and you can demonstrate that need, then it's sometimes easier to meet that criteria as a founder where you are quite early stage and haven't built up your portfolio so much. However, there's limitations to this. You need to be able to have enough funds to pay yourself the prevailing wage. For the O1 visa, there's no minimum amount that you need to pay yourself. Generally, we recommend, obviously, making sure you're compliant with local employment laws and all of that. But, you can pay yourself a larger portion through equity. And that can kind of, offset paying yourself a little less and demonstrating to USCIS the nature of your work, which is very common for founders. So the limitation of the H1B is that you are, the Department of Labor has to, approve, and you need to demonstrate that you're going to be paid at least the prevailing wage of your occupation based off of your geographic area, which can be quite limiting. But there are strategies around this. Instead of submitting a full-time H1B petition, you could submit a part-time one where you'll pay yourself hourly and within a range of hours that you disclose in your application. So some clients will do that. They'll start off only working 5 to 10 hours a week as they're growing their business, and then they will add on longer periods of time or switch to a full-time H1B once they have sufficient funds for that. Like I said, a downside of the H1B is you're limited to 6 years. Time spent outside the US can be recaptured into that 6 years. With one exception, under AC 21, if you meet any of those requirements, you can extend beyond the 6 years, but that is if you are pursuing a green card route. The other thing is that spouses cannot work, H4 spouses cannot work unless you have an approved I-140, which is the green card pathway. And then that will allow for work authorization for H4 spouses, which again, pro or con, right? Another pro of the H1B is that it's a dual intent visa. So for most US temporary work visas, they are non-immigrant intent, except for O1s. They're kind of quasi non-immigrant, quasi dual intent, but the rest of them, like TNs, H3s, these are all non-immigrant intent, which means that you cannot have the intent to permanently immigrate to the US. However, H1Bs and L1s are dual intent. So if you have a pending adjustment of status for your green card, that won't implicate your intent issues with your underlying work authorization. So there's some benefit to that as well. And then in terms of L1s, so that's like, again, very case specific. You need to, high level, there's more eligibility criteria to it, but you need to have worked for your foreign startup, or it doesn't have to be a startup, your foreign company that you own abroad for one full continuous year in a managerial or executive capacity for an L1A. And then you open up your US operations and you keep your foreign operations going. And so you have hired a team out there who's running the foreign operations, and then you start up the US operations, work for it for one continuous year in a managerial capacity or executive capacity as well. That not only gets you a work authorization, which is the L1 visa, you also may be eligible for the EB1C, which is a green card route, which is like the EB1A is a first priority. So it's a good strategy for some Indian-born nationals to kind of take this route towards a green card that may be more plausible with their long-term plans. So sometimes that's a strategy too for founders. If you are willing and open to starting your operations abroad first and then coming to the US, then that's a route as well. I would say L1s are very USCIS kind of digs deep into them. You need to demonstrate the eligibility criteria. Our fees are very common. It's better if the individual moving is a professional in some capacity. The nature of their work will be professional. Doesn't mean it's not doable for others in terms of like a restaurant. It just is a little bit more challenging. You need to demonstrate more. USCIS asks for more supporting evidence for that. And then for the most part, you need to be able to demonstrate ability to pay, unlike for the O1. So you need to show that there's funds in the company that can pay you. And then for the EB1C, especially, that you will be able to pay yourself up until you get your green card. So you do need enough funds, which can be limiting. But an L1, like I said, is a dual intent visa. So that's good. Spouses get an open work permit based off of the primary applicant having an L1. So that's a benefit as well, because if your spouse will be working, then they're not tied to an employer except for to your startup, and probably just dependent on their spouse, but that's another story. And then the next one is the E2 visa, which is a very common investment visa. The limitation of it, well, there are a few, but the main limitation is that you need to be a citizen of a treaty national country. So you can look up the treaty countries. Canada is on that list, but India is not. But so a lot of people who have immigrated to Canada and have now attained their Canadian citizenship, which is a way faster process than it is in the US, can then do an investment into the US through an E2 visa. There's no minimum investment. Generally online, you'll read that people recommend $100,000 minimum. This is not a threshold that the US government has set. It's not a real threshold. I would say $100,000 plus is definitely a case that may be an easier sell to the government, but I've had successful cases where they've spent $15,000 to $20,000. Ultimately, you need to put the money at risk. You need to demonstrate that the company you're investing in, either through a purchase or through starting on your own, is going to be, you show your 5-year plan, your business plan, that you're going to, make some US hires, that you're going to be creating enough income that's more than just to support your family. And that's kind of the threshold you need to demonstrate. And in terms of the amount of investment, it needs to be substantial compared to the nature of your business. So if someone is going to be starting a trucking company and only investing 15,000, that doesn't make sense, right? You need a fleet. You need to demonstrate that you have purchased some of these, that you have a place that you're keeping them, and 15,000 isn't going to cover that. So that's not realistic. Versus someone who has a tech company that's just starting with one computer and this software that they're developing, 15,000 may be doable. So it's really about spelling out the nature of the company, what the long-term plans are, and then there's a component of sourcing the funds, which is a part of the E2 visa, which is important. So depending on, you can get funds from, I was going to say anywhere, not anywhere, but it could be gifted to you from a family member. It could be VC funding. Ultimately, you just need to demonstrate that the funds were given to the applicant or the treaty national company, and that those funds are now at risk and being spent on the business. So that's kind of how we focus on the sourcing of it. And then for E2s, another benefit is that your spouse can also work. So of the 4, spouses can work on L1s and E2s in terms of the dependent visas, and sometimes on H1Bs, depending on people's green cards. But for O1s, they definitely can't. So these are all considerations based off of, everyone's, I guess, unique circumstances. So, yeah.
Right. Thank you so much for such detailed answer. Thank you so much for, explaining everything in detail. And that was really, really insightful, Alyssa. Thank you so much for that. So with that, I know a lot of people are waiting, and we also have to take the Facebook questions as well. But still, I would like to know one more question. So are there instances where a founder, might have initially opted for one visa, a type of visa, and then, after their business became successful, then they transitioned into and they opted for, a different visa?
Yeah. I've done a few of those. It's just all dependent on people's, situations. But like top of mind, would like a certain case stands out to me as someone who was on H1B. They were a founder. They started on a part-time H1B, and then they switched to an O1. And they did that because they were hitting their 6 years and they didn't have an approved I-140 at that point. So they were running out of time on their H1B, and they wanted to, and then they were eligible for an O1. So during that time when they were building up their startup, on a part-time basis through their authorized work on their H1B, they were profile building so that they could meet the O1 eligibility, so that they didn't have to leave the U.S. for that 1 year and then come back and be reselected in the H1B lottery. So it's very common. I think if anything, for the most part, I would say once someone is a founder and on an O1, they generally won't switch to a different one, because at that point, you have a little bit more flexibility, unless, of course, someone is looking for work authorization for their spouse, or certain circumstances based off of, if they have travel and they want to be on a dual intent visa while their green card's pending, then they'll kind of consider something else. But I'd say most founders, once they're on that O1 route, they're now focused on their green card application and know that they'll continue extending their O1.
Right. Okay. Thank you so much again for answering the question. Now, let me quickly move to our audience's question. So, Kalpesh is here from LinkedIn, and he says, interesting. Thank you so much, Kalpesh, for your comment. Let us know if you have a question, if you would like to know anything. Please post your question in the comments below, and we'll be more than happy to take it. So, let me start with Dharmesh's question. Dharmesh says, for founders seeking an E2 or L1 visa, how do you assess if the business and investment actually meet the minimum substantial or qualifying thresholds required?
So
we also have a part 2. I'm so sorry. We also have a part 2, and he says, are there common misconceptions about what substantial investment means? Okay, let's start with the first question.
Yeah. So in terms of substantial investment, that's required for the E2, not for the L1. But for the E2, like I said, I think we kind of did touch on this later on after Dharmesh posted his question. But basically, the investment needs to be, the argument we need to be able to demonstrate that the amount you're investing is reasonable and substantial for the nature of your business. So we would really demonstrate that through pulling your business plan, looking at what you have already spent on, and then the nature of your business. So if all you really need to spend in the next year is on marketing, and that's reasonably a few thousand, then we would demonstrate that that would still be that's all that is really needed for your company, because the product is already developed. It's already been, it's really, there's not much more financial investment that needs to go in order to sell to clients. But again, like I said, if you have more inventory and you need it for the nature of your business, then we need to show that that money is substantial for what it is. So there isn't a clear definition. It's about arguing to the officer why this investment amount is substantial compared to the nature of what you are going to be doing in the US. And then for the L1, there isn't a requirement of how much you need to pay yourself. Usually if it's on the lower end, officers will question how true and operating your company is if you're not paying yourself a reasonable amount. But for the L1, the focus is more on demonstrating your qualifying relationship between the foreign office, the US office, and then specifically with your managerial or executive role abroad and in the US, or specialized knowledge. So the focus then is on including evidence that shows that you have proprietary knowledge, or that you were leading a team, or you led a function of the organization. So that is kind of how that will be documented.
Okay. So Dharmesh, I hope you have got your answer. In case you have a follow-up or anything else that you would like to know about, please continue posting your questions. We'll be more than happy to take it. Okay, so Lasha is also here from Facebook, and he says, I'm already in the USA. I have a work in social. Can I still participate into green card lottery? And if I win, do I have to leave the country?
I actually don't deal with too many of the diversity lottery. I think he's talking about the diversity lottery green card, which I think just opened up last month. Don't quote me on that. I don't handle too many of those. So I won't be able to answer this specifically, but I would say kind of reach out to an attorney who does handle. I know that there's quite a few attorneys who specifically also only handle the diversity visa green card. So, like Rajni said, I think the focus on finding a U.S. immigration attorney is really, dependent on their area of expertise, which is unfortunate because you want someone to kind of assess all of your options. But some of us are very, I am very experienced in working with startups specifically and within these various routes. And so I don't do so much of the diversity visa green cards, unfortunately.
But Lasha, we do have a lot of shows with a lot of attorneys on our channel. So you can, definitely subscribe to our channel, and we'll be bringing a lot of shows, and you can, ask your question, and we'll definitely ask one of our experts and we'll reply to your question. But thank you so much for, posting your question. We'll be replying to your question after asking it from an expert. Now, let me quickly take Ishani's question. So Ishani is also here from YouTube, and Ishani says, a startup client is considering acquiring a US-based company with existing employees on various work visas. What are the key immigration-related due diligence considerations and potential risks we should assess to ensure a smooth transition?
Yeah, that's a really good question. You should definitely engage with a U.S. immigration attorney to make sure that prior to purchase, because you want to make sure that you've kind of done all your due diligence, which obviously you're trying to do as well. I would say focus on making sure that you have access to all the petitions that the U.S.-based company submitted on behalf of the employees, so you understand the commitment based off of financial commitment in terms of length of period of stay, if there's pending green cards. And then you also want to make sure that you do your I-9 and E-Verify compliance as well. If they have been compliant, for them to provide that documentation to you. And if they haven't, that you make sure you engage with an attorney so you can set up a system internally so that you can make sure you're compliant moving forward, and you can demonstrate that and paper trail that. Also, when you do the purchase, depending on the nature of it, whether it's a merger or acquisition, the nature of the employees' work visas, you may need to disclose this to USCIS just to let them know that there's been a change in ownership, but that's very case specific. So again, I'd recommend kind of engaging with an attorney to go through that with you, because you want an attorney's eyes on those, an immigration attorney's eyes on those petitions prior, ideally, to you purchasing over a commitment for foreign employees.
Okay. So, Ishani, I hope you have got your answer. In case you have a follow-up, please also post it. And thank you so much for your question. And okay, so Lasha is also back and he says, thank you so much. Of course, we are here to provide you information and provide you help. So thank you so much for being here. And let me quickly take Yuri's question now. And Yuri says, how do you evaluate the potential of visa options like the O1 or E2 compared to the H1B in terms of aligning with the startup's long-term goals? And then there's one more question. Then after you answer this, we'll be taking that.
Okay. Yeah, no, this is literally where I start off with my clients, right? If high level, they've consulted with me and we kind of know that they're potentially eligible for an O1 or an E2 and an H1B, then we unpack what makes the most sense based off of their plans. So if they already meet a lot of the O1 criteria, and then sometimes my recommendation would be to pursue that over an E2, because you don't have to put the money at risk yet. But if the nature of them, the startup, is that they're purchasing a company and the money's at risk anyway, then that may be the better route, because eligibility is for a longer period of time. If they do get married, or if they already are, then their spouse has that option. H1Bs are usually only applicable to people who have previously been selected in the H1B lottery, or are like simultaneously working with a cap exempt organization. So sometimes that's a limitation. And then at that time, I also want to know what long-term plans are. Do you want to pursue a green card? What are your plans? Do you want to change up your company? Are you going to start up a few companies? That's very common in the industry. And so how do we kind of want to frame your narrative for your green card application while you're pursuing your work option? So we kind of talk through that, and I try to understand your long-term goals and align that with what makes the most sense with the various temporary work options based off of that. And then also based off of adjudication at the time, right? E2 visas are not adjudicated for the most part by U.S.CIS. They're adjudicated by the consulate office. So you're going in for an interview and someone's deciding on the spot whether you're eligible or not, versus an officer in U.S.CIS who sits and goes through your documentation for days, right, or hours, and is really looking at everything very in depth. And so sometimes a strategy would be going to a consular office versus submitting it at U.S.CIS, and there's strategies around that too. So it is all basically, I say, short answer is it depends on your long-term goals and the nature of your investment and what you're trying to do in the U.S.
But and so what if they don't have long-term goals? They are looking for like quick advice or instant advice for just that moment. So how do you manage that?
Yeah, I mean, I go into my consultations being like, do you eventually want a green card? Because if we need to assess that. But in terms of if that,
everyone does, right?
Sometimes a lot of Canadian citizens don't, because there's then tax implications of having a green card. So, and the proximity and all of that too. Sometimes it's not the long-term plan. Sometimes people just want to work in the US for 4 or 5 years and then go back home to their home country. When people tell me that, I say, if you are eligible for a green card, you should maybe still apply and decide at that time if you want to proceed with actually getting the green card versus not. Because, being eligible is, not too many people are. So if you want, that's a good opportunity to have. But again, very, very specific to the situation. But I would say in terms of evaluating, I do on consultations, I will do like high level of collecting as much information through our conversation as possible and giving you my high level advice on what makes the most sense. I would say in terms of the O1, E2, H1B, like I said, there's all the pros and cons I listed previously, and it'll depend on, do you want to have to pay yourself a certain amount, right? With the H1B, do you want to put those funds at risk for the E2? Do you meet the eligibility criteria of the extraordinary ability for the O1? So if you meet all three of those, then it's a strategy of, okay, which one has better adjudication? Which one are you currently most prepared for? And likely, I'd say if you meet all three of those, the E2 is probably the better option. assuming you meet all three of those criteria. And of course, this is just, with as little information as possible on the circumstances.
Okay, and her next question is actually on the tax implications. So she says, please do discuss potential tax implications for investor visas. Also outline the application timeline and required documentation.
Okay, so in terms of tax implications, I am not a tax attorney or a tax professional, so I would recommend, because it's very specific based off of your home country and any tax treaties. So I would very much recommend that you speak to a tax professional on that. Like I said, there are tax implications for becoming a green card holder in the U.S. in that giving up your green card in the future or your U.S. citizenship in the future for tax purposes. So because the difference with the United States, this is, again, I'm an immigration attorney, not a tax lawyer, but just in terms of informationally, the difference with the United States versus other countries is if you move abroad, you still have to pay taxes to the U.S. government. So sometimes people will have, made a change in plans and they want to retire in a different country and they're still paying taxes to the United States. And so they may want to abandon their green card or their citizenship for tax purposes. And when you do that, you are, when you abandon your citizenship, the U.S. government will ask you if you're doing it for tax purposes. And then in the future, if you ever wanted to come back, that will implicate your U.S. immigration journey and options available to you. So that's a consideration in terms of once you are a green card holder and or a citizen. In terms of for the visas, the work visas, that is different. You obviously, when you're working in the U.S., you have to pay U.S. taxes. How that works with your home country and treaties will depend on where your residence is and based off of the nature of the country. So for that, I would say talk to a tax professional. In terms of I think this is about the E2, right? Outline the application timeline and required documentation. So documentation, for the most part, will vary based off of the nature of your business. I'd say high level, you need to be able to demonstrate that you have the formation documents, that you have the business plan, you have all of the source of funding documents, and then you need to demonstrate your eligibility, why you're best to kind of run this business, which could be your resume, supporting documents of previous work in the industry as well. And then for E2 timelines, they are specific to the consulate. So you submit E2 applications to the relevant consulate in Canada. That's in Toronto. They're the only ones that adjudicate the initial E2s. And the timelines vary, but generally what I've seen is that when you submit the application, you'll usually get an interview within about a month or two max. That can vary depending on how busy they are. And then once you go to your interview, if they approve your E2, they'll send you your passport within a week or two. So E2s, in terms of, I'd say the application preparation time is a lot longer, but once you submit it, it gets rolling a lot faster versus an L1 or an H1B that get adjudicated with U.S.CIS. And then if you need a visa, you need to go to the consulate or embassy and apply for that visa before you can enter the U.S. So timing kind of varies based off of your circumstances.
Okay. Thank you so much for that detailed answer. Alyssa, Yuri, I hope by now you must have got your answer. Thank you so much for your question. Okay, so Alyssa, it's already 1. We have crossed 1 hour mark, but if you have a little more time, we can discuss a few more questions because,
Okay, I can do a few more minutes, yeah.
Okay, great. Thank you so much for that. Let me quickly take Arjun Mehta's question. Arjun is also here and he says, what are the unspoken challenges of switching between visa types? For example, moving from F1 OPT visa to an O1 or an H1B. Are there risk founders might not be aware of when they ladder through visa categories like this?
Mm-hmm. It'll depend on, again, it's very important that you work with a qualified immigration attorney who's experienced in these, because what we'll do is we'll review to make sure that you were maintaining status in your previous visa status when we change status to one of the other ones. If there's a potential gap, while you were in F1, you were unemployed for a bit, but you went beyond the permissible time, and that may raise a potential issue, then we may advise to do a consular process for your application versus a change of status from within the U.S. So it's very important to make sure that your immigration attorney that you're working with is reviewing your previous applications, your previous status, asking you those questions. And another thing to consider for F1 to one of the other visas is that F1 is a non-immigrant intent visa. You need to be able to demonstrate that you maintained your ties abroad. It won't usually come up at the change of status to another work visa, but it may come up at the green card stage. So you want to make sure that you are keeping documentation of your compliance of all your visas in the US. Documentation of that is keeping records of when you attended school, that you attended classes, while you were working, your pay statements, when you switch jobs, make sure you just download them and save them somewhere so that when you're applying for your green card in the future, if any of those things are questioned, you don't need to then go back to your old employer. You already have it all saved. And if there were any gaps in employment, that you demonstrate the exact dates and documentation that demonstrates that, so that you can demonstrate that you were within appropriate grace periods and that you timely filed your next application. So that's high level, but again, it's very case specific. Biggest recommendation I give to everyone is keep documentation of your whole U.S. immigration journey, no matter what. It may never come up. You may never need to give it to you at CAS, but it's just the best way to be prepared for any potential questions.
Right, absolutely. And guys, if you want to get in touch with a good attorney for your case, so we have it right here. So you can get in touch with Alyssa. Her details are scrolling below, and also right there on screen. You can note it down. info@crossing frontiers.ca. You can write to her on her email, and you can also visit our website, which is www.crossingfrontiers.ca. Let me quickly take Rohit's question also. Rohit says, I have heard that national interest waivers and NIW can be used for founders, but what does a startup need to demonstrate in order to genuinely show national benefit or interest? Is there any practical guidance you can give on the merit of a tech startup here?
Yeah, so it'll really be about documenting the genuineness of your proposed endeavor. So letters of intent of potential clients you're going to work with, or if you already have clients for your startup because you have work authorization to work for your startup, including those. Including, for companies that are quite early stage, haven't really taken off the ground yet, I would definitely recommend including a business plan that clearly demonstrates what you're going to be doing in terms of staffing projections, financial projections. That's not on the national interest component, that's on the proposed endeavor component to show the genuineness of your company. But in terms of the national merit, the national interest component, you will really need to identify the market that you're going to be in, the types of clientele. So I'd say if you're in the semiconductor industry, and that's an industry that USCIS has clearly, loves for national interest. There's a lot of supporting evidence in that. So you won't need to, the argument will be a little bit easier in terms of demonstrating the national interest versus someone who, is in real estate and in one geographic area, and you could be probably in affordable housing, and that is a national interest argument, but is it siloed to one geographic area? Is it national? So it's really for national interest waivers. The good and bad thing about it is that it's not definable. It's really about how you demonstrate to USCIS the impact of the work you're going to be doing and demonstrating that it is in the national interest of the US. And so that can vary based off of the nature of your work and the nature of your startup.
Okay. Thank you so much again for that answer, Alyssa. And thank you so much, Rohit, for your question. I hope you have got your answer. In case you have a follow-up, continue posting it in the comments section. And whenever we get Alyssa back for an episode 2, we will be taking that question maybe on in that episode. For now, Alyssa, I'll take a few more minutes, maybe 5 more minutes or 2-3 more minutes, if that's okay for you. I would like to share my screen and show those Facebook questions. I would also like to get an answer to those Facebook questions. So I think I'm already sharing my screen. I don't know why am I not able to show it. I would like the control to help okay, it's here. Okay, so let me take it from the top. It's just posted 1 hour back, and let me zoom my screen a bit. So This anonymous participant says, trying to figure out where to schedule an H4 visa appointment for my spouse. Is Islamabad Consulate Embassy still conducting these interviews for first time? Okay, I think this is for Pakistan. But then this here is one question from Hari Krishnan, and he says, if I book Dropbox appointment in Chennai, can I submit documents at Bangalore drop-off location? So is it
Yeah.
possible? Uh-huh.
I would say for all the consular related questions, because they're so specific to each consulate, each consulate does things differently based off of location. So at a minimum, what I'd recommend is they have their email addresses posted and their phone numbers for the most part. So reach out to them, and you can also specifically ask. And otherwise, your attorney should be able to answer this question, because if they are providing consular processing support as well. But each consulate is different. Things change on an ongoing basis. So I would recommend reaching out to the consulate.
Okay. I think that's a great answer. Thank you so much for that. And then there is this one more participant who says, hi guys, the salary mentioned in LCA is different from what is mentioned in the offer letter. So which one to tell when the visa officer asks for the interview about salary?
Yeah, I mean, this is very case specific. I'd want to look at the whole petition to make sure that what was disclosed is the offer letter salary higher than what's been disclosed in the LCA. At a minimum, you need to, if it's drastically different, you need to be able to, you likely haven't disclosed to USCIS the actuality of your petition. So you may want to file an amendment of the LCA. Sometimes what I recommend for clients, especially for startup founders who don't know how much they'll be paying themselves, is to put a range, so that way, if you end up paying on the lower end of the range, or if you eventually want to pay more, you can you have that wiggle room. At a minimum, you need to be paying above the prevailing wage. So I would, if you are going to the interview and you are going anyway, I would make sure that the offer letter salary is higher than the prevailing wage for the specific role and the location, which likely is the one in the LCA.
Okay. Thank you so much for that answer. And then there is one more participant who says, hello, everyone. I took 10 months of break due to health issues and did not travel to USA on H1. I have H1B valid till October 2025. Will it be any issue at immigration? And from past 3 months, my pay stub did not generate.
If you're outside the US, you don't have any obligation to be paid. USCIS only has jurisdiction on your work authorization while you are on US soil. Did not travel to the US on H1, so any of that time you were not using your H1 time. You don't need to demonstrate that you were being paid during that time.
Okay. So after this, let me take maybe one more question for today's show, and then maybe we can wrap it up. So this participant says, I just appeared today, 4th of November, for consular interview at Chennai, and my visa H1B was approved, but I have not received any blue slip from the lady who took my interview. Is it normal? And any idea by when can I expect my passport? I selected VFS Delhi for delivery. Please, if anyone can provide clarification, I'll be grateful.
Yeah, again, dependent on consulates.
Mm-hmm.
Yeah, but for the most part, I'd say unless you're put into administrative processing, which they may do afterwards too, even though they said it's approved, it could still happen. That may delay the process, but for the most part, once it's approved, you'll generally get your passport within a few weeks. And then if you don't within a few weeks and you haven't heard anything about administrative processing, then I'd recommend reaching out to the consulate to touch base on when you should expect it.
Okay. Thank you so much for those answers, Alyssa. I would really like to take more questions, but unfortunately, that's all the time we have. Thank you so much for extending the time too. And thank you so much for being here. And, it was a great episode. And thank you so much for that great debut on Immigration and Jobs Talk Show. And for our audiences, I would like to say to get in touch with Alyssa, you can email her. Her email ID is info@crossingfrontiers.ca. I would like to read it. info@crossingfrontiers.ca. Yes, that's our email. And you can also visit our website, which is www.crossingfrontiers.ca. Thank you so much again for being here, Lisa. There were so many questions still pending, and we were not able to cover all of them.
Yeah.
So, if you're okay, we would love to have a second part to this episode.
Yeah, I would love to do that. I like this, and I think that the more, targeted questions we get as people are more informed too, then we can kind of unpack them more in detail as well. So I'd be happy to do another session. But I had a lot of fun doing this. I, love talking about US immigration for startups. So this was a lot of fun.
Thank you so much. Thank you so much for that, for those kind words. And we are going to see you very soon, and we are going to, schedule the show. We'll check your availability for a second episode. And thank you so much again for being here. And your answers were insightful, detailed. So thank you so much for being so elaborate and so detailed with your answers. Thank you so much again
Yeah,
for being here.
absolutely. Thank you.
Guys, that's it from our side for today's webinar. We are going to see you very soon with an episode 2 of this webinar, and we are going to have Alyssa back soon. But until then, you guys keep on watching and keep on subscribing to Immigration and Jobs Talk Show. I'm Rajni Parara signing off for now. Take care and keep subscribing and keep watching Immigration and Jobs Talk Show. Bye for now.
Hello and welcome to Migration and Jobs Talk Show. I'm Sam, your host, and before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. All right, once again, welcome back to today's very exciting live show. And today we are diving into one of the most crucial topics for anyone who is navigating the immigration journey. And today our topic is exploited or empowered. What's the truth behind H1B workers and companies? Well, guys, this topic is really exciting for so many people because today, most of the people they don't know whether they are being exploited or whether they are being empowered. And what's the reality behind H1B workers and companies? So, today we are going to uncover this topic with someone who has seen both sides of the story. So help me in joining us for the very first time on Immigration and Jobs Talk Show is attorney Ira Katz, a highly experienced immigration lawyer for over 15 years and who has also worked extensively with so many H1B cases. So Ira, welcome to Immigration and Jobs Talk Show and it's a pleasure having you. How are you?
Hi, thank you very much. I appreciate your having me here.
So, Ira, I would like to know that what's the vibe in the US? Are people celebrating Trump's winning or are they like having mixed feelings?
Well, it's 50-50, just like the country itself. There are there are a lot of people that are in mourning
Oh,
on
God.
one side,
Right.
literally, and a lot of people that are ecstatic over this. It's really who you talk to, and it's just a very wide selection of opinions about him.
It will be. It will be. So, Ira, what can you say by seeing the current situation in US, what can be the future for H1B workers look like in the upcoming years under Trump's administration?
I think immediately, I don't think there's going to be any impact particularly over the next year, possibly 2 years. I think they're going to be distracted with quote unquote illegal immigration and his promise to deport millions of people. I think that's going to be their priority to start with. As far as H1B is concerned, I don't think we're unfortunately going to see a rise in the cap of workers. I think it's going to stay steady where it is right now. What I do see is that they're trying to implement rules so that companies can't cheat. The issues that they've been having with companies using multiple registrations for a single worker really got out of hand over the last couple of years. And they are trying to implement rules that will limit that are very specific to the individual worker themselves. So that hopefully will work so that everyone has an equal chance. Unfortunately, with that, the cap is not going to rise, I don't think. And I think we are just going to end up sort of in stasis for the next year or two. What I do see, however, is that they're going to crack down on the rules in place, meaning they are going to make sure that people have the means to support themselves. They're going to make sure that the labor condition applications are strictly scrutinized, and they're going to make sure that salaries are going to actually be paid, meaning probably more site visits and more audits.
All right. So, Ira, as you mentioned that I think before H1B process it will more focus on the immigration part. So, do you think, Ira, that as Trump says that he's going to deport millions of illegal immigrants out of America? I mean, is this possible logically, practically? I mean, do you think it will happen?
I think there's going to be a lot of bluster about it. I think they'll do a few test cases. They'll show a couple of busloads for the media. There'll be a lot of court challenges to his ability to do it. I'm not sure he's going to be able to do it. There's also going to be the fact that he's going to need funds to do it. He's going to have to go to a Congress, which I don't know whether it's going to be Democrat or Republican. The Senate definitely is Republican. We're not so sure right now about the House. If the House turns Democrat, he doesn't have the funds to do it. I don't know where he would get the funds to do it other than cannibalize other government agencies, which in and of itself, we would end up back in the courts because that would actually be illegal. So, saying something and doing something are two different things.
Right. Maybe it is also for like a kind of a strategy to scare illegal immigrants so that they automatically leave. Because I also heard this news that a few of the illegal immigrants they are requesting so many immigration attorneys that please do this visa process as soon as possible, so them themselves are leaving the country without taking any action from Trump's side. So this can also
I
be a reason, right?
Yeah, that is true. There's an element of that going on. A lot of people are, he's scared a lot of people. Both DACA recipients, illegal, quote unquote, illegal immigrants, and legal immigrants. I have a lot of clients that are checking their immigrant status right now to make sure they want to make sure that they are 100% covered, that they have no issues. I have companies that are calling me that are asking to make sure that they're compliant, their I-9s are compliant, their visas are compliant. They are. He has. There's a collective chill that has gone through the country, basically.
All right. So, guys, we are also live on YouTube, LinkedIn, Facebook, and X as well. So, join us from any of these platforms. And Ira is here with us for an hour. So, please have a good opportunity and ask as many questions as possible from Ira. He's definitely going to answer. So, Ira, coming back to our topic. So, there are people who already are H1B workers or trying to be one. So, and also they are not very much aware about the truth behind the H1B program, whether they are being empowered with the opportunities or they are unknowingly stepping into a situation where they might be exploited. So, my question to you is that is the H1B program really attracting the best and brightest talent, or are companies just using it to underpay some skilled workers? What's the balance between talent attraction and exploitation?
That's a really good question, and it's a mixed bag because on the one hand, you have really serious companies who need the talent and do recruit properly and do pay proper wages and don't try to get around labor condition certification and things like that. And you find this mostly in the realm of high tech areas, artificial intelligence, developers. On the other hand, and also in terms of the medical professions, nursing, skilled medical technicians, areas of that nature. On the other hand, you have third-party recruiters who are being used by unscrupulous companies here in the United States to essentially recruit scores of IT people. And the companies themselves have no interest in the individual workers. They need bodies, okay? And they don't really care how they get the bodies. And they have budgets, and they basically tell the third-party recruiters, okay, this is your budget. We don't care how you get to that goal. And that makes for a lot of sort of problems with how they use the workers, how they treat the workers, and how they pay the workers. And we see this constantly. We have a policy in our office, for example, we will not work, okay, with certain recruiters. I won't mention any names, but they're well known already, okay, and they bring in tens of thousands of cases. And I wish the rest of the bar, frankly, would adopt the same policy because we know they're exploiting the workers, okay. On the other hand, you have excellent companies here in the United States. I have a particular company that I've been working with now for, I guess, 12 years, okay? Constant flow of workers, they recruit them, they recruit excellent talent. The long term, we've even had people, I mean, unfortunately, the wait times in India are ridiculous for green cards, but we're finally seeing the first green cards. They sponsored their workers for green cards. They want them to stay, and they want them to stay long term. So it's really a mixed bag.
Wow. I think that's so much our audiences are getting to know, and I am really happy to know that you actually are uncovering these facts because people out there they are just in the American dream. They just want to have this H1B visa anyhow, but they ignore all these facts. So I think it's very important for them also to learn. So guys, please feel free to ask any questions from attorney Ira Katz. And all right, Ira. So as you were talking about the wages. So my next question to you is that H1B workers are also supposed to be paid fair wages that match those of US workers in the same designation. So, but there are also cases where employers pay H1B workers significantly less. So, is the wage structure for H1B workers fair, or are companies taking some advantage of foreign workers to reduce cost? Should there be stricter regulations on salary parity between H1B and US employees?
I think it's more an enforcement rather than because the levels themselves that are promulgated are actually are good. I mean, I'm in constant touch with people, for example, in high tech industries. Some of the people that do hiring, HR hiring in Silicon Valley, and there is parity. If you're paying your your worker what's supposed to be paid based on the Department of Labor, you're getting paid what's being paid, for example, in Silicon Valley for a comparable job in a comparable geographic area. The
Yeah.
problem is not that. The problem is that, for example, someone will come to an employer and say, yes, I want the worker, but I don't want to pay the worker for 10 years worth of experience. Let's have his resume reflect 2 years worth of experience. Okay. So this is how they manipulate the system. Okay, so instead of paying, for argument's sake, if the wage was $125,000 on a level 4, okay, they would end up recruiting the worker and paying the worker on a level 1, which would be $75,000. And this is how they exploit the system. So what you really need is more enforcement. We need more audits, and we need Department of Labor to basically scrutinize companies really on a yearly basis to be able to and fine them. Okay, basically to put the onus of this on the companies, and unfortunately, there's actually a case that's now winding its way through the courts, where a third party, a recruiter, was used, okay, and the worker, who happens to be from India, is going to end up paying the price for it. So there's an appeal going on because they're accusing him of fraud, the worker, okay, whereas the company itself committed the fraud. Okay,
Right.
the worker had absolutely no idea, was totally innocent in the process. And that's really the burden that has to be shifted. The onus has to be on the companies now, to be honest about everything, to be upfront about everything, and to be checked and audited about everything.
Right. So, Ira, as you were mentioning that the companies, they only, initiate in these fraudulent activities. So, Ira, what can you say that is there some kind of that the company should face penalties for creating such a wage gap, or is this a fair reflection of a competitive market?
No, I think the company should face penalties if they're found to not meet the Department of Labor standards for pay levels and pay equity for different workers, and there's discrimination in payment to H1B workers. They absolutely should face penalties for that because they know better.
Yeah, definitely. All right. Ira, I would also like to add one more question that can an H1B worker lose their job at any time? And if yes, then why?
Yes, unfortunately, they can. Um, most workers in the United States are at-will workers, and which means that they can be dismissed at any time, except unless it's for an illegal, for something illegal. For example, discrimination based on race, based on gender, based on some sort of handicap or something of that nature. But other than that, workers can be dismissed at any time. And that's really a peril for H1B workers because basically H1B workers have 60 days then to basically find another job or leave the country. And that's a terrible position to be in. You've come here, you've made your life here, you've gotten a job here, and all of a sudden, the company just decides you're disposable, basically. And that is bad, which is why I encourage the workers, it doesn't protect you completely, but to try to have an employment contract, okay, really before you get to the United States. At least in that way, you understand that there's some sort of protection, there's some sort of a warning, there's a possibility of having a payout at the end, or a possibility of having help from HR find you another job, but otherwise you're really subject to the whims of the employer.
All right. So, Ira, all right. So H1B workers, they need to find out the job within 60 days. So what about those workers? Like if an H1B worker is doing great at their job, then is there also possibility that they can still be forced to leave the US?
Yes,
Oh,
unfortunately, yes. Same thing holds. It's really it's a question of the way the labor market works here, and that's for any worker. It's whether it's a U.S. worker or an H-1B worker. Most workers in the United States are at will, unless you have an employment contract that gives the specific details of your employment.
but I know what can you say that why does this happen? Because if an employer is working well, then why he can get to face these types of situations? I mean, what's the reason behind it?
Um, it's really the way the market is set up here. I mean, we are a capitalist society, and the balance of power, really, structurally between the employers and the employees is on the employer's side. Um, the good thing that right now, because of the way the market is, and the fact that the employment rate is very low, and particularly in sciences and technology, employees have a little advantage in that it's become a little more difficult to recruit employees now. So that if I'm an employer and I've put in the time, the effort, and the money to recruit an H-1B employee, and the employee is a good employee, I'm generally not going to fire someone on a whim,
Yeah.
because it's going to be very difficult to replace right now.
Exactly. And it's not only difficult for the employer, but also for the company as well, because they are also losing a good asset, right? And I think
Yes.
employers, they only make a good company. So I think this is something very unfortunate, and this is something I think people should know, that it's not only about that you are working well, then only you will be, get the permanent residency in US. That is also the other case. You should also learn the other side of the coin, that even if you're working and even if you're doing a great job, then also you can be forced to leave the US.
Yeah, unfortunately, yes. Unfortunately, yes. And one of the big problems here is, from particular countries, and India being one of the countries, the time now that it takes to get a green card is just so long and so prohibitive
Yeah.
in most categories that that's another thing that sort of the employer has over your head, that because of that he can really push you out on a whim if he really wants to. Okay, but again, the market is right now so tight for employment that it really doesn't make sense for the average employer, particularly in high tech and in sciences and technology, to recruit, to bring someone over and to employ someone, to put the time and effort to train. Okay, and then basically just on a whim to fire someone. It's not it's not a usual thing these days.
Yeah, right. So, Ira, as like you mentioned about companies that they are firing. So, I want to know that why do then companies prefer hiring H1B workers over US workers? Because if they are, if the H1B workers, foreign workers, if they are going to have so many problems and still there is no guarantee to it, then why do they prefer to hire H1B workers? It's better now to just keep on working with the US workers themselves. What are the ethical implications of this decision?
That's a really interesting question. I think there are two sides to that coin. One is you have a couple of things that are going on in the United States labor market. Okay, one is that workers are changing jobs day to day. There is no loyalty, particularly in tech right now.
So like US
So
workers, they are also not being in the company. That's also not
no,
guaranteed.
no, U.S. workers are spending an average of a year and a half at their jobs, tech workers, until
Oh,
they move on. Okay, and so what they're finding is item one is that the workers, H1B workers, tend to be more loyal to the company.
yeah,
One, they're kind of in a position where they have to be, okay. But also in general, even where they have the opportunity to change jobs, we find that it's very unusual. Once they're in with the company and they like the company and so on, they tend to be very loyal workers because there seems to be a very different mindset from other countries around the world,
yeah.
where something has very much changed in our labor market. Again, particularly in the tech world, there is absolutely no loyalty today in by U.S. workers. That's one. The second element of it is, frankly, H1B workers. The work ethic is higher than U.S. workers. They tend to put in longer hours. They tend to work harder. They tend to be. I mean, I get this from a lot of my clients. They're just and that's why they come back and they say, there are jobs that I don't want American workers doing, which is, you sit there and you say, okay. And then the third thing, again, in very specific areas of tech, the training is actually better, we find, from certain countries in areas. It seems that in math, physics, workers from certain parts of Europe, from India, and from Israel are just better at their jobs than U.S. workers. And this reflects in tech hiring.
Wow, it's so eye-opening. But I mean, I would say that it's really also unfortunate, right? Because employers in US, the H1B workers, they are more loyal, right, than the US workers themselves. So it is something that actually, I would say it's a real reality behind, the H1B workers and the companies. I think, Ira, you are doing great, and I hope that employers and the companies, they are getting to know so much from this episode. So thank you so much, Ira, for your answering all the questions in a very detailed way. So, Ira, I would also like to add one more question that, nowadays most of the companies are relying so much on the remote work. So, my question to you is that with the growing trend of remote work, do you think that the company will rely on H1B workers in the same way as they were, or they will start hiring talent directly from other countries? How might this change the future of the H1B visa program?
I see it already because we see already there is a lot of hiring going on in, for example, the marketing sphere
Mm-hmm.
that's starting to take place from the Philippines, and that is really wage based.
Yeah.
People are looking for lower wages, and these are hired through third parties, so they don't have to go through Department of Labor standards or anything. So they're being paid by companies in other countries. Okay. And so this is depressing wages worldwide, actually, as a result of that. Now, are American companies going to start doing this? Probably yes. because it's going to infect every sphere. The question is it going to make it into tech, high tech, to the extent that it'll affect the H1B program? Probably. Because we see more American workers, American employers are getting used to the fact that their workers are working remotely right now. So if they're working remotely from other states, I think it's just a matter of time before they'll probably figure out a way to be comfortable with the fact that they have workers working remotely all over the world. So yeah, I think it's coming. I think it will affect the program. But given the fact that for the lottery, you have 85,000 places, a 25,000 gap cap. Given the fact that last year we had, I think it was 240,000 applications for 85,000 places, it's sort of at the margins. So even if it cuts it down by a third, you're still going to have all the applications, and you're still going to have people clamoring for the jobs. And on the other hand, on the employer side, the good companies are not going to want to do this. Okay, you're not going to see this happen from from Apple. You're not going to see this happen from HP. You're not going to see this happen from from Nvidia. The companies like that won't take chances like that because they actually invest in their employees. Okay, so they will not go to a model that will affect the quality of work. Okay, they're clamoring for the cap to be widened. They want more foreign workers. They want better talent. They're constantly screaming that they can't get enough workers. We don't have enough tech workers here in the United States. We just don't.
But Ira, I would like to interrupt one thing that according to our sources, on August 27, we got to know that there were 15,000 employees who got laid off from Google.
Yeah.
So, yeah, what is your take on that?
I think it's just a shift in emphasis. Google is going through sort of they're moving to AI, and I think that move to AI just naturally cut jobs as they were building. It's sort of where we lay off from one end and we put into to the other side. I'll give you an example. For a while, the hottest thing here was trying to recruit full stack developers. Okay, in computers. Okay. And it was impossible to get full stack developers. I had people calling me and trying to see if I had connections overseas, if I had companies just were losing their minds. And we came to a full stop recently. Okay, no one cared anymore. It's like no, our emphasis is now shifted. We want to find AI developers. Okay, and that's what you go through. You go through these sort of shifts, and the manifestation of that. I'm sorry for the long-winded answer. Manifestation of that were the huge layoffs at Google. So I think we will kick back and see a lot of different types of jobs and positions coming back, but coming back in a different way. Coming back, for example, now it'll be through AI development.
Wow, that's great. All right, Ira, thank you so much for your answers. And I'm really enjoying this show, and I am really so much in flow. And I think our audience are also. And with that, we have got so many viewers right now. So let me just greet them: Kiran, Vishnu, Monali Thakur, and Indu too. So, hi guys, and hi Mohit also. Please watch our show till the end, and we are definitely going to take your questions. So, Ira, should we take one question from our viewers? What can you say?
Sure. My pleasure.
All right, great. So, let's take up this question from Indu. So, Indu is asking that as few got selected after lottery, there is delay in the process. When can we expect for 2025 H1B process?
That's a good question. And they haven't really promulgated the time schedule yet, so it's really hard to tell. It's going to be dribs and drabs as it usually is. And once you get the selection notice, you're on the selection notice itself. You have the window, and when you have to have the petition filed by. You know, there's not much more I can give you than that.
Mhm. Okay, all right. So I think Indu, you need to wait for some time to get this answer, and I think Ira will some on the other. Maybe in the next show, we are definitely going to take this up. Thank you so much for your participation, and Mohit is also responding. Thank you so much, Mohit, for your response. We are definitely going to take up, and Kiran is here with a question, Ira, that how do the psychological effects of job insecurity and fear of deportation among H1B workers influence their productivity and overall well being? And there's a continuation. What longitudinal studies could be designed to quantify these impacts in comparison to US workers in similar roles?
A really good question.
Right.
Yeah, no, it's a really good question. Somebody had actually started a study at Northwestern University. I don't know if they followed through with it. I know anecdotally, okay, from my clients and from conferences that I've attended. It really does, and speaking also to HR management, it does have a real effect psychologically. When you know all of a sudden you're getting to your 6th year, and unfortunately you can't get a green card. You know you can't extend anymore. Your life is in the United States. You know you have social relationships in the United States. And you have to scramble to figure out something else, what to do. You know, in many instances, for example, I have 2 clients right now, okay, who unfortunately finished their 6 years with the H1B. They can't get a green card. We were trying to fit them to get O visas, but they just didn't qualify for O visas. So they went back to school. So they're in OPT right now, advanced training. Okay, they don't want to be back in school, but they want to stay in the United States. So this has it does have a detrimental effect psychologically, and also for the employer. Remember, there is so much time being spent in concentrating on your visa, and that takes away a lot of time from your work. A lot of time concentrating on your work, a lot of time, and you know the employers understand it generally that you have to focus on this, but it doesn't make for a smooth transition even in leaving the United States. In other words, if the best idea really would be, you know, if you had the ability to extend, number one, the H1B based on need of the employer and the fact that you could prove that you have the center of life in the United States, okay? And I understand they don't want to give you a green card, for anything, but then at least give the worker the chance to be able to resettle. Meaning, okay, we understand your 6 years is up. You have no opportunity to stay in the United States for any one reason. Fine. So you have another year to be able to figure out what you're going to do. But the 60-day window is ridiculous. You can't really, okay, because it's not really a 60-day window, because in year 5 already, okay, or even at the end of year 4, my clients are wondering what they're going to do to extend. So they're taking time away, from work and taking time away from their lives, and this is really bothering them, and it does have a detrimental psychological impact.
I think this is something very important. Not only we should talk legally, but we should also shed our lights on how the psychological impacts it will happen.
Yeah.
And I think this is thank you so much, Kiran, also for taking that up. I mean, it's a very good question, and uh, just keep on posting these questions also, so that not only you, not only us, but also so many people out there should get to know about what's the reality behind H1B workers and companies. So I think we are going great, and lot of topics we have already discussed. So Ira, right now, I think I should. Ask some more questions from the FB groups, because there also we get a few questions from FB. So I think we should take that up.
Sure.
And yeah, so yeah, this is the question, Ira, that I would like to ask. That while filing DS 160 for my parents, should I write who will sponsor as me or my parent? Am I on H1B at US and they will be visiting first time? Also, they are from. Um, any problem from my side? Ira, can you hear me?
Yeah, I hear you. I'm sorry. I didn't see the question.
Right now, can you see my question?
Not entirely. It's kind of cut off. I'm just
Okay, no worries. Let me share it again. Wait, I think there
okay.
might be some, technical issues. Mm, yeah, just let me know. Is it, I mean, can you see now?
No, I'm sorry. I can't. If you would
Uh,
read it out to me,
yeah,
I'll remember.
sure, no worries. Let me read it out. So it is that while filing DS 160 for my parents, should I write who will sponsor as me or my parent? I am on H1B at US and they will be visiting first time. Also, they are from Kolkata. Anyways, to get both BAC and consular job in Kolkata. Yeah.
Oh, she's talking about her parents
Yeah.
visiting. So the DS 160 is for her parents on a B visa, I assume. Um,
Mm-hmm. Ira, can you hear us? I think we have lost Ira somewhere. No worries. I think Ira will be back. But all right, guys. So let me first of all let me say hi to all our audience who have joined us right now. Thank you so much, guys, for joining us. And till the time Ira will come back, we are also going to take a short break. So keep on posting as many questions as possible. Let's keep on going this great conversation again. And thank you so much. We'll be right back just within a minute. So keep on watching Immigration and Jobs Talk Show. Hi, guys, and welcome back to Immigration and Jobs Talk Show. But unfortunately, right now we are having some kind of technical issue from Ira's side as he lost some connection. So I don't think that from now, I mean, on today, we are going to continue this show because of some technical issues. Oh, all right, Ira is back. How is
Yeah,
that possible?
I apologize.
No, no,
We,
no. It's so great. I was just saying that to our audience that we are going to connect later on, and suddenly you pop up. How that is that possible? I mean, you lost the connection, right? And there was some big problem as well.
we lost power in my building. I'm actually on my iPhone right now.
Oh my God, that's really grateful to us. By even losing the connection, you're back with the show. All right, Ira, but we know that you are on your phone, so we won't take much time. But definitely, we are going to just add few more questions, and then we are going to have another episode also with our viewers. What say?
Sure, sounds good.
All right. So, Ira, let's back to our questions. As I was talking about that, there were so many people who were, facing these kinds of struggles and hurdles of H1B workers. So, I would like to know that what strategy should they have or option they can explore to stay in the country and secure their future in the US?
That's 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 tough. First of all, the one strategy, even though right now, unfortunately, getting a green card is very difficult.
Yeah.
If you win the H1B lottery and you get an H1B and you enter the country on an H1B, um, my advice always is to start the green card process literally from day one once you enter the United States. Now, you'll be, hopefully you'll be approved, but unfortunately, you're going to have to wait and wait and wait and wait. But will that improve? It might. We've had periods of time where unfortunately people have had to wait 10 or 12 years, and then it's accelerated to the priority dates being 1 or 2 years. So it really pays because you really don't know what's going to happen in the future. So that's one strategy. Second strategy is see if you qualify for another visa. Okay, once you're in the country, that you could change status to. So, for example, if you build up your resume in some particular area, is it possible that you could qualify for an OV visa, for an extraordinary ability visa? Are you doing something that may qualify for a national interest waiver, for example? Okay, so I recently just had a client actually who came over on an H-1B visa, um, and we were trying to keep them in the United States somehow. He had not told me that in his past life, basically, he had worked for the United Nations, okay, in a capacity, and that capacity was in terms of low income housing. He had he had actually been on a very important committee. Now, that's an issue in the United States that's extremely important right now. Housing is a terrible problem in the United States. So his experience transferred to the ability to get a national interest waiver in the US. And we successfully applied for him for a green card on that basis.
Right.
So you really, really never know, where you can get. You have to be very creative, but you have to start early. That's the key. Okay,
Right.
with everything, with registering for the lottery. Okay, and you know what? I have clients that register for the lottery every single year for year after year after year after year, and in year 5 or 6, they won. They got it. Okay, so it's being persistent. That's really the key.
All right. So, Ira, what do you think that as Trump is ruling right now in US, so will this impact companies that rely heavily on H1B workers because Trump is always America first, and H1B workers are obviously those are also immigrants. So, what can you say that do they have to face some stricter regulations, or will they find some kind of new opportunities under Trump's administration?
Um, I think I think in and of itself, not much is going to change. I think enforcement's going to change. I think they're going to become stricter as far as enforcement is concerned, and I think that's really the only change we're going to see. And I don't think we're going to see it immediately because I think they're going to be distracted again with quote unquote illegal immigrants for at least for during the first year and probably for the first couple of years of their administration. And remember also, a lot of the money that's behind Donald Trump comes from Silicon Valley, from actors in Silicon Valley. And they don't want to see the H-1B program go away because a lot of their workers come from the H-1B program.
Right. That's a very good point.
Yeah.
Nice. All right. Thank you so much, Ira. And Ira, one more question. This is going to be a last question for today's episode. So, in your view, I would like to know that what should any last message that you would like to share with our, with our applicants who are applying for the H1B or who has already been working as an H1B worker? Any last message that you would like to give them by keeping in mind the Trump's administration?
I, the really the last message is make sure everything is up to date. Make sure your company is complying. Make sure they're filing their I-9s. Um, don't worry about pestering HR, okay, because that's what they're there for, okay? And make sure you're always in compliance, okay? Because as I said, there's a case going on now with a third party worker who was brought in by a recruiter, perfectly innocent, okay?
Right.
And they're being basically charged with fraud, and they had no idea what was going on. This is wending its way now through the district court. And I look at the case and I basically say, should they have known? No, but they would have known had they known what was going on, had they asked questions. Always ask questions, okay? Never feel like you're in a position, okay, where you're threatened based on the fact that you don't want to stir things up or you don't want to be a pain in the neck. Be a pain in the neck. It's your right. Okay. Okay. You want to know the I-9 was filed by your employer. You want to know that your visa's properly in place. You want to plan ahead of time. You want to ask questions of your employer. Okay. Am I staying? Are you going to give me notice? Am I? All of these questions are very, very important.
Great. I think it's not a problem if you can be a pain in the neck, right, Ira?
Absolutely.
And that's
Absolutely
how
not a
every
problem.
employer should be. They should have that
Yes.
much courage, to ask questions then on there.
And by the way, the same of your lawyer. Uh, um, Whether, no matter who you're using, okay, they have to be responsive to you all the time, all the time. And don't take anybody that tells you it's too complex or it's too this. You want to know exactly what's going on and what your rights are all the time.
Right. All right. So, Ira, thank you so much. And we have almost reached to an hour. And, again, I would like to say that your insights were incredibly valuable. And I think people out there, they will definitely apply your insights. And I think they are very much happy. And we also got so much responses from people, though we couldn't take so much on this episode, but we are surely going to take from next episode. And Ira, thank you so much for your time, for your, even though you lost connection, but still we got you. And that's really, a good spirit, a very happy spirit, I would like to say. So thank you so much, Ira. And thank you so much, everyone who has joined us today. And please contact attorney Ira Katz on the given number in case if you're feeling or navigating any immigration problems, then feel free to contact him on the given number. That is 914-639-6750. I would like to repeat it again, 914-639-6750. And please email him at ira@icatslawoffice.com. I would like to spell it out, IRA at IKATZLAWOFFICES.com. And do visit his website, that is www.icatslawoffices.com. So I think now we have reached the end of our show. So Ira, it was greatly having you. And I was so happy with today's episode. And how was your experience? This was the first episode on our channel. So
I enjoyed it very much. It was a pleasure chatting with you. Thank you for hosting me.
me too, me too. It was a pleasure for us too to have you as a guest. So, all right, thank you so much, Attorney Ira Katz, and thank you so much to all the lovely viewers. And don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. We will be here, and we will definitely bring up more different insights, more different topics for you to understand more about the reality behind H1B workers and companies. Thank you so much, guys, for everyone joining us. I'm Sam signing off for now.
Hi everyone, welcome back to Immigration and Jobs Talk Show. And before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this important disclaimer, welcome back everyone to Immigration and Jobs Talk Show. And today we have an absolute treat for you. Joining us is the incredible immigration attorney, Ralph Antonioli. And we are diving into a topic that can be a game changer for many. We will be discussing about mastering the O1 visa, a comprehensive approach to securing success for extraordinary achievers. Now, before we jump in, let's take a moment to appreciate the remarkable journey of our guest. Ralph Antonioli is not just any immigration attorney. He is a veteran with nearly 30 years of experience, specializing in business immigration, sports law, and innovative immigration solutions. As the founder of Antonioli and Associates, a respected firm based in Washington, D.C., Ralph has built a reputation for crafting legal strategies that are tailored as they are effective, meeting even the most complex regulatory requirements with ease. His expertise in O1 visas and other employment based categories is nothing sort of phenomenal. With an impressive 99.9% approval rate, a clear testament to his strategic and meticulous approach. But Ralph's story is so much more than just his professional achievements. His journey as an immigrant to the United States has given him a unique perspective and a deep commitment to helping others navigate the often complex and daunting immigration process. He's worked with firms of all sizes, from small startups to giants like Sidley Austin, one of the most prominent firms in the world, where he owned his skills and gained invaluable insights into the global immigration systems. Now, here's where Ralph's story takes a truly inspiring turn. In 2010, his life changed dramatically when he suffered from the rupture of three brain aneurysms, followed by 6 weeks in a coma and a battle against multiple life-threatening conditions. Given less than 1% chance of survival and told he would never walk, talk, or practice law again, Ralph defied every odd. He relearned how to walk, how to talk, and with unwavering perseverance, he passed the bar exam in Washington, D.C., an achievement his doctors thought was impossible. This near death experience profoundly shaped Ralph's priorities, inspiring a lifelong dedication to disability rights for advocacy within the legal profession. He's committed to increasing representation for disabled professionals, a group he passionately advocates for through the American Bar Association's Commission on Disability Rights, fluent in 5 languages and holding 3 nationalities. Ralph brings a global perspective and cultural sensitivity to every case. As an immigrant and as an attorney, he understands the challenges his clients face and is passionate about helping them achieve their dreams. Today, Ralph will share his invaluable insights on how creativity, meticulous case preparation, and thorough regulatory analysis can unlock opportunities through O1 visas. He'll guide us on how these visas can help extraordinary achievers from all fields access the US market and pursue their professional and personal ambitions. So now, without any further ado, let's welcome Ralph on Immigration and Jobs Talk Show. Hi, Ralph. Welcome to Immigration and Jobs Talk Show. It's such an honor having you on the platform. Thank you so much, firstly, for sharing that beautiful bio and beautiful journey of yours with us so that, I can read it out to our audiences. Thank you so much for that. And yes, welcome. And how are you?
Thank you so much, Rashni. I appreciate that introduction, and I'm really happy to be here. Try to hopefully navigate something that may be intimidating for some, but my job is for your audience to learn that this type of visa is not just for the superstars. It could be for anybody. So I hope your audience can take advantage of this and yes, and learn how how to put together a good O1 petition that may otherwise they think they may not qualify for. So I'm looking forward to this. Thank you.
Thank you so much for gracing our platform, Ralph. It's an honor having you on our show, like I said. And yes, and today we are going to talk about, mastering the O1 visas. So, Ralph, in your introduction, I told our audiences that you hold 3 nationalities, right? But you know in and out about US immigration, and you have helped the audiences with 99% of, that's the success rate that you have had, right? So I would like to know from you, you must be very much familiar with the US politics because you handle US immigration and you're an expert in that. So, Ralph, I would like to know from you that recently President Trump he got elected, and he's going to be in the office for his second term with his administration, which is under a lot of controversies these days. So, as an attorney, what are your views and where do you stand? Do you think it is going to be good for the immigrants? Because these days, the immigrants have a lot to think about, to talk about. There's a lot of chaos also going on, not just in the illegal immigrants' mind, but also on the legal immigrants' minds. So, as an attorney, what would you like to say?
Well, yes, I was going to raise this. I'll call it the elephant in the room, but I guess we're going to talk this head on. So, yes, President Trump was elected for a second term. There is a lot of noise out there about what's going to happen and what's not. My job as an immigration attorney is to reassure people that any particular case requires, at the end of the day, that you meet what the statute says. Sure, are there going to be changes? Probably. Are things going to get more difficult to get approval? Possibly, but again, what I want your audience to understand is that although change is probably going to happen, this is not going to happen overnight. It takes time for a particular policy to be changed, and even more importantly, for the law to change. That requires congressional action. Just because candidate Trump was promising this and that, that's a lot of it is rhetoric. And I'm going to start by saying that this is also a point where having good legal advice is critical. Like I said, at the end of the day, you have to prove what the regulations say. I was going to discuss this later in our conversation, but since you brought it up, I recently participated in meeting with people from USCIS and the Department of State, and they spoke about what was like under Trump 1.0. You know, his first, and they said that it was challenging, and I want your audience to understand that you have to be realistic. That it's probably going to be tougher, but that only emphasizes the need to have a good lawyer with you. For example, just to give your audience an example, one of the things that, well, at least in the first term of President Trump, and I don't see why this is not going to happen again. They had this approach called Buy American, Hire American, and that plays a big part in the visa process, because I'm going to give you an example of what someone who used to work for a U.S. consulate told us yesterday. He basically said that they're really looking with a fine-tooth comb on, can an American do this? You know what I mean? So that's why it's important to be very meticulous, very careful in how you prepare your cases. And as you alluded to earlier, this has always been, regardless of who's the president, this has always been my approach. And that's why we've been extremely successful in approving cases. At the same time, on the other side of the coin, you have President Trump saying that he's willing to give everyone who's got a STEM degree from a U.S. university a green card right away. Again, that would be great. But whether that's actually going to happen, we're going to have to wait and see. My recommendation for everyone will be, and what I tell my every client is, whatever you see or whatever you read, don't believe it. Reach out to me first. And
Absolutely.
because 9 out of 10, the person who's writing knows nothing about immigration law, and they just write whatever they think they understand. And more often than not, unfortunately, that creates more panic than anything else. So what I always tell people is, before you believe anything you read, shoot me an email or give me a call and we'll discuss it. So yes, this is a real, I don't want to call it concern, because to me it's not a concern. I'm here to help my clients and to make sure I work to the best of my abilities to give them everything I've got. What I always tell people when I meet with them is, like, unfortunately, I can't guarantee a result because that's outside of my hands. But what I can guarantee you is that I'm going to give everything I got to get your case approved. So, what's happening after January 20th, when President Trump takes the oath of office again. It's hard to know, but I don't really like to speculate, but I think we have to be ready for everything. Like I told some colleagues yesterday, we know what the minimum they're going to do because they did it in their first term. And that shouldn't scare us because we're also ready because we know. You know what I mean? Yeah. So I just want to stress the need to, have competent lawyer with you. Talk to a lawyer. I was gonna talk about this in the O1, and since we go in, like I said at the beginning, the O1 category is not just for superstars. The O1 category is for, all you would need is a good story, and to put together your good story, you will need a good lawyer. So, the O1 category is a category that is heavily on the criteria. We're going to talk about those probably a little bit later. But the O1 category is defined in the statute, and that's exactly what USCIS has to follow. They can't they can't go outside of what the law says. So that's why it's critical to have good representation. And because I've seen people try to do them themselves, and that's just not a good idea. I mean, especially not with what's coming in the new administration and everything. It's critical to have someone to sort of work with you on this journey. So
No, absolutely. I think, especially around this time, you should be under some guidance, somebody who can help you with your cases, because the scrutiny is definitely going to be stricter, and things are going to be definitely strict. Because first, we have heard that from a lot of attorneys that it was not exactly a very good time, especially for the immigrants. But Ralph, also, if we talk about this Trump 2.0, or this administration that he has right now, there are a lot of immigrants under in his team. And let me just start with his wife. His wife, Melania, she herself is an immigrant, right? And then if I talk about Elon Musk, Elon is an immigrant. And then Vivek Ramaswamy, he's an Indian American. So we can call, I mean, he is an Indian American, but he definitely has those immigrant. I mean, his parents are immigrants. So there are a lot of in his administration itself. There are a lot of immigrants. So do you think that that is going to be favorable for the immigrants? And because if we listen to Trump and his speeches, he mostly talks about going against illegal immigrants or undocumented immigrants is what he says, right? So, but do you think it is also going to affect the legal immigrants?
that is an excellent point, and I'm glad you brought it up. I think so. The fact, for example, I mean, Elon Musk, he is, I mean, don't quote me, although this is live, but I think he's going to be the president. So,
But he wasn't
um,
born in America, right? I think he was born in Africa, if I'm not wrong.
well,
So I don't know. He's
he's
eligible.
he's from South Africa, yes.
Yeah.
So I'm glad you brought that up because certainly I don't think realistically, but again, you should not take this you should take this with a grain of salt, meaning I don't think it's smart for them to go after business immigration because yes, for example, Elon Musk depends a lot on H1Bs, for example. So I don't think, I mean, if they go after legal immigration or business immigration, I think they're going to be shooting themselves in the foot. I don't necessarily think the fact that Trump's married to someone from another country plays anything because I don't think, that's a different conversation for another for another session, maybe.
I understand.
But no, but I think the fact that he had someone in his administration, is Stephen Miller, who's going to be the guy putting together policy. And I'm going to be brutally honest. I mean, if it was up to him, he was going to deport everybody. But I don't think that's realistic. Like you said in your question, and I think this is what people need to take into consideration, is the fact that the political points are, like you said, is with people who are here illegally. I don't like to use the word illegal, but it's someone who doesn't have that. That is a very big word because when people say the word illegal, and again, I don't like to use that word, they're usually referring to people who cross the border without a visa. But you also have to take in consideration that there are a lot of people who came in on a visa and they overstayed. So that's, it's again, like I said in response to your previous question, I don't think you have to step back a little bit and look at this realistically. Okay, they're saying there is about 20 million people without legal status in the United States. I mean, how are you going to do that overnight? You know what I mean?
Yeah.
Like,
Yeah.
logistically it's impossible. I mean, and I don't know if there are any Trump supporters in this call. I hope not, but if they are, um, they have been known to be very undisciplined. So, I mean, who knows? Maybe for this second time around, they're more organized. I don't know. But I think business immigration, I can't say for certain it's safe. It's probably there's probably gonna be more RFEs. There's
Yeah.
probably gonna more, you're gonna have to present more evidence. You're gonna have to be more detailed. But I don't think it's a good idea for them to mess with business immigration because, they're sort of advocating for people to follow the law. And I think business immigration is exactly that. You know what I mean?
Yeah. Yeah.
So, and the fact that the reason I brought up this guy is Stephen Miller is because he's probably very aggressive, but like you said, he's going to have Elon Musk in there. And I'm sorry, I don't remember the name of Vivek, right? Vivek? They are probably going to be like, look, I believe he's in IT too, right?
Yeah. Yeah. He has been an entrepreneur. Yeah, that's right.
So, I mean, the business immigration is how the United States stays competitive. That's the truth. And if you're going to, start implementing things that turn talented people away, then I don't think that's a very smart idea because people are just going to be looking to other countries.
No, absolutely.
And it's like, but again, it's going to be like a balancing act,
Yeah.
On the one side, they're going to be like buy American, hire American, but on the other side, it's like we don't want to lose this talent to other countries. So it's going to be, I think it's going to be case by case. It's going to be a fight that's going to be happen case by case, So that's what I believe. And again, I want to emphasize that I don't want your audience or anyone to to just panic. Call me, call me before you do. So.
Yeah, absolutely. Guys, if you're confused at all, please directly give Ralph a call. Maybe he's going to help you with a detailed consultation. He might definitely going to help you. He will definitely going to be helping you with your cases and with your questions. Here are his details. If you want to give him a call, you can give him a call on this number, 240-898-2288. I would again like to repeat it, 240-898-2288. You can also email him. His email ID is ralph at Antonioli lawfirm.com, and you can also visit his website, which is www.antoniolilawfirm.com. All right. So now, Ralph, we already have started getting questions. I see
Yes.
people posting their questions. Let me quickly say hi to them. Hi, Kavita, Arjun. Then we have one question from LinkedIn. The name is not mentioned. It says LinkedIn user. And then we have from Paveen. So guys, okay, again, the LinkedIn user has posted a lot of questions. We are definitely going to take them, but let me quickly start with my questions. Ralph, also, if you can please tell about what are the key differences between O1A and O1B visa categories, and how do the eligibility criteria vary between them?
Yes, absolutely. Yeah. So before I explain the difference between O1A and O1B, I want to give your audience a little bit of history. So the O1 category was created by the United States Congress in 1990. This was in response to a high volume of cases where people had, for lack of a better word, or for this particular purpose, extraordinary abilities in particular areas. Before the O1 category was created, most of these people came to the United States, or most of these professionals came to the United States on H1B visas. But as we're going to discuss, in this in our time together, the H1B has a lot of limitations that the O1 visa does not. So, this was created so that people can have more flexibility in working in the US and, potentially be here without a time limit. Because as you know, the H1B category only allows for someone to be in the United States for 6 years. So in direct response to your question, the O1 category is divided into two separate subcategories, if you will. The O1A, this category applies for individuals that have extraordinary abilities in the sciences, education, business, or athletics. On the other hand, O1Bs are for people who have extraordinary ability or have achieved an extraordinary achievement level in the arts, motion pictures, or the television industry. Both are similar; they're not the same, but that's basically the difference between the O1A and O1B. So O1B is for what I call the SEBA categories, which is science, education, business, and athletics. O1B is mostly for the entertainment industry. So it's for artists, which we're going to talk about what art is a little bit later. And then people in the motion picture and television industries. So yes, those are the main categories. Again, like I explained a little bit at the beginning, the O1 category is basically a by criterion type of visa. So depending on whether you are pursuing a visa based on science, education, business, arts, or athletics, or arts, motion picture, or television industry, then you basically the first step is to determine what field you fall into. So let's say for someone in the IT industry, and I see one of the questions in the chat here asking about IT. IT would typically fall under sciences. So that will be an O1A. Okay. We can, and if someone works, for example, in TV production, that will be an O1B. So yeah, that's basically the difference between the two. I mean, both are O1 visas, but it's this when for filing purposes is when you sort of focus on whether it's an O1A or an O1B, but for general purposes, it's just an O1. So I hope that answers that question.
Yeah, it does. Thank you so much for clarifying and answering the
Excuse me.
question, Ralph. I think just so they can simplify the fields and they can make they can differentiate between the fields, so they made these categories O1A and O1B, right?
That is correct.
Right.
So basically, based on the field, based on the endeavor of the person or the field that the person works, is when it is determined if the person is an O1A or an O1B. But again, this only comes into play when you put together your petition. Then once the case is approved, as I recall, sometimes the visa only says O1. So this only comes into play when you are actually filing your petition with USCIS.
But is the process also the same, or does the process also varies? I mean, for O1A and O1B.
What do you mean by process? Well, I mean, the criteria for an O1A and an O1B are very similar. They're not identical. They're similar. But when it comes to processing, when filing, that's identical. That's identical. I mean, so usually how it works is, you put together a pretty decent O1 petition package. You file that with USCIS. Once one of two things happen. The case is either approved or USCIS issues a request for evidence, asking the petitioner in this case to provide additional information to, usually because they're not satisfied with certain criteria that we explain or basically spell out in the petition. I say two options because sometimes people think, well, is it going to be denied on the get-go? That's pretty rare. I mean, unless it's a really bad case, cases don't usually get denied outright. I mean, usually it's either on straight approval or an RFE. And but I mean, filing with USCIS is identical for both.
All right. Thank you so much, Ralph, for clearing that. And thank you so much for the answer. And Ralph, as you can also see, there are a lot of questions here from our viewers, and people are also, having a conversation and chatting while listening to you on YouTube and also on LinkedIn. So yes, I think we can also share the screen so that Ralph can also see what's going on the social media. But if you allow, I would like to take the questions from the viewers, if that's fine for you.
Absolutely.
Perfect. Let me start with Lynn, because I think this LinkedIn user who posted its comment is Lynn. And Lynn wants to know, can you explain what the O1 visa is? I think, yes, if you can see that.
Yeah. So, like I explained at the beginning, but I'm happy to, the O1 visa is a visa that is designed for people who have, and this is a word of art, extraordinary abilities or achievements in specific fields. So like we just spoke, the O1A is for those individuals in the sciences, education, business, and athletics. And the O1B is for individuals in the arts, motion picture, or television industry. So I think to better answer that question, I will probably give you an overview of what people need to show so that you are qualified for an extraordinary ability. And this goes to my earlier comment that you don't have to be a superstar. You basically need a good story and a good lawyer. So for example, let's start with the O1A. For the O1A, you have to show that the person is a extraordinary abilities in either the sciences, education, business, and athletics. Okay, so how you do this? The easiest way to do this is if someone has a international recognized award. So, for example, let's say somebody won a Nobel Prize. Okay, this is all they have to show. That's it. An internationally recognized award. I mean, this again, as you can imagine, this is usually not the norm. So, for those people who have not earned a Nobel Prize or an internationally recognized award like a Nobel Prize, we move into the second way, which is the most common way to show that someone is considered an extraordinary ability in either the sciences, education, business, and athletics. So you have to. There is 8 criteria that you can possibly use to meet the O1 in the O1A. So you can either show, again, I'm gonna give you 8 criteria. All the person needs to meet is 3 of them. Okay. The first one is receipt of a national or internationally recognized prize or award for excellence. This is any other award that doesn't fall into the category of a Nobel Prize or something of that stature. So you can argue that you receive an award, a local award, and then you argue that your contributions were critical for this award to be issued, and again, you can show this. The second way you can show that you are an extraordinary ability is membership in associations requiring outstanding achievements. These are pretty mouthful, but basically it's associations that sometimes the most common one is like a fellowship. So if you're a fellow in an institute, all you have to show is that for you to become a fellow, you had to meet certain criteria in that organization. It's not just, it's you have to contrast that with, for example, a what they call here a pay to play. So like you pay and you become a member. That probably is not going to fly. It has to be some type of organization where you became a member because of what you did. Um, the third category is referred to as published materials about the individual in professional or major trade publications. This is, interviews, articles in magazines in the person's field that, speak about the person being extraordinary, being, above and beyond the common ground. Then the fourth is participation as a judge in the work of others in the same or similar field. So in this case, if you were invited to judge a competition in your field, let's say in robotics, for example, and if you were invited because of who you are or because of your credentials, that's probably going to meet the then this is the next criterion is probably a favorite in the IT industry, which is original contributions of major significance in the field. As you can imagine, this is pretty broad. And again, this goes back to what I said earlier about you telling your story. What I always often tell clients when I first meet with them is, okay, tell me why you're better than everybody else. And that starts the conversation. Excuse me. So the original contributions could be, this is pretty broad. So we can, you tell me why you're good, and then we work from that. Excuse me. The next category is authorship in scholarly articles in professional journals or other major media. This is, for example, things that the person has worked on. For example, if you go to the easiest way to prove this is go to Google Scholar and put your name in there. And let's say you've written 10 articles, and again, it's criterion by criterion. So you start by saying, yes, I've written certain articles, and then you start sort of breaking out by article saying, okay, I wrote this article. This article was cited 100 times. This is then the seventh, and this is usually used by a lot of people who, for example, are self-employed. We're going to talk about how you need a employer petitioner to file for you to secure an O1 and the workarounds. But this particular criteria is defined as employment in critical or essential capacity for organization with a distinguished reputation. So basically this, you just show that you work with organizations that have, a great reputation. So for example, if you work for someone like Apple, or if you work for someone like Tesla, or if you work for someone like Microsoft, excuse me, that's how you will show this. And then the eighth one is pretty straightforward. It says you show that you are a person of extraordinary ability by showing that you commanded a high salary or other remuneration for your services. So this is basically you show that you received a really high salary based on, a high salary for what you did, and that would qualify you for an O1. Again, I read 8 criteria. You have to show that you meet at least 3 of them to be qualified for an O1. And the 8 category that I read are for O1A, which is for, again, it's for sciences, which would include IT and anything related to, for example, AI or robotics or things of that nature. For the O1B, which is for arts, motion picture, and television industry, the initial criteria is the same. For example, if the person received like an Oscar or an Emmy award or a Grammy, that's enough for the person to meet the O1B. Again, this is not always the case. So again, you go into the regulations provide 6. It's not 8 like O1A. It's only 6 for O1B. So again, that you have to meet 3 out of 6. So you have to perform in a lead or starring participant in productions or event with distinguished reputations. Basically, you have to have been a critical part of a production or, a television show. Then you have to receive national or international recognition for your performances, or work has been published about you regarding your performances. You can also show that, the productions or, movie or series, now that streaming services are really popular, you have to show that, it was successful. So, you will present press articles or critics reviews and things like that. And then you will also show recognitions from other organizations saying, yeah, this guy was out of this world and he was amazing in what he did. And then again, you have the high salary, which, if again, this is case by case basis. So I hope what I do want to highlight though is that for extraordinary abilities in science, education, business, and athletics means a level of expertise. And I'm reading from the regulations, because this is, like I said at the beginning, a lot of these are works of art. So if you basically put together a good story and work with a competent lawyer, you're going to be able to meet these criteria. So for science, education, business, and athletics, which is an O1A, as we discussed, you have to show that the person is in a small percentage who have risen to the very top of the field of endeavor. So this is, creativity comes into play here. You have to show, and I'm going to talk about this, when we address the best practices and best approaches on how to meet these criteria. We're going to talk about that, but basically, when it comes to science, education, business, or athletics, you have to show that the person is, I don't know, I would say in the top 5%, top 1% of what they do. This shouldn't be intimidating for people, because, as I'm going to speak about it later, the key is to narrow down the field as much as we can, because the more narrow a particular field is, the less people that are probably going to be in the top level. You know what I mean? So what I mean by that is, we have to narrow down. If we say he is an extraordinary ability in the field of IT, you can imagine there's going to be thousands, if not millions, of people who are going to be extraordinary. But if we say he's an extraordinary ability in IT, particularly X, Y, and Z, then the field becomes extremely small. So again, this is a case-by-case basis. You have to show that you're on top of your endeavor, whatever that may be. And again, a lot of these regulatory schemes may seem maybe intimidating, but again, I want to emphasize that working with competent lawyer and doing your homework goes a long way. Putting together a good story and supporting documents with as much as you can. Basically, present a story to the person so they look and they are. I always say that the first 10 minutes of the person looking at your case are the more critical. If you can convince that person within 10 minutes that you are on top of what you do,
Right.
you have won your case. So yeah, I mean that's basically. I mean it's kind of a long answer, but um, it's very case by case basis. My job here today is to basically give your audience a sort of like a 10,000 feet picture of what the O1 category
Right.
is like, and that it's just not for the top, just for superstars. If you present a really good story, you can definitely meet the O1 criteria.
Great. Thank you so much, Ralph, for that detailed answer. Thank you so much. And I'm sure it did help Lynn. I think it must have helped him a lot. But he also has a follow up. He has posted another question and he says, did Elon Musk use the O1 visa initially? Can you give some examples of someone who used O1 visa? How does it apply to tech workers, artists, athletes? How about the spouses and children's? I think then because you were talking about people working in the entertainment field and these sports athletes, then I think majorly anybody who is because now I think Lynn is asking examples. So anybody and any artist who's traveling abroad for any project or any movie or any film, I think they must be using the O1B visa, right, Ralph? And if you have some examples and if you can answer
Yeah, I
some.
mean, I think this is a two-part question, or maybe a three-part question. First off, I don't know if Elon Musk ever used the O1. I do know that Albert Einstein was in O1 at some point, even though, even though I'm gonna go back because the O1 didn't exist until 1990. He did an EB1, which is we're going to talk about that later, which is where the O1 sort of got its. Um, I've done about, I would say, 100 plus O1s. Most of the O1s that I've done were for business people. So in the case of business people, what you focus a lot on the reference letters, which is how you show that the person has influenced the field. Um, like I said, you show that the person um, had original contributions of I also work with artists, particularly in the television industry. I work with photographers that worked in the television industry. I work with educators. So I mean, and I've also done P1 visas, which is not part of this conversation, but those are for athletes. You can also meet the you can either for athletes you can do O1s or P1s, but I mean, since we're just focusing on O1s here, tech workers usually, like I said, like I alluded to earlier, they would meet the in the sciences. So again, this is I see a lot of questions here saying, well, I'm a researcher, for example, or I don't know if my resume um, will be enough to meet the O1. Like I said, every case must be looked at with a microscope, if you will. Just by looking at a resume is probably not even 10% of what I need to determine whether the person would qualify for an O1. But yeah, I mean, it's a case by case situation. I mean, there are other categories but the O1 is something that is out there and that has its advantages. But what I would recommend someone wanting to explore the O1 is to get in touch with me, and because I don't think we don't have enough time to go case by case. All I can say is that unless you have one of those internationally recognized awards, you start looking at the 8 or 6 other criteria and see how you can meet them. Creativity comes into work. Basically, what you do is you sell yourself to USCIS, and that's where advocacy comes in. Um, so, I mean, that's really what I can offer. I mean, unfortunately, I don't know if Elon Musk was ever an O1. Maybe, I don't know. But now, when it comes to, like I said, tech workers, the O1, I'm going to be honest, the O1 is not a favorite category. It's out there, and I encourage people to explore that, especially because the H1B and L1 category are going to be heavily scrutinized. But again, it's a case by case situation. Just because you think your resume is weak is not an impediment for you to, schedule an appointment. Let's talk about how we can strengthen your. For example, if something in your field requires you to be a fellow, how long does it take to be a fellow? Do your research, do your homework. One of the criteria is to be a part of an organization that requires excellence. All right. How do you, for example, there is a society of X. How do you join that X? How much time? Think about it. There's, for lack of a better word, there's a lot of ways to skin a cat. So, there is no one silver bullet. The O1 is one of those categories that lend itself to a lot of creativity. I have done an O1 for someone, and this was probably the most challenging O1 that I've ever done. It was for someone in the educational field. The first thing when you Google this person's name was that he was expelled from a university for plagiarizing. And I was like, okay, good. So the USCIS officer is going to put this guy's name in Google, and that's the first thing that's going to come up. So, we got on pretty big RFE, but at the end of the day, I was able to meet the statutory requirements and take the attention away from what's out there to what actually is required. So again, this goes back to don't worry too much about whether you're a superstar or not. Worry more on how you can meet at least 3 out of the 8 or 6 criteria. The other part of the question refers to spouses and children. So spouses and children of O1 petitions, of the O1 visas, qualify for what's called the O3. They are eligible to come to the United States for the same amount of time as the principal O1 can. Unfortunately, as it happens with H1B spouses, O1 spouses cannot be employed. They can go to school, and that can eventually open another avenue. They can they can secure an H1B, or that. This is a different topic for another conversation, but unfortunately, the O3 category doesn't allow for employment. Again, it allows for going to school, like if they want to pursue a master's or another degree, but unfortunately, it doesn't allow for employment, like the H4 does in certain circumstances.
Right. I think O1 itself is such a vast topic that it won't be possible for us to complete everything in this episode, right, Ralph? It will take us a couple of episodes to finish talking about O1.
Yeah, I just realized we're almost at the top of the hour here, and I don't think we even scratched. I don't think we even spoke like 1% of what the O1 is all about. So
It's important because we have to start from the basics, and then we are going to dive deep into
if
what O1 has. So we are definitely going to do more episodes, but for now, thank you so much for answering this question for Len. And he now has actually one more follow up. So
okay,
if you have some time, I would like to continue, because I think in 5 minutes we'll be completing an hour. But if you have some more time, I would like to take more questions from the
yes,
viewers.
absolutely, yeah, absolutely. The one thing I do want to, if there's one thing I want people to take away from today's conversation, and I hope we're going to continue because there's so much to explore in the O1, and there's always, I also want to be a resource for people who, let's be honest. I'm a very straightforward lawyer. I'm going to tell if I think your case is not going to work, I'm going to tell you. I'm not going to, I'm not going to be here and tell you, yes, I'm going to make it happen. I'm not going to, um, I don't like to waste people's time, and I don't like when people waste my time. So I'm going to be pretty straight, but I
No
also
beating
want
around the
people,
bush, right onto the face, whether you did that.
exactly, because I want people to know that I'm a resource, especially as we're about to embark on on a very potentially rocky 4 years. Okay.
Mhm.
Um, I want people to take away that the O1 category is probably the least category to be scrutinized, because just because of the nature of it. And I want people to know that, business immigration, although it may have some pushback, is not, I don't think it's in the interest of those who are in power or who will be in power to mess with business immigration, because they ran on a business platform. And again, you have Elon Musk there that, like it or not, money moves the world, right? So he's going to have a lot of influence. And I mean, if he goes after business, which I highly doubt, um, he's going to be shooting himself in the foot. And I mean, what I do want people to drill this into their, memory is do your homework,
Mhm.
consider hiring a lawyer. Don't go at this alone, especially after January 20th. Um, Keep in mind that we have to convince USCIS. This is not
Mhm.
like any other. This is not like most other, like a lot of other business visas where you go to the consulate and they can deny you because they don't think your case is true. If you convince USCIS, you're 90% there, unless there is some other huge issue. Once we convince USCIS, the hardest part is done. So I want people to know that every case is an opportunity to tell a story, and rely on a competent lawyer, hopefully me,
Mhm.
to tell that story. And, just don't be bogged down by whatever you may hear out there.
Mm.
9 out of 10 is probably exaggerated and or written by someone who doesn't know anything about immigration. So keep that in mind.
Mhm. That's a great advice. Thank you so much for that, Ralph. Now, again, there are two more questions actually posted by Lynn, so I would like to take them too. So he says there are many companies that are being pressured to invest and open R&D factories in the US. Question is whether the workers hired are going to be on business visa from abroad, and or foreign students switching from student visas to working visas. um, then the second part of the question is also how many this will be affected, and then the second part of this question says also regarding for foreign investors looking to open franchise businesses in the US, and then also immigrate to manage the business in the US, what should they be looking for? Let's take one by one, maybe this one first.
Okay. Yeah. So I think since this is an O1 conversation, companies, the current administration has put a lot of input in STEM fields. This is what I mentioned earlier, that President Trump, or soon to be again President Trump, said that he's going to give a green card to everyone who's got a STEM degree. He's going to give a green card to anyone who basically staple a green card to their diploma. I don't know if that's going to happen, but most people who just graduated from U.S. University, and I'm not sure if this goes into the second question, but I believe most, again, realistically speaking, most people who just finished their degree, they're probably not going to qualify for an O1. They're likely going to be more, they're probably going to be the criteria of an H1B or, probably H1B is going to be the best way to go. Then from an investor standpoint, and again, this is probably a topic for another conversation, but when investors want to put some money in the United States, and again, this is I hardly believe that the next administration is going to try to prevent investment from happening in the United States, mainly because they're going to have Elon Musk in there. The E2 category is probably the best category for investors. This is also a heavily scrutinized category because it requires a lot of documents, a lot of granularity in offering, trying to get an approval from E2. An E2, the main characteristic of an E2 is to make sure that there is a treaty between the United States and that person's country of birth or country of nationality, so that that there can be some sort of an investment in the United States based on that treaty. Again, this is something for a topic for a different day, but I don't think the O1 category is going to be a favorite one for students. Those students who are in OPT or STEM OPT, they're likely going to go into the H1B lottery. So again, yet another topic for another time. What was the second question? If you remind me, reminding me of the second question.
Right. He said that also regarding foreign investors looking to open franchise businesses in the US and then also immigrate to manage the business in the US, what should they be looking for?
Yes. So this is, again, this goes back to what I just said at the end of my last answer. For this type of scenario, an E2 is probably going to be the best way to go. Okay. In the case of a franchise, you're not really starting a new business. Well, because what you're doing is you're basically growing a brand that already exists, right? So you're buying the franchise. So all you're going to have to show is that you put some, when it comes to investment, you have to show that you put some money at risk, that you invested. Again, this is a E2 conversation. This has nothing to do with O1, but for a franchisee, I think the E2 category is probably the best way to go. Again, this is, like I said, we didn't even start talking about a lot of details in the O1. So if I start talking about another category, it's just going to confuse people. So, for franchisees, I would think the E2 category is the I don't want to say easiest, but it's the best way to go about, trying to invest. And the E2 category allows the main investors to hire people of their own nationality to work with them. So that's a big advantage of the E2. But again, this is an O1 conversation, so I don't want to spend too much time on the E2. I hope that answers the question.
Right, it does. And I hope so that, Lynn, you have got your answer. Thank you so much. If you have another follow-up, please continue posting them in the comments. Even if we don't have time to take them up in this session, we are going to do another session with Ralph very soon. So maybe we can take them in another episode, or maybe we can directly reach out to Ralph and ask for an answer, or maybe you can directly reach out to Ralph. If you want a direct consultation or are looking for an answer. And here are his details. You can give him a call on this number, which is 240-898-2288. I would like to repeat it, 240-898-2288. You can also email him. His email ID is ralph@antoniolilawfirm.com. And also, you can also visit his website, which is www.antoniolilawfirm.com. Thank you so much for that. And Ralph, I would like to take one more question. This question is actually posted by Madhvi in the comment section on YouTube. And she says, I am a researcher with a few published papers, but I haven't still received a lot of media attention or publication or public recognition. Am I eligible for O1 visa?
Well, yeah, that's a great question. And I think it goes back to what I said earlier. You have, if you're a researcher and you've published, if we can show that's just one criterion. We have to show at least three. So if you don't, if you haven't, if you haven't received a lot of press attention, then we're going to have to look at the other criteria. So for example, you can get letters of recommendations from people saying that you have provided significant contributions to the field. That's how you meet that criteria. You can show, again, you have eight criteria to choose from, and we can explore each one. For example, membership in association. Maybe you're a member of like a sorority or a fraternity or some type of organization that requires you to be somewhat an accomplished professional. That may qualify. Again, do your homework, and maybe once you appeared as a judge in a competition. It doesn't have to be a judge for something that was televised. It can be anything. And then like I said earlier, there are many ways to approach this. So just because you only have one thing doesn't mean you're not going to meet it. We have 8 other options, or 7 other options, if you will,
right,
to look at that we can meet. So this is the great thing about the O1. It lends itself to creativity. So, and like I said earlier, I said, our job and my job as a lawyer is to tell the USCIS officer to look at the case, and in 10 minutes of looking at what we presented, the guy can say, I'm going to approve this. So at the end of the day, it's case by case basis. I encourage people to reach out to me, and I'm more than happy to speak with them about whether they think they could meet. If again, I encourage people to either reach out to me or I think that's probably the best way to go. If we're going to be talking about everyone's individual case, we're going to be here for 2 weeks, right? So I think it's just because you have one thing, don't get bogged down on that. There are other options. There are 7 other criteria, and each one is at play. Anything goes. Yeah. So I think, and if you're, if you're a researcher, there's also other options. There is something called a J1 researcher that you can apply for. The company, I'm gonna just do this briefly because again, this is a J1 visa, but it's a J1 visa that is not usually utilized, but it's for a researcher. People believe that the company has to be a research company, and that's not true. It can be any company as long as they create a research type job. So yeah, that's another wrinkle to this. So Yeah, I mean, and ultimately, if you, yeah, I mean, I think it's, yeah, I mean, the bottom line is it's a case by case situation. You don't want to, you don't want to, I mean, don't convince yourself that you don't have it before you talk to a lawyer. So,
That's
so
true. Don't come to a conclusion until you seek.
exactly. Yeah. And I think what they say here, don't sell yourself short. I mean, I'm sure if you look, um, I mean, this is going to sound maybe a little weird, but, it's like a beauty contest. You know,
Uh-huh.
you have to convince the judges, right?
Right.
So, I mean, look at it that way. I mean, I mean, it's, yeah, that's kind of maybe an odd concept, but that's what it is. And my
You
job
never know
is
what
to,
might work for you, right?
I'm sorry?
You might not know. You never know what might work for you.
No, and at the same time, exactly. And at the same time, this is such a subjective
Right.
process that you may get you may get a guy who's got like a cousin who does what you do. You never know.
Mm-hmm.
And hey, this guy, we're human after all. I mean,
Yeah,
you know.
absolutely. So it'll be better, Madhvi, if you directly get in touch with the right attorney, and why not directly get in touch with Ralph if you're looking for an attorney. And then Ralph, also I would like to take one more question. This is actually from Kavita, and Kavita says, I have heard a lot about O1 visa being for people with extraordinary ability, but I'm not sure what that really means. Could you explain in more detail how USCIS defines extraordinary ability? I think we already have talked about this, and you already have explained.
Yeah,
Um,
I'm happy to give a quick overview again so they understand.
Please. Uh-huh.
Um, yeah, so like I said, well, USCIS doesn't really define extraordinary ability, the regulations do. All we have to do is show to USCIS that you actually meet the definition. So, for example, if you are in the field of arts, you have to show that your extraordinary ability means distinction. What does that mean? Distinction means a high level of achievement in the field evidenced by a degree of skill and recognition substantially above what's ordinarily encountered in the field. What does that mean again? It means that you have to narrow your endeavor so much that when you explain it to them, I am an IT expert who specializes in A, B, and C. And there
Mhm.
are only like 3 people in the world who do A, B, and 3. And I'm one of them. You know what I mean?
Mhm.
That's how you do it. If you say I'm a expert in IT, how
Right.
many people are experts in IT? Millions, right?
Right.
So, but the secret, I mean, not a secret, but it's you have to narrow down what you do. So, for
Mhm.
example, in the case of like my photographer, for example, that I work with, he was he was a photographer for Apple, and he would take pictures, all those pictures that would go on billboards.
Mhm.
So we narrowed down. He's like, okay, I have an expertise in photography. If you just stop there, you're going to have millions of people who are photographers, right?
Mhm.
But if you say specializing in taking, in products that have to do with cell phone technology, or that narrows down the field. So at the end of the day is what I tell people is tell me what your superpower is, and then we're going to expand on that. So don't tell me I'm good at IT because there's 10 million people who are good at IT too. We have to start with, okay, we start with IT, and then we start going down the list and see okay, what type of IT do you do that not everybody else does? So that I think that's the right approach. If you're looking at sciences, the regulation says, and I think I touched upon this earlier, and this applies specifically to people in the sciences, education, business, and athletics, where IT will fall in. And this is you have to show a level of expertise that you are on a small percentage that have risen to the top of that field. So again, that basically encapsulates what I just said about, you know, narrowing down as much as you can what you do. Don't tell me I'm great at in IT because that's a loser argument. Tell me I'm great in IT at doing ABC because there's only like 5 people who do that, and I'm one of them. You know what I mean? That's the position you want to be in. So
Right.
that's what they look at. And when USCIS uses a very broad definition of the word endeavor, which is basically what you do. Okay. So like your field, you can basically, if you can articulate something that makes a little bit of sense, that's it. You go with that. It doesn't have to be something that is widely recognized. No, you do you. You know what I mean? So, and you tell me what you do, and then we're going to craft your field based on that. Of course, we're going to start with a science, and then we expand on. So that's basically what they look at when they try to see if a person meets extraordinary ability definition. That's what it is.
Right. Thank you so much again for your answer, for that detailed answer, I should say. Ralph and Kavita, thank you so much for posting your question in the comments below. I hope you have got the answer. In case you're looking for anything else, and if you're looking to get an answer to maybe another follow-up of yours, please continue posting them in the comment section, and we'll be more than happy to take them. And yeah, I think that's it. We still have one more question from Arjun. If that's okay for you, Ralph, I would like to take this as
Yes,
well.
absolutely. I was looking, if you don't mind.
Uh-huh.
This person kind of caught my attention. I think it's Bhavin in the chat.
Okay, let's take Bhavin's question. Right.
I
How
can
long?
tackle that pretty quickly because it's it says how long I can stay in the United States on an O1 visa, and can my family members accompany on an O1 visa? The second part I already addressed, but I'm happy to do it again. One of the great pros of the O1 visa is that there is no time limit, meaning the first period of employment is usually 3 years. So your first I guess period, you can stay in the United States for 3 years on your initial entry. Then you can extend that in 1 year increments indefinitely. This is definitely an advantage when comparing to an H1B, for example, where the H1B you are limited to 6 years. And the O1, you can extend your O1 status indefinitely. Of course, you have to show, every time you extend this, you have to show that you continue to be a person of extraordinary abilities. But but there is no limit as to how long you can stay in the United States, as long as you continue to demonstrate that you meet the criteria for an O1 petition. And when it comes to family members, like I said earlier, yes, they also benefit from the same period of stay as the principal O1. The visa for family members is the O3. Like I said earlier, they are allowed to go to schools, university in this category. Unfortunately, these categories is not allowed for employment though. But if we're going to go really granular about this, if you pursue some kind of degree in the United States, you can potentially qualify for other categories like an H1B or So, I mean, again, this is a very large topic, and I think I just wanted to address that because I wanted your audience to see how how advantageous will be to pursue an O1 as opposed to an H1. Because, for example, and another big difference will be you can do an O1 at any time, whereas the H1B you are subject to the lottery, right? So, yeah.
Right.
Yeah.
Okay, Bhavin, I hope you have got the answer. Thank you so much for your question. And I think, okay, that's it then. Thank you so much, Ralph, for those amazing answers, for those insightful, detailed answer. It was lovely having you on the show. And, I don't think so. We had so many questions actually prepared for this show. But then I was only able to take, I think, one or two. And then mostly all of them were from the viewers. So I most definitely think we need to have an episode 2 of the same topic so that we can get into more questions and we can cover more details about O1 visa. And like I said, I think it is a very vast topic and we will need to have more and more episodes to talk about this, right? So that people can know better and know in detail what exactly O1 visa stands for and how it actually helps, especially the extraordinary people, right? So thank you so much for being here. And guys, if you want to get in touch with Ralph, I would again like to repeat the details which are displayed on screen. You can give him a call on his number, which is 240-898-2288. His email is ralph@antoniolilawfirm.com. And then his website, you can also visit his website, which is www.antoniolilawfirm.com. Thank you so much, Ralph, again for being here. I hope you enjoyed the first episode with us.
Yes, absolutely. And I'm really looking forward to doing another one. Especially, we were going to talk about, and I want your audience to stay tuned. We're going to talk about IPOs and things of that nature that may be of interest to people, and how to avoid, rejections, and how to put together a very strong O1 petition. So, looking forward to
Right. I
help.
think this was just the tip of the iceberg, right?
Yes.
So we have a lot to cover. So we definitely will be doing the shows with you on a regular basis now that, you have been here for the first episode. So thank you so much. Thank you so much, Ralph.
Thank you. I really appreciate it, and I appreciate the time.
Yes, I'm definitely going to come back to you and check your availability for the second episode. And thank you so much for being here for the first one. And guys, please make sure that whatever questions that you have regarding O1 visa, to drop them in the comments below so that when Ralph will be back for his second episode, we are going to take these questions and we are going to get an answer from him. But for now, we'll have to take your leave. Thank you so much. Stay tuned with us. Our daily immigration dose is going to is going to come at 4 p.m. Eastern time. So make sure that you also are live and you're also tuning in while the program goes on. But for now, thank you so much for participating in this webinar and also for posting your comments. For now, I will have to take your leave, and I think so will Ralph. So we'll see you very soon. Thank you so much. You guys take care. And
Thank you.
Right, and don't forget to subscribe to Immigration and Jobs Talk Show. I'm Rajni Bharara. You take care and have a happy day ahead.